Oh,
Emailing Michael now.
Okay, thank you.
So you factor in like it's not just what you brought to the door.
Exactly. Right. It's not like a leadership in the firm.
That's what counts. It's good. When do you have to decide?
So last night we were in the office till like 7 a.m.
So you could do you get to bill?
We'll do a little. So I went from that into like this.
So you worked all day Sunday, all day Monday, all day Tuesday, and Wednesday too? All in compensation. You go partner by partner. So like Jenny, every single how many are there on today? What about the ones that are like packing? I made a small
Twice. So
drinks and then maybe get together. But I was a little surprised. Yeah, I guess.
There's a lot of I wouldn't have said this. 10 or 15 years ago. I'm motivated, so it's a little bit
But we
different.
put up this stuff on 30s.
Admissions Discipline Training Day. And I hope that we institutionalize this practice going forward. We will be having another one of these trainings focused on the third prong of our mission, access to justice, a little bit later this year. So today, the board, you will have an opportunity to get a really kind of basic education on the core functions of two of our most critical areas, our admissions and our discipline systems. If you think about your time on the board, you know that many issues related to these areas have come at you. Just thinking over the course of the last year, you've dealt with the cut score on the California bar exam, the job analysis, the transition to the two-day bar exam. On Saturday, you will be asked to approve the procurement of a new case management system for admissions. Also in the last year, you've approved a new case management system for our discipline system. We've hired a new chief trial counsel. You've heard about case prioritization. We've talked about the client security fund and the funding needs in that fund. And as you know, we have a report due on that topic in March. So you've touched on these areas, obviously, at each and every one of your meetings, but what you haven't had the opportunity to do is step back and really learn about the full scope of these systems, how they work, what they do, and who's behind making them work. So today you're going to have that opportunity. I'm going to turn it over, Donna, to you briefly to see if you have any remarks. I want to thank you for pulling this all together. It's been a tremendous effort on Donna's part and many staff, so I want to express my appreciation as well. Turn it over to Donna.
Thanks, Leah. I have really very little to add. What I think we might as well do is go on ahead then and get started with Amy Nunez from our Office of Admissions. Amy, the clicker is in front of you. Okay. Use the button on the left to advance the slides forward.
Good morning.
Good morning.
I'm Amy Nunez. I'm the Interim Director for the Office of Admissions. And today, my team and I will be describing the various functions carried out by our office. As we start, I want to point out two items related to this presentation. The first is you will hear the various ways in which our team carries out the function, the mission of public protection in our various efforts throughout in each of these units. So I really want everybody to hear that in each of the descriptions as we're going through. And the other thing that might not be conveyed is the volume of work that we process in the office. To highlight that, I have prepared a copy of our key indicators. This is a report that we prepare for the CBE that highlights all of the efforts carried out by the office. Let me hand these out right now. There are two handouts to this. One for the accreditation presentation that you will hear. Oh, thank you. Thank you. So just as a highlight of how our office functions, some of the work that we carry out crosses multiple units. For example, in the statistics here, if you can see, the number of people placed on the motion in 2017 were a total of about almost 5,900. 5,873 people were placed on the motion, while in 2016, 5,414 were. One thing about that statistic is that that population has touched various parts of admissions. That is, they've gone through accreditation, they've touched the bar examination and development, they've gone through moral character, administration. So this is a population that has gone through almost every part of our office. So the other item that I want to highlight is, I've highlighted statistics and also, again, the emphasis on public protection. So with that, let me talk about the CBE. Am I pointing at the?
No, move it anywhere.
Okay. Let's have the right side up. All right, thank you. So these are the entities overseeing the work of the Office of Admissions. And just to illustrate how these entities engage, I want to highlight the path that the bar exam studies took in 2017. And I'm going to just talk about the standard setting report as an example. The report was received by the CBE from the researcher, and upon review and discussion, and this is also after discussion with both the RAC and Law School Council, this is a Rules Advisory Committee, both of which are advisory committees to the CBE. The CBE formulated a recommendation that was brought to the Board of Trustees. The Board of Trustees then formulated a recommendation that went to the courts. And the Supreme Court, made the final decision as to whether or not to change the PET score. So this is just a way of illustrating the method in which these entities interact and engage. The other item is information on the composition of the committee. There are 19 members, and effective this year, Rule of Court 9.4 states that of the 10 members elected by the Supreme Court, at least one of the examiners has to be a California judicial officer. So we will soon have a judicial officer in our committee. The 6 subcommittees meet along with the CBE about 6 to 8 times a year. All right. And now we're going to hear from our group on exam development and grading. Thank you.
Good morning, everyone. My name is Lisa Cummins, and I am the program manager for examinations. My main job is to oversee examination development, as well as testing accommodations. And Christina, I work alongside with Christina. She's primarily responsible for the grading of the examinations that we give. So the committee is responsible for administering 2 main types of examinations. And one is the first year law students examination, which I'll go into a little bit in my presentation, as well as the California bar exam. So okay, so The California bar exam, up until the July 2017 administration, which was just our immediate last administration, was a 3-day bar exam. And 3 days being on the first day, you had your 3 essay questions in the morning session, and then a 3-hour performance test in the afternoon. Second day was the MBE, which is the multi-state bar examination. And then on the third day was sort of a repeat of the format of the first day, which was 3 essay questions, 3 one-hour essay questions in the morning and a 1-hour performance test in the afternoon. So beginning with the July 2017 administration, we have now been administering a 2-day bar exam. So the difference there is, as illustrated on the slide, is that on the first day, we have 5 1-hour essay questions, and they are divided up 3 in the morning and 2 in the afternoon. So with the afternoon session, which is now no longer 3 hours, it is now 3.5 hours, because we have, in addition to the 2 1-hour essays, we have a 90-minute performance test. So on the second day, the second day really hasn't changed. As in the old exam, on the second day, we had the multi-state bar examination, and that is a 200 multiple choice item exam. 100 questions are administered in the morning, 100 questions in the afternoon. So the multi-state exam is not developed by in-house by the state bar. It is developed, owned, and graded by the National Conference of Bar Examiners. But we do develop the rest of the exam, the written portion, in-house. Oops, sorry. So there are 13 subjects on the bar examination, and they're listed for you up there on the screen. Throughout this, I will also highlight the differences between the first year examination and the bar exam. So the first year examination, first year law students examination is, some of you may know it as the baby bar. It is primarily given to, or required for students who attend unaccredited law schools must take the baby bar in order to advance to their second year. And so there are only 3 subjects tested on the baby bar, and that those are criminal law, contracts, and torts. The baby bar is not a licensing exam, unlike the California bar exam. So it is dealt with a little bit differently. So the bar examination is developed. You can see the slide there. So the essay questions and the performance tests are developed a little bit differently. The essay questions we solicit from law professors and other qualified authors from basically the entire United States. So we have some authors that we use frequently, and then we also solicit new ones. So so those are again authors who are usually professors, and they solicited, and then they provide the questions to us. The performance test is drafted with a performance test drafting team, and that team is basically a lot of clinicians in the sense that they're professors who run clinics in various law schools. And so we meet a couple of times a year to edit those performance tests. So that's how it's different from the essay questions in terms of development. Question and performance test editing. So again, as I mentioned, the performance test is edited by the performance test editing drafting team, who meets twice a year. The questions are edited by, we have a group of contractors called the EDGE team, which stands for Examination, Development, and Grading. The EDGE team, in addition to helping with development, they help with the grading of the bar exam, and Christina will discuss that. So our EDGE team is in a constant state of editing questions. They have their banks that they have. Each EDGE team member is assigned 2 of the subject banks, and they edit prior to exams, and they edit throughout the year in terms of making sure their questions are in order. And then we have pre-testing. So the other thing that's different with the baby bar is that we do not pre-test examination questions. So the pre-testing involves, and we did it differently with regard to the essay questions and the performance test, but it involves sending out for the essays to selected graders. Again, we use our senior graders for some of this pre-testing, and they're given the questions and they're told to write an answer and then evaluate the questions in terms of whether there are any potential biases or any ambiguities and issues with the questions, and then they come back to us, and the EDGE team finds that those pre-tests are very valuable in terms of their editing of the questions. The performance test is pre-tested in a slightly different way. We have those graders come to our office in San Francisco, and they actually do the performance test under testing-like conditions. So it would be a 90-minute, so they're in the office and they do the test, and then afterwards there's a debrief session. And so then at the debrief session, we also hear about, whether it is too long, too short, how did the item perform. And then after that, these questions and these performance tests are banked, and we have many questions and performance tests in our banks. And then at the time that it comes to for administration of each exam, questions are chosen and performance tests are chosen out of those banks to be administered for any particular exam. I also want to mention that for the first year exam, there are 4 essay questions and a 100-item multiple choice test, which has been developed in-house. And that exam, instead of 2 days, is administered over 1 day.
Good morning, everyone. As Lisa mentioned, my name is Christina Dole, and I work with Lisa in the Department of Examinations, and specifically with the grading of the bar examinations and the first year examinations. First thing is that we want to make sure that our answers are anonymous, that the graders do not know whose book they're actually grading. At the test centers, the examinees will actually fill out the 6 essay and performance tests, the 6 book covers with their name and applicant number. Once those books come back to the San Francisco office, we have a computer program that randomly generates some code numbers for each of those examinees, and those code numbers are what replace the applicant number. From there on, the graders don't know whose book they're looking at, and it's all an anonymous process. The logistics for the books back into the San Francisco office, staff there are responsible for the printing of all the laptop answers, the coordination and assembly of all the books, and then of course up to the release of the results. It takes about 4 weeks, 3 to 4 weeks to process all of the examination answers. The first week, we're looking at all the MPE Scantrons. We're making sure that the name matches the applicant number. You wouldn't believe that how many applicant numbers actually are either filled in wrong or they write in their social security number instead of their applicant number. So there's a lot of fixing of the MPE Scantrons to make sure that information is accurate. Weeks 2 and 3, we're looking at the actual handwritten and printed essay answers, and we're doing a keyword check. We want to make sure that the answer that we're looking at belongs in the correct number. Again, examinees will put 2 answers into 1 answer file. We want to make sure we catch that. We also want to make sure that when we printed the laptop answers, that they didn't happen with a printer where we skipped maybe page 7 out of page 8. So we're verifying that we have all the answers correctly printed and in the correct answer book. From there, weeks 4, we endearingly call walking the line, where we take the complete set of 6 answer books from each applicant and we separate those by question number. So when you're a grader, you're grading all whatever question number you're assigned to. So you're grading all of question number 1 or all of question number 2. And then of course, the very last part of the logistics is actually boxing all the materials for the graders. Graders, we have a qualified pool of approximately 150 graders that we will select depending on the exam cycle if they're available. These graders are all from the Greater Bay Area, and they come from a wide variety of practices. They have a wide range of experience, and they are all practicing lawyers who pass the bar within their first or second attempt. In addition to our graders that grade the exams, we also have a six-person team of what we call EDGE team members. Those EDGE team members are comprised of people that have been former graders that will actually supervise each of the grading teams. The first task for each of our graders is to do some pre-grading research and question analysis. So we will assign each of our graders to one of the 6 questions, and they are to write a fully researched answer to the question. They need to conduct the necessary research and then, of course, provide documentation and citations for that answer. Each question has 12 graders on their grading panel. After you conduct the necessary research, all 12 graders swap their answers with each other. So you now have 13 well-written answers from your colleagues regarding the one bar exam question, which then brings us to our first calibration meeting. At the first calibration meeting, the supervising EDGE team members review all of the 13 different answers to the questions. They help have a discussion, and ultimately, as a team, they come to a consensus of what exactly the bar answer should be and what tentative weights should be assigned to each one of the points. Essentially, our goal is to make sure that no matter whether grader A, B, or C is looking at that book, that book is receiving the same grade from whoever is grading the book. At the second calibration meeting, the graders will receive 10 books from actual examinees. Together they read the answers as a group. They have a discussion on what points this answer should receive, and they come to a consensus of what grade this book should receive. Once it seems like the group is well calibrated, at that second calibration meeting, we pass out the books, and the graders are officially allowed to start the grading process. The third calibration is held midway between the grading cycle, and this is just a meeting to assure that the graders are continuing to adhere to the established grade guidelines. We have a 3-phased grading system, phase 1, phase 2, and phase 3. You might hear me also call it a first read, second read, and a third read, or a resolution read. All answers are read at least once before a pass-fail decision is made. If you receive if you receive below 1390 after the first read, you fail the exam. If you receive a 1440 or above, you pass the exam. Anyone in between that range of numbers goes on to our phase 2 second read. The second read, the books are distributed to a different set of graders. At phase 2, once the grades are given, the grades are averaged between the first grade and the second grade. That average grade holds the same standards. If you have 1390 or below, that's a fail. 1440 or above is a pass. And if there's any grade discrepancies of larger than 10 points, then those books go into a third read or a third phase, our resolution phase. Our resolution phase, the books are actually given to the supervising EDGE team member. The EDGE team member reads those books and they assign a new grade that replaces the first and the second read grades. From there, same happens. 1390 or below is a fail, 1440 or above is a pass. Absolutely.
So I understand that for applicants who fail the exam, their scores are revealed to them.
Yes,
Right.
failures, yes.
So you just described multiple scores. Which score do they get? Only the final one by which they were judged? They don't get these sort of, if the first two are discarded, for example, is that disclosed?
They actually get all their grades, so they will see what the first read phase 1 grades were, they'll see what the phase 2 grades were, and they'll actually see their resolution grade if there was a point discrepancy. A lot of the people that do submit requests for reconsideration point out the fact that I don't like the grades that I got for the first read. I want to go with my second read grades. Can we just look at those second read grades? That's not how our grading process works. But yeah, they get all the grades and all the different reviews.
I've got a question. Is there been thought to shortening now that we're a 2-day, the time process between the exam and the results?
You asked that question and led me into my next slide. Thank you.
Before you go to that, I just wanted to raise, it's my understanding that in many other jurisdictions, the scores are also provided to those who pass the bar exam. I know there have been concerns about doing that in California, but I just wanted to raise that there are variances throughout the country with respect to that practice. And it is something at some point that the board may want to have further discussion on.
Do you know offhand how many states do release the pass? I'm just curious.
Yeah, I don't know, I could get that, but I don't know exactly. I also want to point out, following on Rita's, is that some states even publish the name of their top bar exam score, and they have a whole ceremony for that person.
Let's make lawyers more competitive. Let's do that.
No, that one doesn't get revealed. But I also want to add to Christina's is that we're talking about a 1440 score out of 2,000 maximum points. And also that we grade in 5-point increments. So when you hear 10 or more points, you think, oh, that's a huge amount, but actually it's really not that much if you're talking about grading in 5-point increments. So, okay.
So, as task, why, what's the process? Why does it take so long? I took the exam in July. Why am I getting my results in November? Good question. Number one, it's a large number of applicants. For our February exam this year, we had approximately 500 applicants. For July, we had 5,000, I'm sorry, what did I say, 500? Yeah, no, that's way too less. 5,000 applicants. In July, we had 9,000 applicants, and as I understand, for February 2018, we're actually over our numbers from last year, so we already have more than 5,000 registered for this.
How
Yes.
many graders do you have, and how many tests does each grader grade?
Great questions. Can I just put a pin in that? Because I am going to answer that. 12 graders is what we have on each grading panel, and we have 6 grading panels. Yeah, in addition, Lisa just mentioned, in addition to our 12 actual graders, we do have 4 backup graders that go along with the process as well. That way, if one of our graders gets sick, gets a trial, has to go out of the country, we have someone that's followed along with the process, has been through the calibration meetings, knows what the grading guidelines are, and can ultimately step in and start grading from there as well.
And among those are apprentice graders who have never graded before, who are completely new to the process, and that's some of the ways that we bring in actually new blood into the system.
So going back to my numbers, 5,000 examinees for February, 9,000 examinees for July. Well, now times that by 6, because each applicant has 6 books. So you can see how many books we're actually dealing with inside of the San Francisco grading office. Getting the books ready for the grading process, we have about approximately 700 boxes that we pack and ultimately will be distributed to our graders. That's about 800 examination answers per grader. And if you keep on drilling down those numbers, so you're looking at asking the graders to read approximately 20 answers per day for 8 to 10 weeks. That's about 3 hours per day that we're asking these graders to read. 20 to 25 answers, and that's about 140 answers to 175 answers per week that we're asking them to read. And again, that's through 3 different cycles, so that's for 8 to 10 weeks that they're reading through phase 1, first read, second read, and then all the way through the resolution. The February examination, from start to finish, from when we receive the books in the office to when we release the results, it takes about 11 weeks. And again, 4 of those weeks is just the processing of the exam, the printing of the answers, and the assembly of the books. For the July, because we have almost twice the number of applicants, it's about a 16-week process. Phase 1, for reading the books all the first time, takes about 4 or 5 weeks. From there, people will pass, people will fail, and people will be within the range to have a second read. So the second read itself takes about 2 to 3 weeks to get all those books read. And then, of course, there's the third read, the resolution, and that's about a week for those books to be read. So was I able to answer your question with all of that?
Well, and please don't take this as any criticism of the length of time, because but now that it's really one day that we have to deal with, could that be looked at in the future to shorten what we are doing?
Absolutely.
Because we're only really doing one day now.
Absolutely. Ever since we moved to the 2-day exam, we've had it on our minds that we would like to compress that schedule. For the July 2017 exam, we actually did try to compress the schedule. It didn't work out for us. We got a lot of pushback from the graders, only because the graders are used to working on a cycle that 4 days about for 100 books. So in February, again, we're going to try to compress that schedule a little bit and see if we can. Our first goal, or at least I should speak for myself, my first goal was seeing if we could bump that up maybe a week. See how that goes, and then, yeah, that worked. Okay, maybe let's try 10 days and getting them out early. But yeah, absolutely, it's on our mind, and we will have it built into the process that we do want to. Yeah, absolutely. That we do want to make the grading cycle a little bit quicker.
Should I follow up with a question? Going back to the baby barn, assuming a similar process is followed, the board recently proposed a new rule that would, unaccredited schools would have to become accredited. Would that mean we won't need a baby barn anymore?
No, I don't think so, because there still would be a process by which the unaccredited law schools become accredited. So I would assume that, and George might be able to speak to this more, but I would assume that for some period of time, that schools, when they're first coming on board, will still be not provisionally accredited, or I guess if you're provisionally accredited, you probably still have to take the bar. But there'll still be some period of time when an unaccredited school has not become fully accredited, so that they would need to take the baby bar.
So there's always going to be a school out there you anticipate that is working towards accreditation, where they just open up and they have to get there, so we're always going to have the baby bar.
That's my understanding.
If I may, just briefly, the current guidelines for accredited schools require a provisionally accredited school to require their students to take the first year exam. And that stays in place until the school usually takes a couple of years. The newest CALs went through this process about 6-7 years ago. And the students are required until the school receives full accreditation from the committee. So the pending proposal is to have in the future just 2 types of schools, CAL accredited, fully accredited, and any new school would come on as a provisionally accredited. So the current guideline would just stay in effect, and those schools would still require students to take first year. So the long-term plan would be to keep the first year exam in place for as long as we have CAL accredited schools.
How much does it cost a first-year law student to take that exam?
It's $624 for the first year.
Thank you.
I just want to also add one item to your question about a factor that may contribute to the length of time for grading the exam. Another method for cutting down some of that time is a paperless process, which we're anticipating that a new case management will help us do. So I think a lot of the work that Christina's described may be reduced by a new case management system, which will help automate a lot of this process.
Thank you.
Are there any other questions regarding to the grading? Oh, in case any of you would like to know about the first year exam and how it compares grading wise to the baby bar, the first year of the baby bar, there has approximately 400 applicants for each exam. 400 applicants transfers into approximately 2 boxes per grader, as compared to about 9 boxes per grader during the July exam. Instead of having close to 100 graders, we actually only have 12 graders that grade the first year. And instead of having the 6-member team of EDGE team supervising members, we have 1 EDGE team member that supervises all 12 graders. That process takes about 7 weeks from start to finish. Again, from receiving the applicant's answers, assembling all of the books, getting the books out to the graders, having the graders read the books for a first time, compiling their scores and either saying the score is high enough to pass or the score is not high enough to pass. Instead of having a second read and a resolution for the first year, we have a reappraisal step. So any body in between the scores that did not necessarily fail and did not necessarily pass, those are reappraised by the supervising EDGE team member, and rather than just reading one specific book, they read the applicants, all 4 of the applicants' books, and holistically look to see whether the applicant is qualified to go on to a second year of law school or unfortunately failed the bar exam. And are there any other questions before I turn it back over to Lisa to speak about testing accommodations?
I hate to get too far afield on this, but I'm wondering a few things. How are the graders selected or qualified? And then I'm wondering if there's any relationship between the number of graders, that is to say the number of tests that we're looking at, and the relative pass rates of the people that are taking the exam. It seems like a lot of tests to me to be graded by those individuals. And then is there grading of those, at least the written portion of it, is it subjective or is it objective?
So to your first point, there are 12 graders, which we find 12 graders to be the optimal number to keep all the graders calibrated and looking at the same guidelines and point structure. Sorry, I forgot your first point. Oh, how they're selected. So anybody that is a practicing attorney can go ahead and submit an application into the bar exam or to the state bar. And from there, they have to live within the greater Bay Area because that's where we do our grading is in the San Francisco area. And the committee selects graders depending on the diversity, the subject matters, the practices, how long they've been in a practice. We want people that are new to the field and people that have been in the field for quite some time. And then ultimately, the supervising EDGE team at the end of an examination cycle is going to evaluate the graders that are on their team, whether they did their appropriate research for their question, whether they were able to stay calibrated with the team and make sure that they were guiding within the specifications. And another factor is how many books went into resolution. How many point discrepancies of greater than 10 points were in there. So based on that feedback, some graders do well, and those are the graders that we want to keep in our pool. Some of the graders don't do the appropriate research, don't attend the appropriate meetings, and those are the graders that we don't invite back.
I also want to add that some of these graders have been grading for quite a long time. They've been grading for 20 years, some of them, more than 20 years. And we do try to, in our grading teams, have a range of people who have been grading for a long time, people who are brand new, people who are in the middle. And yeah, as Christina mentioned, is with regard to the number of 12 per grading group. I believe, if I've got my history correct, that number was kind of determined by, or run past our psychometrician, and he said, or his opinion was that that's about the maximum number of people you can have in a group in order to keep them calibrated on the same page. You get more, bigger group, it's really much harder to keep them calibrated and all on the same page, which is very important for our grading process to make sure that the applicants are not in any way prejudiced by the fact that maybe one grader may be off, and because we do want to make sure that anybody, as close as possible, anybody in the group in terms of grading is going to be grading very close together in agreement with the books. That answer your question?
I think so. They're not easy questions to answer. And I have some other thoughts in my mind about other things that we've been talking about and seeing how, and we may get into this at some later point, if there are any areas where implicit or cognitive bias can come into the sort of the grading process. So those are some of my thoughts. And then, you heard about the phrase about buying a Friday afternoon car. I'm just wondering if a person who, when somebody is grading all of those tests, and now they're at the tail end, that they may not grade in the same manner at the end as they do at the beginning. So is that fair to the applicant? How would that affect, cut scores and things like that? So those are my thoughts.
We try as much as possible during the process. There are checks and balances that we have in terms of making sure the graders are pretty much calibrated, and those are internal checks that we have. If grader looks like they're grading too low, we have them, have the education try to bring them back within the fold. So there are many ways that we try to make sure that people are still calibrated. But good questions. Okay, so I'm going to go on to testing accommodations. So applicants who have disabilities under the Americans with Disabilities Act can file a petition with the State Bar requesting accommodations for the exam. And in the next slide, I will go into some of the types of accommodations that are requested, the more common ones. But anyways, it begins with a petition from the applicant, and that petition has to be appropriately documented. So we have certain forms that the applicants have to fill out depending on the applicant specialists have to complete depending on what their disability is. So those are the disability verifications. So then along that process, if there are disabilities, for example, learning disabilities, ADHD, psychiatric disabilities, physical disabilities, we send those to outside consultants. And our outside consultants are these various disciplines, and so they come back to us with a report that has a recommendation as to whether or not some, all, none of the applicants' requests should be granted. They are not exactly rubber stamped, but we do put a bit of credence on our consultant recommendations. So a decision will be made generally by the director as to whether or not to grant the accommodations requested, deny the accommodations requested, or do a modified grant, which would be something of in between. Some grant some and not others. The applicant, after they get their decision, has the right to appeal. And so there's a process by which we go through at the staff level. Usually the ones who have been sent to a consultant will get that appeal. If there is some substantive new information, that appeal will be sent to our consultants again, and they render their recommendations as to whether or not that appeal should be granted, all, part, some. And so then that decision again is communicated to the applicant. If the applicant has not been granted everything that they requested in an appeal, that generally will go to the committee of bar examiners as one of the testing accommodations appeals that they consider. So some examples of accommodations that are requested, some more common ones are extra time during our 2-day exam. So for example, instead of the 3 hours, they want time and a half, which would be 4 hours and 30 minutes for the morning session, and the afternoon session will translate, because it's a 3.5-hour session, into 5 hours and 15 minutes for time and a half. There's also double time, which is a fairly common, which would be 6 hours and 7 hours respectively. And then there's also extra time over extended days, which would mean instead of perhaps taking the exam over 2 days, they take it over 4 days. And testing in a private or semi-private room, oftentimes these are people who have ADHD, who are too distractible, and so they request testing in a special room. Permission to dictate to a typist. These are people who maybe perhaps have physical disability, carpal tunnel syndrome, something like that, where they can't really type the exam or write their exam themselves. And then there are special versions of the examination questions. So, for somebody who's sight impaired, it could be Braille, although we're getting fewer and fewer and haven't had those in quite a while, because I think with the technology these days, people use different things other than Braille. Large print, however, is pretty common. We have people who are sight impaired again. Audio recording of the exam, or to have the examination put on a CD or a USB for use with screen reading software or speech recognition software. So, any questions? Okay, that concludes our section.
Thank you.
Thank you. Oh, sorry. I just wanted to add that for July 2017, we had approximately 600 applicants who were granted accommodation. So it's quite a large volume.
Good morning. My name is Greg Shen. I'm one of the program managers in the admissions department, and I oversee the team here in the Los Angeles office. And two of the functions that I'll be talking about today has to do with eligibility of the applicants who ultimately apply to take the bar examination, and to also give you some details about the actual logistics and administration involved in giving out the examination. So with respect to the eligibility issue, obviously one of the key requirements is the legal education requirement that the applicants have to demonstrate. And there are effectively 3 different tracks, if you will. The first track that you're probably most commonly aware of is if an applicant completes 3 years of law study at a ABA approved or a California accredited law school, demonstrated by the receipt of a Juris Doctorate degree. For those applicants who do not attend either an ABA approved or a California accredited law school, they may attend one of the unaccredited law schools in California. And they need to complete 4 years of law study within that program, followed by, as Lisa alluded to earlier, taking and passing the first-year law students examination after the first year of law study. A smaller program that you may or may not be aware of is studying in a judge's chamber or a law office study program. There are probably right around 100 active people who are doing that, so it's a very, very small number. But once again, this is a very specialized study program, which they complete 4 years of. Then once again, they are also required to take and to pass the first year examination. And then the third and final track is for those applicants who complete their legal education outside of the United States. And effectively the requirements there are that because we want to ensure that the legal studies that they completed in X country is substantially similar to what they would have completed here in the United States, we employ a number of credential evaluation service providers who will actually look at the transcript of those individuals from those foreign law schools and once again give us sort of the thumbs up that the legal education is substantially similar. But in addition to that, those foreign educated students are also required to complete 1 year of legal studies here in the United States at either an ABA accredited or a California accredited law school, which is typically accomplished through completion of an LLM program at one of these law schools. So think of our folks here in Los Angeles within admissions, sort of the natural next evolution process. Once Lisa and her team have developed the examination. Obviously, the next step is to process all of the applications that come into the office from the applicants looking to take the bar examination, and then ultimately administering the examination itself. So as you're well aware, the California bar examination is administered 2 times per year, once in February, once in July. If you look at the numbers up on the screen, those are actual numbers from 2017 in terms of the number of applicants that actually sat for both of the examinations. And as Lisa pointed out, the number that were provided, or granted rather, testing accommodations. So if you add up those numbers, you'll see that slightly north of about 14,000 applicants sat for the bar examination in 2017. I will highlight that in July 2017, we had 9,183 applicants, which was the second highest number on record, and was somewhat unexpected. We did anticipate that there would be greater numbers, given that July 2017, as you know, was the first administration of the 2-day bar examination. And our speculation going into that examination was that applicants may have been sitting out on the sidelines in anticipation of the 2-day examination. And if you compare the July numbers to historicals, we were probably about 1,000 higher than we would have been sometime in the past. So it was a materially higher number. And just to give you a quick preview for February 2018 exam, which is coming up in about a month, and I think Lisa and Christina alluded to this, we had a little north of 6,000 applications that were received, which is actually the highest on record for February. So we're anticipating another big testing number for February, and I'm speculating that the 2-day bar examination is still a little bit playing into effect there with those numbers. So talking a little bit more about actual testing logistics, you'll see from the various arrows on the California map there, those relate to the different testing facilities that we utilize throughout the state of California to administer the bar examination. On average, we're probably contracting with anywhere from about 10 to 15 different testing centers. And these testing centers will be as far north as Sacramento, as far down south as San Diego. In the Bay Area, we'll test in Oakland and Santa Clara, down here in Southern California, Ontario, Los Angeles, Orange County, and Pasadena as well. There are generally 2 sort of main types of test centers. The first type would be the large convention center type spaces, where it wouldn't be uncommon to have anywhere from 1,000 to 1,500 applicants. So just think of a large convention center space, hangar type space, where you'll just see rows and rows of tables of examinees taking the examination, and some of you may have actually visited some of these locations. These facilities are typically contracted about 18 to 24 months in advance. And that's obviously to ensure that we have the adequate facilities to actually administer the examination, not to mention also that these facilities are also contracting with other parties, so oftentimes we do have to lock them in well in advance. The second type of facility, as Lisa had pointed out earlier, was those facilities that are reserved for those applicants who have been granted testing accommodations. And because of the special needs requirements and accommodations that they've been granted, oftentimes they require private rooms, semi-private rooms, smaller type conference rooms where you might have 5 to 10 applicants testing. And for those, we typically utilize hotel type facilities, and we will contract with a number of hotels throughout the state of California to once again have that space available. Probably not surprisingly, facility cost is one of the sort of main cost drivers in administering the examination. There are probably 2 other large buckets of costs, which I'll also talk a little bit about. Once again, probably not surprisingly, we have a number of proctors that we employ to actually help administer the examination. During the July examination, which is obviously the bigger of the 2 exams, it's not uncommon for us to have anywhere north of 1,000 proctors that we're locating, that we're employing throughout the various facilities. And these proctors will do anything and everything from receipt of the examinations, accounting for them once the exam is over, making sure that all of the exams are properly packaged and sent out to the right places. During the administration, we have proctors walking on the floors to hand out examinations, collect examinations, ensuring that no one is doing any funny business, security proctors helping to maintain the integrity of the examinations by checking for the required government-issued IDs, and the admittance ticket, which are sent to the applicants in advance. And that's also a fairly hefty cost in terms of administration. The third and final would be the electrical outlets that we provide for the applicants. As you may or may not know, probably 80 to 85% of our applicants are testing utilizing their laptop. There's a process where they download a special software from ExamSoft, and they need to get their laptop certified so that once they've elected to take the examination utilizing that method, they will bring their laptop to the facility and they will plug into one of the electrical outlets that we've provided for them. And that's to ensure, obviously, that they don't run out of power, et cetera. So really, those three buckets of costs drive anywhere from about 80 to 85% of the total cost of the exam administration. Those are typically the ones that we focus on when it comes to trying managing and paying the costs for the exam administration. Any questions that you might have?
If I could, Brandon Solos. What goes into excuse me, determining the geographic locations of the testing centers?
I think that's an excellent question. There's no specific formula per se, although that we try to sort of disperse the locations in such a way as to maximize coverage so that individuals who are located in various parts of the state can have some locations that are more closer than others. Once again, I don't think there's a magic in doing that. I think there's always a balancing act between trying to find the ideal number and locations with sort of potential cost synergies, right? There's an ongoing discussion within the committee that their costs have gradually ratcheted up. And once again, being in Ontario, the costs are much more attractive. And we decided that we were going to go ahead and try that to see if that would work for us. The other example I would give is that for the first year law students examination, which are typically smaller number of testers, I think this was probably about 18 months ago, we actually administered the exam in the San Francisco CalBar offices. We had sort of mixed reactions with that. There were, I think, 10 testers, so it wasn't a huge number, but I think most of you are familiar with the fourth floor conference area, and that's where we tested. Now, it's not, that area wasn't exclusive to us, so we had individuals going by the elevators, we had other departments there. So, you know, in some ways, it wasn't the most ideal, but there was zero cost associated with doing that. So I think there are certainly opportunities that we should continue to look at.
Now, have we ever done a study on the locations of the test takers or the applicants, where they're coming from, and then, because, you know, I see the grouping there of the testing centers, you have a high concentration in Southern California, and obviously there's more law school down there. And then Northern California around the Bay Area and Sacramento, again, law school there. But like for students who live in other parts of the state, I mean, have we ever looked at what other high concentration of or I guess what cities high concentration of applicants are coming from?
We've done that on a case-by-case basis. I'll give you an example, is that for our test centers in Sacramento and San Diego in particular, when we first open up the registration, we'll actually limit the number of registrants to those two locations for folks that live in the area. And the idea is that we want to give preference for the people who live in the Sacramento area, the first dibs to go test in Sacramento. Same thing with San Diego. There was a rumor or a story a long time ago that apparently individuals or applicants like to test in San Diego because after the exam they like to go down to Mexico and party and celebrate. And because of that, what we tried to do is once again limit the takers to the San Diego area. So when we do that, obviously we need to know zip codes, et cetera. But I will tell you, that's not a hard and fast rule.
Well, I mean, people are certainly welcome to come to Bakersfield.
Let me work on
Loose
that.
after the bar exam.
Ontario has some good bars.
I just wanted to raise another question that the board may want to consider at some point, is just reducing the number of test centers overall, which would drive us to the very large convention center take places. But there are some significant potential cost savings, I think, that could be incurred by reducing the number of test centers. It does not get geographic distribution, but there'd be other reasons to do that. because we do have challenges recruiting proctors, even in some of our more metropolitan areas. So this is other possibilities for us to consider. We're somewhat unusual in the licensing board as we've done a little bit more looking at the number of sites that we offer these exams.
If I can add one thing to that, I think that's an excellent point, Leah. And I will tell you that the Santa Clara Convention Center, which we use, which happens to be one of our largest potential testing sites, off the top of my head, we've tested anywhere from 1,600 to 1,800 applicants, which is very, very large for us. But as Leah pointed out, that's one of the areas where we seem to have difficulty finding proctors. I don't know if it has anything to do with the fact that Silicon Valley is there, and the job market, et cetera. But I do agree. I mean, strictly from a cost-saving standpoint, I would love to find a facility that can test 5,000 folks, and we spread those costs out over 5,000 people. But I think one of the things that you'd want to consider, and the thing that sort of keeps me up at night, is if something goes wrong at one facility, at a large facility like that, now you're impacting 5,000 versus 1,000. So there's sort of a balance there. Just something that you need to
We have the earthquake, the rock band.
Earthquake, power outages,
Christian rock band.
flooding, Christian rock band, sure. Okay, thank you.
Good morning, everyone. My name is Mark Torresgill, and I'm the program manager for the Office of Moral Character Determinations, and allow me first to thank you for your time. And what I'd like to do right now is spend a few moments to review the process that we use for determining a person's good moral character. And I just want to add that, in addition to the legal education requirements and the requirement of passing the bar exam, an applicant has to establish his or her good moral character, which the Supreme Court has said very clearly is essential for the protection of clients and essential for the protection of the judicial system itself. So how is it that, first I suppose the first question is, so what is moral character? Well, a number of different elements go into that definition, and includes things like qualities of honesty and fairness and candor, trustworthiness, observance of fiduciary responsibility, and respect and obedience for the law. Those are some of the things that we're looking at when we're doing an evaluation of a person's good moral character. So the process, so how do we go about the process for looking into a person's moral character? And it essentially is a background check. It begins with the filing of an application, and for those of you who are attorneys, I'm sure you can recall that having to fill out a moral character application that is very, very extensive. And it requires the applicant disclose his or her background, employment history, residence history, history with regard to any civil actions that are pending or have been filed against him or her, the arrest records, conviction. The application will also include DMV records, rap sheets to the extent one exists. So it's a very comprehensive application, and is intended to be comprehensive in order that you can see into the person's background to see whether or not there are any incidents or areas of misconduct that might implicate an individual applicant's ability to practice law. The application process begins in the pre-processing unit here in Los Angeles. And what that pre-processing unit does is to make sure that the application is complete, make sure that there are no missing documents in that application. And once that application is complete, the pre-processing unit then conducts a preliminary evaluation of that application. And if there are no incidents or areas of misconduct, if that applicant's background is pristine, and in effect, if that applicant has led a very boring life, and then the application can be cleared at that stage because there's nothing in the application that raises any areas of concern. There are, however, what we have sort of categorized in different levels of seriousness and increasing levels of seriousness. We identify them as, level 1, 2, 3, and 4 cases, to the extent that there are any incidents in the applicant's background that raise any concerns in these different levels of concern. Then the application is forwarded to a moral character analyst for further review and scrutiny. So what kind of incidents would we be looking at in a person's background that might raise that might require further scrutiny? You see here examples of the types of incidents that might raise areas of concern and increasing levels of seriousness. Here in a level 1 review, you might find an applicant might have a juvenile misdemeanor in his or her background, or maybe a bankruptcy without any adversary actions, or maybe simply academic probation. But something like this we'd want to look at, maybe scrutinize a little more, look at the facts and circumstances, see whether there's anything else that might raise additional areas of concern. In a little more serious areas, we have level 2 areas of concern, which would incorporate misdemeanors, failures to appear, maybe some minor college infractions, things of that nature. Again, these are just examples, as we have a much longer list under each of these categories. And we start then getting to level 3 type matters, which start to increase the level of seriousness and concern for us. DUIs, for example, or other professional discipline. For example, if you've got a real estate license, and maybe you have a restricted license that was imposed for a particular reason. Something we want to look at more carefully. Fraud accusations, major undergraduate discipline, and then of course we have the highest level of concern, which would require enhanced level of scrutiny of the person's background. For example, multiple DUIs, felony convictions, law school honor code violations that we see quite a bit, surprisingly, and maybe court sanctions imposed on a lawyer with a license in another jurisdiction. So when those matters...
Mark, can I ask a question
That's
before you
fine.
move on to the next slide? Where does mental health issues and substance abuse issues come under this analysis when they haven't risen to, a DUI, for example, or a misdemeanor? There's just issues there, because I know we ask about it.
Yes, we do.
How do we determine that needs to be looked at in the process that we go through for that?
Yeah, well, first of all, and we can talk more about this later if you wish, but, we don't deny a person a good moral character evaluation simply because they have an addiction. That's not what we do. What we are doing is looking at a person's background and to determine whether or not there are areas of concern that implicate their ability to practice. So it has to be tied into practice and their fitness to practice in that regard. So if there is for example, we see this a lot with drunk driving cases, DUIs, where the individual may or may not have, where the alcohol addiction has manifested itself in some form of misconduct. So, at that point, then we are in fact concerned with whether or not that person, is ready to be admitted into the practice of law and adequately, represent his or her clients in that practice. So, that's where, when the issue has manifested itself in some form of misconduct, then we take a closer look at it. Okay. So,
building on that question, how does the work that your unit does interact with lawyer assistance program services to newly admitted lawyers?
Yeah, and matter of fact, I'll be getting into that in just a little bit.
Answer it now. You need to answer it now.
Yeah, I will, and we'll be talking about that.
And we've been asked to make sure that everybody speaks right into the microphone.
Okay. Everybody, please speak into the microphone. Thank you.
I got that part. Mark Rodden. Is the information that you obtained here on the board, does that come directly from the applicant?
It comes from different sources. Sometimes, we don't get complete, sometimes the applicant is not completely forthright. And so we do receive information from the law schools. We get certificates of good standing from other jurisdictions who may reveal to us that the applicant who's licensed in another state has undergone discipline. We get our confidential questionnaires. They often reveal information. We do look at databases, PACER and courtroom records. So we do, and we get anonymous letters sometimes from individuals, and so we will look closely at what.
You also get information from the Department of Justice?
We get information, sir.
And so forth?
Well, they do fingerprint checks, right? So as a result, we will get rap sheets, and we'll be able to see what's on those rap sheets. So yes, absolutely.
This is Hyland Chen. What about undergraduate student conduct records? Something other than just the transcript?
Yeah, what usually happens in that case, the applicant will voluntarily disclose, because there's questions on the application very clearly asking, have you ever been subject to academic or disciplinary sanctions, either in undergrad or in law school? What often happens is that not often, but occasionally, let's just say, that the applicant either forgot or failed to disclose some form of academic or disciplinary sanction in undergrad. We will look at the application that they forwarded to the law school, because all the law schools require that they disclose academic or disciplinary sanction in undergrad, and oftentimes we will see something in that record from their law school application that we get a copy of, and it doesn't coincide with what they've told us on the application. So we're constantly doing those types of cross checks.
And how would you treat an incident of sexual misconduct in undergraduate articles in law school?
Yeah, an incident of sexual misconduct we look at very carefully, and we look at whether or not, what the sanctions were, if it resulted in sanctions, whether it went through a Title IX investigation, what was the result of that Title IX investigation. We'll make inquiries, to the school itself. We'll ask for the records and the background records, and we'll also ask the applicant to provide any and all records concerning that allegation. So we look very carefully at those kinds of cases, and they do in fact come up. So moving back into the presentation. What happens here when we find so after the application has been forwarded to a moral character analyst, what we'll do is look at these more carefully at these sort of level 1 through 4 kinds of incidents appear on the application. And if after looking at it a little more carefully, it remains a level 1 or a minor level 2 issue, then the moral character analyst is authorized to clear the application at that point. If the issue raises more serious level 2 kinds of incidents or level 3 cases, we start a further investigation. We start communicating with third parties, maybe other agencies, the law schools, witnesses, whatever we need to do in order to truly satisfy ourselves that we have as much information as we need to get for that matter. And these matters will often be reviewed by a section chief in my office, supervisor of the moral character analyst. And also with serious levels 3 and 4, those matters also undergo enhanced investigation, and they are referred to me usually for my review, and I have the authority to clear cases at that level as well. But what we do, if we have cases that raise significant issues of concern, then we can refer them to the Committee of Bar Examiners for what's called an informal conference. So what is an informal conference? An informal conference is essentially an interview with the applicant, and it takes place either in San Francisco or Los Angeles, lasts about an hour. We ask the applicant to come in and sit with members of the Committee of Bar Examiners and their subcommittee on moral character determinations. Usually it's somewhere between 2 and 4 members attend. They'll have a copy of the application and all the information that we gathered. They will have reviewed it, and the applicant will be subject to an interview. And following that interview, the committee of bar examiners has the option of making several recommendations, a positive determination, and re-refer for further investigation, advance or negative determination. We'll talk about that right now. So if the committee of the bar examiners decides that after the interview and evaluation of the application, the committee can clear the applicant as having established good moral character, and that applicant then has 3 years to pass the bar exam. And if they meet the other legal education requirements, and if they have, then they will be cleared. If they don't, then they'll have to submit another moral character application after 3 years. The committee can also re-refer the matter back to my office for further investigation. And what we do is we try to collect whatever information we need in order to answer the subcommittee's questions, or we can ask the Office of Chief Trial Counsel to weigh in on whether or not weigh in on the application itself. Mr. Colantano, this is an answer to your question with respect to the Lawyers Assistance Program. Another alternative that the Committee of Bar Examiners can pursue is an abeyance. An abeyance essentially puts the application on hold in order to allow the applicant to perhaps address some of the issues that have been raised. And for example, if we have an issue where the applicant has multiple DUIs and some of them are recent and clearly has an issue with alcohol, then what we would do oftentimes is to refer the applicant to the State Bar's Lawyers Assistance Program so that they can undergo an evaluation, and the committee will refer the applicant maybe for 3 months or 6 months, a year, whatever the committee feels needs to be done in order that the applicant do what's necessary in order to be properly rehabilitated and perhaps recognize that they may or may not have an issue. But the Lawyers Assistance Program plays a substantial role in making those types of, in helping us evaluate applicants and their ability to practice.
And how long does that process take? How long is somebody receiving assistance from LAP between your referral and when they're cleared to join the bar?
Well, the way it works is that when an applicant is referred to the Lawyers Assistance Program, they will go through an initial evaluation, and that process takes about 3 months. And the Lawyers Assistance Program will then make a recommendation, and they will they have different levels of insight. You know, they can say several things. One, the Lawyers Assistance Program can say, this individual went through an evaluation, and we talked to them, we've done random checks, whatever we need to do, and we now conclude that this individual does not have an addiction problem, and there's no need to admit them into the program. Well, in that case, well, we can feel comfortable perhaps clearing that applicant. Another thing that the LAP can do is submit what are called insight letters, and they have different levels of insight. The highest level, the best level, is something called a significant insight letter that comes from the LAP that says effectively that this person, yes, has an issue, but they have in fact recognized that they have an issue, and they know very, very well what they need in order to maintain a level of sobriety, and so they have a very, very good insight into their condition, and they receive what's called a significant insight letter. And then when we receive that, that's a very good thing, a very good sign. We can clear them at that stage. And there's other levels of insight going down all the way to no insight. Or the LAP could say, we need to have this person needs to be in our program and be in our program for a while. So, we do listen very seriously to the recommendations of the LAP. So,
just to add, one of the great things that happened this year in the fee bill is that we did see a modification in the LAP statute such that we could use LAP funds to actually pay for the services for those applicants who are referred from the Committee of Bar Examiners. So that has been a really positive development. Heretofore, the Office of Admissions has had to pay for those funds or pay for those services for the applicants themselves.
And do you have a ballpark on the number of people who benefit in this way per year?
I don't, Mr. Colantano. I mean, I can try to get that
Is it a
information.
handful
for you.
hundreds? I'm just trying to get a sense of the order of
It's not a handful.
It's not a
We'll hear about
handful.
it more today, well, later when we get to the LEP segment, but I don't know if it's that way at this present time, but it has been slightly more than half of the LEP caseload has come from the applicant population.
I just want to make an observation that this is a significant way that is perhaps underappreciated by those who pay attention to the bar, that we are protecting the public by preventing folks from getting in trouble as lawyers, but we're also making it professionally accessible to a range of people who are not otherwise join us. So we're serving both our access mission and our protection of public mission in ways that may be underappreciated.
Right, thank you for that. And I will say also that one of the things that I enjoy seeing is someone, perhaps an applicant, who is very resistant to recognizing that he or she may have an issue. We send them to LAP, and then subsequently they're actually saying thank you, for having sent them to the program and gone through the program, and then develop the kind of insight into their condition that speaks well for both for the program and for the applicant him or herself. Moving on, if there's a negative determination, then the applicant can reapply after 2 years, but the applicant also has the ability to contest the denial of good moral character, and that appeal then goes to the State Bar Court. In that appeal, the Committee of Bar Examiners is represented by the Office of the Chief Trial Counsel, and the Office of Chief Trial Counsel then conducts its own investigation. There's an investigation period leading up to an administrative hearing, then the applicant will be deposed, and information will be gathered, and then it goes through a sort of trial level administrative hearing that's conducted in the State Bar Court Hearing Department, and to the extent, depending on the outcome, either the Committee of Bar Examiners or the applicant can then appeal that outcome to the State Bar Court Review Department, which acts as a appellate level State Bar Court, and ultimately, if one of the parties wishes, can appeal that to the California Supreme Court, which makes the ultimate and final determination. The last, most recent moral character case that came out, and all of you may be familiar with it, was the 2014 case in Ray Glass, which is a very, very important case, and where the Supreme Court actually confirmed and reiterated the importance of this process that we do in evaluating individuals' good moral character. So I thank you for your time. If you have any questions, I'm happy to answer them. Thank you.
Never can tell if the mic is low enough when you're 5 feet tall.
You probably need to get closer or louder.
Okay. I'm Natalie Leonard. I'm the program manager for the program in legal specialization, and I want to thank everyone for your time and tell you a little bit about the program.
How many legal specializations are among us? I know you're on Joanna and Sean.
Yes.
Me, Mark.
Actually, I'm ending research page.
All right, so I think you're 3 out of 12.
Joanna, Sean.
No,
Oh.
I specialize in state law.
So three.
Yes. So
It's true.
3 out of 12, and if you discount in only this way our 2 non-lawyer members, it's 30% of the lawyers on the board.
Thank you.
Texas State.
So this all starts with the Supreme Court rule, Rule 9.35, in which the Supreme Court asked the State Bar to create a program for certifying specialists, and the State Bar has been doing so for a number of years. The Supreme Court's idea behind creating this program was to protect the public by giving them an independent means to determine an attorney's qualifications and commitment to the area, and also to promote attorney competence. We think anecdotally that it also helps to encourage civility in the profession, and it rewards lifelong learning and commitment to individual areas of practice. There are 11 specialty areas. They are all designed to focus toward areas where consumers may have a legal need. And many of the times, consumers in these areas may be approaching the legal system for the first time. They may not know where to turn. They may not want to turn solely to the internet, a very popular place for referrals, but you don't know who's writing, why they're writing. So here, the State Bar provides a very trusted and credible source explaining clearly what these individuals have done to earn their certification as specialists. There are about 5,000 specialists in California right now. This is one of the larger programs in the nation. Florida, Texas, and California have the largest programs in total. And as Michael mentioned, yes, 3 of those members are here with us today, Sean and Michael and Mark.
Leave that up for a moment. I think what's interesting about this is that the 3 largest are all around between 1,000 and 1,300, and they are sort of what you'd expect for a program aimed at a consumer market. Estate planning, trust and probate, family, and workers' comp. The second tier is the 3 that are in the 300 range, and that's tax and criminal and appellate. Interesting to me that there aren't more criminal, because that certainly has a consumer audience. And I think the reason that you see the numbers for appellate and tax is not because they're aimed at a consumer market, it's because they're aimed at a lawyer-to-lawyer referral market. And I know that in my practice area of appellate expertise, it's becoming expectation. If you really want to sell yourself as an appellate lawyer and you don't have an appellate certification, there's a question asked about your competence. So the program is developing sort of a momentum on its own. But I think those numbers are kind of interesting. And I have a lot of respect for the 38 brave souls who sat for the Admiralty.
I'd like to see immigration next year.
Yeah. Yeah, well, so as to Michael's thought about the tax, originally there was only a taxation specialty. There was not an estate planning specialty. And so the original focus of that was in an estate area. And then after time, it was determined that really we needed 2 in those areas. And so tax has gone off in a little bit of a different direction then, but it started out as an estate planning discipline.
You know, I don't know if you have statistics on this, but Mike raised the point about criminal law section. Sorry. The criminal law portion, most of those, I believe, are public sector individuals. PAs, public defenders, and things like that, because they get, I can't speak for the entire state, and I know they get an additional pay if they're certified specialists. There's very few on the private side that have a specialty in criminal law, which surprises the heck out of me.
And the appellate number is a little, it conceals the fact that there are really 2 separate specializations. There's a civil appellate specialization, which is about 2/3 of that number, and there's a criminal appellate specialization, which is the other 1/3, and there's a few brave souls who hold both.
And I do think historically, in the criminal area, there have been primarily public lawyers. What we've seen most recently is many private defenders. And I think that this time, we had a record number of applicants overall, many in the criminal area, and I think you're going to see the balance shift a little bit this time. We don't know the pass-fail results, so I can't say for sure. But that's something I think we can look forward to. Immigration, of course, was something that was very well subscribed this year as well. The program is governed day to day by the California Board of Legal Specialization. That's a 15-member board. It changed in its composition recently, probably at just the right time, prior to some of the recent cases that had come out. Previously, it had 1 public member, and the remainder individuals were certified specialists. But now the board is a mix. It's a combination of certified specialists, attorneys who are not certified specialists, and more public members, 3 public members at this time. And for the first time last year, a public member was the chair of the board. So those members are appointed by this body through your nominations and appointments process. And they also work with individuals who are specialists or otherwise experts in the area to develop the exam, but those are selected by the California Board of Legal Specialization, and they are all volunteers. So one thing that some people in this room know is that it's very challenging to earn a certificate of specialization. It's not a referral program. People invest a lot of time going ahead to do this. The first thing that you need is 5 years of experience in the practice area. And it's not just any 5 years, it's not just time passing. You really do need to have a very broad base of experience. So you may decide to specialize very narrowly in your practice, but the idea behind specialization is to have a very wide understanding so that you can refer issues that need to be referred and take issues that fall within your lane. We see people starting this process anywhere from the day that they are admitted. They don't come to us at the 5th year. They use the guidelines in order to develop their practice as they're going. They use their guidelines to help get the right types of work that will make them strong attorneys that have successful careers, that provide great services to consumers. They can actually take the examination as soon as their 2nd year. That's not appropriate for everyone. It depends on how much experience they've had in the field. The reason why they can take it at that point is because the exam results are valid for 3 years. So a person who's got a very aggressive, committed practice might be able to use that time to get certified at the soonest possible time. And we do see the number of individuals in their, not so much 2nd, but more their 3rd to 4th year growing quite a bit. And we've seen about, I would say, as a result of adding those individuals, about a 25% increase in the number of individuals that are taking the exam. The exam is a one-day exam. It can be challenging for folks to return. They've all obviously passed the bar, but this is something that's hopefully within their bailiwick, what they do every day. The exam is offered at the same time as the first-year law students exam on the same days, usually in the same places. So that gives us some efficiency in the price. We can make the price a little bit more attractive when we do that. And the exam consists of something similar, but not exactly the same as the first-year law students exam. The sections are of the same size, but of course of different composition. So the first-year law students exam is about being ready to progress to your 2nd year. The bar exam is about establishing minimum competence, and then the specialization exam is about establishing proficiency, one step up from there. Your essay portion, you have more topics on this exam. You have 8 short essays. Reason being, you need to show a wide experience, a wide breadth of experience, but also as you practice more and more, you may specialize in certain areas, and as a result, we need to give some flexibility to say, I focus on these 6 areas, I studied for these 2 for the exam, I can identify the issues, but I may not know the areas as well as somebody who does them all the time in their practice. What we won't do is we won't ask people to adjust their practice to prepare for this exam. Rather, we want an exam that supports those that achieve excellence in their practice. The afternoon session is a 75 multiple choice exam, and a little bit of trivia. In the past, we used to give part of the essay questions in the morning and then part in the afternoon along with the multiple choice, and people could decide how to break up their afternoon. When we did that, we had about 10 to 20% attrition in the exam. People didn't come back in the afternoon. So now that we've changed it, and all of the essay question is in the morning, and all of the multiple choice is in the afternoon. This time we had 941 applicants, and only 1 person chose not to return in the afternoon. And that's the first person in the last 4 administrations where we've done it this way. So maybe that says something about how people feel about the different parts of the test, but once we get them there, we're glad that they're now completing it. The exam is designed by certified specialists, professors, and sometimes non-certified specialists who have practice in the same area, we use a model kind of similar to what Lisa described to you in drafting the essay portion of the bar exam, but they also draft the multiple choice questions themselves. We don't have the benefit of a national NCBE, so those questions are developed in-house. Those drafters also mix it up and grade the exam as well. You don't get to grade the question that they drafted, but we use something similar, and we work with some of the EDGE team members to go ahead and draft, and we use a process much like the first year. We have one grader per question, so for each specialty, there'll be 8 graders. What's different is they come on site. They do all of their grading when we're all together. We can do that because of the size. And there is a resolution process that's very similar to what Christina described. I don't know how long people would have to stay if they graded the bar exam while remaining on site. Probably longer than they would want to stay. But we can usually finish a subject in 1 to 3 days. We actually do take about as long as the bar exam to release the results, though, and sometimes people ask why that is. Reason being, we stagger our resources. We share the infrastructure of admissions. Bar exam and first year have statutory deadlines. Those are graded first, and then when those experienced personnel become available, they come to help us with the specialization exam. And so that's the priority as it should be. And we ask the patience of those that are taking the exams. The exam results will be released this year on March 15th. The next thing that will happen once an applicant passes the examination is the independent inquiry and review process. They're asked to submit individuals' names who are familiar with their practice. We're not looking for a person's opinion. This is not a club. This is not a fraternity. We're looking for individuals who have witnessed the person in practice and that are aware of the person's proficiency in the practice. And we ask that all of their observations be evidence-based. The names are submitted to the department. Oh, Joanne.
Joanna Mendoza, do you just get other attorneys, or do you actually get clients to comment on that?
Right now, it's attorneys and members of the judiciary. That's not something that has been done, but that's absolutely something that could be considered. And I'm making a note. In addition, as part of that application, they also will show their experience and their education. The specialists commit to completing additional continuing education, and they commit that it will be in their area. So all of us as attorneys are required to complete 25 hours every 3 years. Specialists agree to commit to complete 36 hours, and they're all in their specialty area. They report on the same schedule as MCLE, so Group 2 is reporting on February 1st. Right now, they do so through a paper system. The reason why they use paper rather than the My State Bar attestation is because as this program rolled in, previously the specialists reported their education on a 5-year schedule. Some of them had already taken classes in years 1 or 2. We wanted them to be able to have credit for that education that they had taken, so the paper system allowed that phase-in period. As we go forward into a new AIM system, we hope to be able to have a consolidated online reporting. So the paper seems like a step back. It's a step forward in terms of flexibility, but one that will sunset pretty soon. So just to summarize, a specialist shows that they have the knowledge by passing the exam, that they can apply the knowledge by having the experience in the area, that they're committed to keeping that knowledge current through the education, and they've established a reputation for proficiency in the field that we see through the independent inquiry and review process. You might also be interested to know that the program is completely self-funding. No general fund dollars are used as part of the program, and the program does contribute indirect costs back to the State Bar in exchange for the services that are used here. Are there any questions? Thank you.
I just want to give a little plug for the program, because I'll tell you that in my experience, I'm a better lawyer than I was before I took the exam. Because it's having to study for the exam, I had review my subject comprehensively in a way that you don't in practice, and learn some things that I didn't realize I didn't know. And I certainly know that it's had benefits to the way my clientele perceives me. So it's a valuable program both for me selfishly and for our missions of protecting the public and providing access to justice by making lawyers better servants. So I just want to applaud the bar for a program that I consider to be very valuable.
Are there thoughts of increasing the number of specialties?
Yes, we get proposals from time to time. There's been a dialogue in the City Attorney's Department of the League of Cities about establishing a specialization, ultimately because of the tension between the youngsters who want the credential and the old dogs who don't want to take another exam and don't feel the need for the credential. They've decided to do it outside the bar structure as a private exercise. But I think once they get through their internal politics, they may be having some dialogue with us about establishing an expertise for public law. We basically look, my sense is, and you should answer this, we look to the bar itself, the public law, the professional community to come to us with proposals. We haven't been out there drumming them up. Is that right?
Well, to be honest, we haven't looked into creating a new specialty in a number of years, primarily because the program has been undergoing a number of operational changes. Cut score study for the exam, changing that up, getting ready for the computer system. So it's actually been a little bit of a while. And so when that process returns, we probably will return to you with some thoughts about what the best way is to determine how to prioritize new specialties. But it is a mission of the program, and the Supreme Court does ask for the program to look into expanding the number of specialties.
And it strikes me that we may want to engage in some dialogue with the California Lawyers Association and perhaps the legislature, because I think there's an economic development strategy for California around what kind of economy we're trying to be and what kind of resources we need to be to develop that economy. And so, for example, an IP specialization might matter an awful lot to our economic aspirations as a state. Figuring out how to do that and what the audience for it is. But those kinds of dialogues I would encourage. I think the admissions section has some other large rabbits to get through the snake in the meantime, but when they're ready, I think there's some interesting discussions to have. Anything else on this issue before we?
Yeah, when you brought up the California Lawyers Association, I think that's one of the questions that I think we need to grapple with a little bit is, it seems like it falls mostly here. Sorry, it feels like it falls mostly here, but there's a feeling also, are there elements that maybe fall over there? And I think that's one of the things that Alan and I are going to work with Natalie on and discuss further. There's a part of me too, and I don't know enough, again, being a public member, not a legal member, but I'll do my background on this a little bit more intensely, but there seems to be a little bit of a compound factor as well, so I just want to look at that a little bit more. So we'll, again, work with Natalie closely, and she's briefed us really nicely, and we've been looking at this and talking about it, and we'll do more of that. So
my impression is that other professions do credentialing entirely in the private sector. Your physician is board certified, and that board is a private association. It's not a government agency. And I think the reason that we have a government agency doing it as part of our regulatory mission is because of the way that we regulate lawyers' communications with the public to protect the public.
Right.
So lawyering is a little different in the way that we market ourselves, and that marketing has risks for public protection, and therefore we do the certification. But there's a part of it that is certainly a trade association function, if you will, and the dialogue we had between the trade association and the regulator that will be valuable.
Right, and it's that business development component where it just gets a little murky.
Right.
And that's the part that I'm just kind of sorting through, and we just start talking about.
Right.
Part of what we'll be examining is that there actually are some private trade associations that are separate from the bar, such as the Association of Certified Family Law Specialists, that do some of those business development steps that the bar is not positioned to do and is not doing.
It's not our mission.
Right.
Thank you.
Okay, thank you.
Takes me a while to straighten out.
Good morning, ladies and gentlemen. My name is George Leal. I'm the program manager for the Education Standards Department. And I first want to say a couple things. Thank you for your time. I know it's been a long morning and we've covered quite a bit. And my little shop is a little bit of an anomaly. And so I've got a lot of information, and I'm often guilty of providing perhaps too much. So I'll try to limit it to what is most important for you to learn. With that said, I'd like to start off by just making two comments. One, I believe deeply that the committee has, for decades, worked hard and successfully to pursue and achieve, in large part, a couple of the key prongs of the state bar's mission. And I speak directly and most thematically about diversifying the profession and access to justice. And as we go through this process and we see where the schools are and what they do and who they teach, I hope you'll come away with that belief. And when I refer to diversifying the profession, another point I'd like to make is that there are obvious different forms of diversity, not only race and gender, but geography and economic diversity. And as we get in talking to and discussing the Cal accredited schools accredited by the committee, I think, and I know that will become more apparent. Let me go to my first slide, and, well, I'm sorry, going backwards. Oh, my apologies. First point to keep in mind is that California is very unique in a number of key metrics. And as you'll see here, there are currently 56 law schools in California. And that, you'll see, is significantly above the 15 that operate in New York, the 9 in Illinois, and the 9 in Texas. And the reason for that, I think, is based on a very long-standing and important public policy. Unlike what you've heard this morning from my colleagues, all states do what my colleagues do with regard to the development, administration, and grading of bar exams, moral character. California is singly unique in the nation. We are the only state that accredits non-ABA education. And as a result of that, and secondly, we also, by statute, allow and provide a means for individuals who attend unaccredited schools that are regulated now by the committee to take and hopefully pass the bar exam. Of course, with the largest population in the United States, there's another factor with regard to the market demand for legal education in California has historically been significantly greater. So for 56 sounds like a lot, and that number changes. Since the Dunn bill went into effect, actually 10 years ago this month, for instance, you'll see in a minute a slide regarding unaccredited schools, has stayed relatively stable at 20, but that's changed dramatically. In the last 10 years, committee and staff, and frankly the marketplace, has closed probably a dozen of the unaccredited schools that were operating 10 years ago today. In their place, we now have 14 or so of the unaccredited schools which are online. And that is currently reflected in the percentage of students that are attending unaccredited schools. 90% of students attending unaccredited schools attend online. And now 10%, and soon to be less than that, of students are at fixed facility schools.
George, if I can just add something. The piece of legislation that George was referencing 10 years ago moved the registration of unaccredited law schools from the Bureau of Vocational and Private Post-Secondary Education over to the Committee of Bar Examiners.
Yeah, and thank you, Donna. And that's had a profound effect because, and, I'm going to give a shout out to the committee and staff over the last 10 years. And that, I think, what drove this particular legislation is the amount of oversight and regulation of unaccredited schools has dramatically increased. And as I say, the committee has closed a dozen or so, and the schools that have come online, figuratively and actually, are in a much stronger position than they were back in the day when the Bureau would be simply allowing this to open. Let me move to the next slide. So keep in mind, again, we have these different tiers, and everyone I know is very familiar with the tier of ABA approved law schools, and there are 21 of those in the state, and we have 15 accredited, Cal accredited law schools and 20 unaccredited. Let me just speak briefly about tuition, because when I speak about economic diversity, the Cal accredited schools, to a large extent, and as well as the unaccredited schools, provide a very, very broad spectrum of individuals who are looking for the opportunity to attend, graduate from law school, and then take the bar exam and practice law. The differences in, and you have a handout before you, and you'll see the specifics, but the discrepancy or the disparity in tuition between the Cal accredited schools and the ABA schools is profound. I personally went to every ABA law school in California, went to the website, and took a look at their tuition, and the trivia game might come up with is guessing which ABA approved law school currently has the highest tuition in the state of California. And any SC graduates, because SC wins that award, at $62,000 a year, meaning that to earn a JD at USC, your tuition, not your fees and not your living expenses, will come to about $180,000. And that matches up with the current average to earn a JD at the Cals of only $65,000. So you can see that at the highest level, the Cal tuition is roughly a third, and in some cases a half of what it would be to attend an ABA school. That opens up and provides a significant opportunity for a broad spectrum of many working adults, people in current careers and people looking to transition and move into the legal profession. I taught at one of the Cal accredited schools for 9 years, and I'm really proud and happy to tell you, every year that I taught torts and remedies, in my classes in San Francisco, I would always have 1 or 2 peace officers, deputy sheriffs, SFPD. One of my colleagues, who's no longer here, who was the director for moral character, was one of my students, and she was at the time a San Rafael PD, and when we started working together, confided in me that during our torts class and during the break, she was doing undercover narcotics work, and she was setting up undercover drug buys in San Rafael during torts. And I said, "You never told me that." She said, "Well, I couldn't tell you that until now." And so my point there is the people who I was privileged to teach, real estate agents, assurance adjusters, small business owners, really come into law school with significant life experience, and many of them become really first-rate attorneys. And I was proud, more than once, trying cases in San Francisco Superior Court, to have a former student in the next courtroom trying, frankly, a bigger, more important case than I was trying. So that's one of the more personal insights. The Cals are largely a fixed facility. They're all fixed facility, and they span throughout the state. What happened recently is there's been a growth in branch campuses. What the committee has, through guidelines, established is the right for one Cals to say, and Dean Winnick is here, and I know would be happy to tell you more about Monterey College of Law, because in just the last 4 years, their home campus has been in Monterey. They have a satellite campus in Santa Cruz that teaches the first year class, and then those students, after they complete, then go to Monterey because of the close proximity. But in the last 2 years, there's now a branch of Monterey College of Law in San Luis Obispo, and the Kern County College of Law, a branch of MCL, just opened last fall in Bakersfield, where there was no Cal accredited school. So you'll see the map is each of those pinpoints are either currently existing Cal accredited schools or branch campuses. And branch campuses are designed to, when they eventually expand their enrollment, to include the four-year curriculum. And so with regard to geographic diversity, I'd like you to know that the system is currently comprised, has a very strong presence in the Central Valley, spanning from Chico through Sacramento, Modesto, San Joaquin College of Law in Clovis, next to Fresno, and the newly opened campus in Bakersfield, and now San Luis Obispo. We have 2 Cals that operate in campuses both in Ventura and Santa Barbara. So there are, and another example is Santa Rosa up in the North Bay of California. Again, providing the opportunity, and many of these people understand, for instance, the Central Valley, they perhaps could, but don't want to leave the Central Valley. San Joaquin College of Law is an excellent example of that. They stay local. It's a more affordable program. And anecdotally, I've been told, and I believe this is true, that probably a quarter of the bar in San Joaquin County or along in Fresno and Clovis are graduates of San Joaquin College of Law, and something like 20% of the bench. So for historically, because the school's been there for 50 years, has provided a very profound impact on that community. The same can be said for Cal Northern up in Chico. Very small school, 38 students. But historically, they have been there for a while, started by local judges and attorneys 40 years ago, and have done a very credible job. And again, a small personal insight, I've been working at the bar 8+ years. My favorite phone call, and this is a plug for that school, for the system, and it's an example of what these schools can do. And I got the bar results. They were just mailed out. This is back in the day when everybody knew exactly who did what. And I called the dean up at Chico. I said, Dean Brooks, are you sitting down? She says, no, should I be? And I said, I think you should. And in a matter of a minute, this is the most fun conversation I had. It turned out that year, I think it was 2013 or 12 or 13, they had a 91% first-time pass rate. 11 students out of 12, I think, passed. Remarkable. That year, they were the top school in California, beating Stanford. And I said, Dean, and one more thing. She was excited, very pleased. And she knew that their student, that class in particular, had done well. I said, are you sitting down still? And she said, yes. She said, well, I can tell you for a fact that because we reported 10 students with regard to the Harvards and Yales, that your school in Chico, with 38 students, had a higher first-time pass rate than Harvard or Yale. And that is an you can go to our website, those statistics are there. So that's an extreme. The next year, their rate dropped as they do fluctuate. So that's, I hope, an interesting anecdote.
What this map tells us is when the state of New California breaks away, they'll start with 5 law schools, which is 5 more than Alaska.
That would be true. With regard to the CALs, the faculty is for the most part adjuncts. These are working, practicing attorneys who bring into the into the classroom, their life experiences, and people teach at these schools, as I did. You don't teach for the money. They get paid relatively very little. They teach because of the joy of teaching and the challenge of training the next generation of attorneys that they're confident will go off and practice. And practice in offices, smaller law firms, public entities, and do what they will, and serve a different demographic than most of the people graduating at ABA schools. With regard to the committee, it has exercised its authority, I think, in a very profound way over the years. In just the last few years, and for the only last couple of years, we now have a minimum pass rate. There's 40% cumulative minimum pass rate. And that's a good example of how collaboratively the CAL's schools and their deans have worked with committee staff, because this came, these schools have been accredited, to my understanding, for 75, 80 years and never had a minimum pass rate. And so through a lot of discussion, public discussion, forums, working with the Rules Advisory Committee where deans sit and we work with them to come up with this and the formula, it's been, I believe, successful. And it is only, however, for other reasons, only been in effect the last couple of years. And just now in 2018 is the committee going to be given the opportunity to move forward and take action against any of the CALs that are found to be operating non-compliant below that 40%. We've been handicapped, of course, with the issuance of our data. They haven't been able to get this data, and the committee suspended those guidelines. But that's changed, and we're going to move forward on that. Let me think. Again, the impact on the community is hard to overstate with regard to that story I told you about Cal Northern. No one here in the room knows that story. You do now. But I can guarantee you that not only did the bench, the bar, and the community in Chico, it was in the local paper, of course, knew and appreciated just how well that school had done. So that's, I believe, an important factor. Moving on to the, the other aspect here with regard to Cal Accredited is diversity. It's ethnic diversity. They, both through the location and tuition, draw from and admit a very diverse enrollment, and have been for many years. Gender comparison, and I think this probably is true in both the ABA schools, but more so the CALs, they are now predominantly female, and that's a good thing, and I think that will itself have a profound impact as these graduates move into the profession. Oops, I'm sorry. I guess I'll go to if you look at the handouts. If you're interested, and I would encourage anybody, there's a list in the handouts of every Cal accredited school along with a website link. We have a list of all the registered schools, and speak to them in the time that I have left. And you'll see, for instance, the size of these schools that Cal accredited is, most of them are small. Cal has roughly 38 students. The school in Sacramento has 232 students, and it rivals an ABA school. Other schools do as well. Now moving to the unaccredited, they pose and provide another opportunity. So I indicated earlier, the type of students that they're teaching and the kind of curriculum they're offering has changed profoundly. Where 10 years ago, probably 90% of the students were attending fixed facility, that reversed, and the number of schools of fixed facility has shrunk and will continue to shrink. For example, the committee just in December, upon request, terminated the registration of 2 unaccredited school, fixed facility school, one fixed facility and one school. Mainly, they just weren't, enrolling anybody. There was a school in Ridgecrest after 5 years that never grown more than 3 or 4 students. So the marketplace plays an important factor in this, but we keep a close eye. All of these schools are inspected regularly on the CALS level. I have to mention, we go in on a 2.5-day inspection along with a committee member who I know from history. I find the experience very rewarding and interesting. Many of them have never set foot on a CALS, so this is a new experience for them. I go in and have done and visited every one of these schools, and a number of them twice. What we did for the unaccredited was sort of mimic that on a lesser scale. We now, for the unaccredited, and there's a list you'll see by type there in the handouts. And the unaccredited fixed facility, you'll see where they're located, and they're an interesting group. Online schools have changed dramatically in quality and in regards to who they are. One of the examples is, for instance, recently, some of you may have read this, Purdue University in Indiana just acquired one of the larger online law schools here in California, Concord Law School, which was among the leaders in online legal education. Another law school, St. Francis School of Law, has been acquired by Baker College, which is a very large university in Michigan that has both online programs and fixed facility programs. And so with that, the development of their curriculum, the platform, the technology, of course, has improved dramatically in the last 10 years. So the quality of education you can get online has improved dramatically. As Dean Brandis, who's in the audience, will tell you that there's quality education online, as there is good and bad education online, as there is in a fixed facility classroom. It really depends on who the school is hiring for purposes of faculty, and more importantly, who are they able to attract as students. And the better online programs have very strict and higher standards of admissions than the law allows. They're taking people only with BA degrees or graduate degree. In just the last couple minutes that I have, I'd just like to make a few more points. The history of, as I mentioned, with the Dunn bill, has changed dramatically with regard to the committee's oversight authority, and that oversight will change and this is the last point with the future. The proposal that, of course, the schools and I and others were quite pleased that the board enthusiastically, if I can use that word, adopted, was the proposal to seek legislative changes and changes at the Supreme Court, allowing the committee to accredit online education and require the accreditation of currently all fixed facility schools. And we have schools that are motivated to do just that, and they will proceed. But that will do a lot to improve legal education, strengthen education. The last point I'll make is California, for decades, and now more so than ever, has led the nation, in my belief, in non-ABA legal education, moving it toward both affordability and effectiveness, diversity, as I said over and over again. And online education now is working its way into the CALS. We now have a school that has a hybrid JD program that's been approved, and they're going to roll that out in the fall. Monterey College of Law has a pending request to the committee to do the same. So the ABA, I'll be frank, is, I think, a little behind the curve when it comes to allowing schools to experiment and move online education into their curriculum. The committee and working with the deans, I think, have effectively moved farther and faster than the ABA is. And the reason for that is these schools are small, more nimble, and they're not tied by tenured faculty teaching in a fixed facility environment that often is very resistant to make the kind of changes that the marketplace needs, the profession needs. And with that, I'll stop and take any questions if anybody has. I can see I'm passionate about what I had to talk about.
I have a question, George. Do we anticipate any increase in tuition costs for the unaccredited as they move over to accredited?
Well, that's a good question, and there may be the sense that they're to improve. I mean, for instance, in the accredited world, with the deans, we now have, the board approved, we have accreditation standard mandating 6 units of practical skills training. And they have to offer 15 units of practical skills training. Some of the, most of the online schools aren't doing that, or even the fixed facility. So to seek accreditation, they'd have to establish that they meet those standards. So yes, they would probably have to hire either more or frankly better faculty than they may have at the moment. So there would be, the rules and guidelines for the unaccredited schools closely mirror the accredited with a few exceptions. So the cost could go up, but again, it's equality. I mean, what I say to the schools is, two things. Accreditation means something. I mean, we work hard, and when a school becomes and stays accredited, it's expected to meet these standards and continue to improve. And the 40% rule, which is probably the primary barrier to any of these unaccredited schools to get there, because historically they've had very low passage rates. But even at the CALS level, we're already seeing, and I knew this would happen, and that metric is important because every student, any of the CALS admit, they have to look, and they know where their numbers is. You can go to our website, and we're going to update that in July. We don't present them for the ABA schools, but we have our list of unaccredited, of CAL accredited, cumulative bar pass rate. So every dean, every admissions officer at the CALS knows, every student that they admit, what are their odds of passing the bar 4 years from today? So they know they need to strengthen and continue to improve their curriculum, their academic support. They have to raise their admission standards in a tough environment where all law schools are struggling to get the best qualified students that they can. So that's the environment that the unaccredited, including the online schools, would need to go to. And I'm pleased to say that the schools, in my mind, and I know them all well, the unaccredited, are already working toward achieving that goal because they believe that in the near future, 4 or 5 years from now perhaps, it's an existential concern. They know they will not, if the law changes, be able to stay and enroll students, and most of them are for-profit, so they're there trying to make money. Because they know now that they're never going to get to that level. And that's why we've had 4 or 5 schools in just the past 2 years basically say we know handwriting's on the wall, we know where we'll be, and there's just no money in it for them to stay open any longer than that.
An ABA school closed, isn't that right?
Whittier.
What ABA school?
Well, Whittier is about is teaching out. Yeah, Whittier.
And there's one in another state.
Yes.
Charlotte.
Oh, that's right. Yeah, that's correct. Well, thank you so. I'm sorry, sir.
I had a question. You said that these unaccredited, or a number of the unaccredited, are for profit. And when I look at the last page, you've got Macmillan Academy of Law and San Francisco International. I guess they're not making much profit because they got 0 students.
Well, you raise an interesting point, Mr. Fox, and that's another example of why moving forward requiring accreditation is that under the old rules and under the Bureau, for instance, a school could and did and has been able to stay open and literally have no students. And that school had a notice of non-compliance issued, and it will be on the committee's agenda next week. But we don't have the authority to close that school. I mean, what I forced him to do is make sure that if he has a student walking the door tomorrow, that all the materials, everything is compliant. And I was, frankly, that's, to be honest, how I've been able to talk some of these schools into closing, because it's an expensive process to be inspected. It's $5,000. And it's a safe bet if I go in and I find a lot of things out of compliance to stay. So people say, I'm not going to spend the money. They walk away. Mr. McMillan, to perhaps his credit, has chosen not to, and he wants to stay in business. But he can, but we hope only for the foreseeable future if the law changes. And the other school just opened, and that's another speech I give. I get calls, at least 2 or 3 times a month for people saying, I'd like to open a law school. And no one will know how many schools people I've talked to and convinced them that opening yet another unaccredited school in California is just not really good. I should have kept track of that metric. Yes, sir.
The ABA schools are responding to the diminished market for their services by expanding their product lines. And they're selling degrees to foreign law students, and they're selling degrees to people who are in related professions that can benefit from legal knowledge but never went to JD. I'm wondering if the Cal-accrediteds and unaccrediteds are responding similarly, and if so, whether that's within our regulatory scope or whether that's outside our reach.
Well, with regard to what they're offering, the committee has jurisdiction over their JD program. And like the ABA, we have an acquiescence standard. That is, if they want to offer an LLM program or Masters of Legal Science, if they establish that it won't literally do no harm to the JD program, or more often than not, provide new resources to strengthen the JD program, the committee grants the acquiescence. So some schools have done that to try to increase enrollment and revenue. More likely, the more successful CALs seem to be working, and we have another branch campus application pending next Friday that will be interesting, because the existing school out in the East Bay, Pleasant Hill, is affiliated, JFK is affiliated with a national university, is looking to open a branch campus in San Jose. Well, there's an existing San Jose CALS that's been there for quite a while. So they're growing geographically. They're trying to expand and bring in students in a broader geographic sense to increase enrollment. And I want to believe that it is improving that's why the bar pass rate and having it publicly made known. I like to think quality sells, and people in a very transparent legal market can go online, and particularly the ABA schools, you can get all that information, and we're trying to do as much as we can to provide all that consumer information with regard to the cumulative pass rate and like so. It remains to be seen what more they can do, but that's what they've been doing over the last 2 or 3 years. And the good news is, I think all schools, is that it may be the enrollment issue has sort of bottomed out, and there seems to be it's either plateaued or it's just moving up very incrementally.
Great, thanks so much. Just a question for staff. We had wanted to accelerate the date on which the Committee of Bar Examiners has a majority of non-market participants by filling a vacancy with a judge. How are we doing on selling that opportunity to our bench officers?
Well, we haven't started yet. We are continuing to work with the court on the protocol, and I believe that we have finished that. And so once that's formally approved, we will begin our advertising process.
Because our admissions function generally implicates our desire to regulate for the protection of the public, to make sure that people who are admitted to the bar are fit for that role. But also has to be balanced with our access to justice commitment, which is to produce enough people in that role to meet the needs of Californians. And striking that balance is a delicate task that implicates antitrust concerns, and therefore establishing a majority of non-market participants on CDE is good public policy and good risk management. So we will keep an eye on that development. Who's next? Is it time for lunch, or do we have another speaker?
It is time to break for lunch. We are scheduled to come back at 12:30 when the Office of Chief Trial Counsel will begin the discipline system part of the training day.
And do they need us to come back promptly at 12:30, or can they spot us until 12:45?
They can spot us until 12:35. We have a very tight day today.
No training lawyers. 12:35 it is.
I informed all staff that I was going to be ruthless when it came to time, and so I need to exercise that same rule with the board.
So folks who might be listening remotely, you're in adjournment until 12:35. Thank you for holding that for good questions. Okay, welcome back, folks. We finished being educated about our admission functions, and we're about to learn about our regulation and discipline function. Mr. Moab, please start.
Thank you very much. In anticipation of this presentation, I went back through old discipline day presentations, and I saw lots of PowerPoint slides filled with statistics, numbers of complaints received, numbers of calls to a hotline, complaints forwarded to investigation, number of reportable actions, number of conviction monitoring cases, etc. I noted that you all receive monthly RAD reports, statistical reports about the discipline system. And in a few months, you will have the annual discipline report. I assumed that you didn't need another 2 hours of me reading statistics off of a PowerPoint slide to you.
In fact, you could do it for a couple of minutes and it would feel like 2 hours.
During the Chief Trial Counsel recruitment process, and throughout my time at the bar, I have given a lot of thought as to how to best demonstrate the significance of what we do. I've spoken to many members of the Office of Chief Trial Counsel about what statistics show whether we are doing a good job or not. I've come to at least a tentative conclusion that the best way to convey how necessary and important this work is to tell stories about the cases that we handle. So that is what we have planned for you today. We hope to demonstrate how the discipline system works by talking about a few of the cases we've handled recently and, frankly, a few of the processes that we've instituted. I want to thank all of the Office of Chief Trial Counsel participants in the presentation, and I particularly want to thank Assistant Chief Trial Counsel Mia Ellis and Deputy Trial Counsel Catherine Kinsey for their dedication in planning and organizing this presentation for you. With that, I'll turn it over to Anthony Garcia.
Thank you, Steve. I'm Anthony Garcia. I work for the Office of Chief Trial Counsel. And I'm
closer to the mic, I think.
Thank you. And I'm a supervising attorney for Office of Chief Trial Counsel. I had a team up we call it Trial Team 3, 4 attorneys, about 6 investigators, and a couple of secretaries and an additional support staff, including paralegal. I want to talk to you today about the expedited cases process that Steve has instituted. Before I start, you have a chart in front of you of the discipline process. And so I'd like to start with a "you are here." And if you go across right under complaint, the word complaint, there's a number 3. And in the dark box right below number 3, it says the State Bar will assign your complaint for investigation. That's where we're starting today. After a case has gone through intake, it goes to be assigned to the investigation. The investigations are assigned by supervising attorneys, like me. The supervising attorneys generally have years of experience and have years of trial experience. And head up teams, I think there's 8 teams in LA and maybe 4 or 5 teams in San Francisco, comprised similarly to mine. I'll start by talking to you about how a regular investigation gets started. The supervising attorneys assign the complaint to members of their team. They assign it to an investigator and a legal advisor. And the regular path is, after a complaint has been assigned, the investigator does what's called an investigation plan, which is basically issue spotting. What issues are involved here? After that's been prepared and approved by the legal advisor, then a letter is sent to the attorney. The letter is sent to the attorney advising of the complaints against him and asking for a response. The attorneys have about 10 days to respond. And if you're familiar with the attorney process, if you give an attorney 10 days to respond to something, the first thing he's going to say is, may I have another 10 days? Or 20, right? So the process to get something back involves 10 to 30 days. Then the investigation proceeds. And at that juncture, I'm going to jump off to the expedited cases, because this is where the expedited cases differ. In an expedited case, the supervising attorney, in my case it's me, I headed up the expedited teams for a while, looks at as I assign the cases, I review them, and I see the ones that have simple, like sole issues, 1 or 2 things that can be dealt with relatively quickly, in my estimation. And so then I assign those cases what we call a code, processing code, the EXP code. And those cases then, I'm assigning them to another team, to the same process, to a team, an investigator and a legal advisor. The investigator then has the option to waive the investigative plan, because they don't need a lot of time spotting issues, because oftentimes, as the supervising attorney, I've basically spotted the issue for them, or, with a quick note. We know it's a single issue. The investigator can also waive, and frequently does, waive the letter to the attorney. And instead of sending a letter to the attorney requesting a response, they will make a phone call, they'll send an email, they'll use a more direct communication process. They'll let the attorney know, we have this issue, we'd like an answer, or we need a document, or something more direct than sending a letter out and waiting for a response. And those two steps can save days, if not months, on the investigative process. What we have found in these cases that we've looked at is the responses from the attorneys, whether they be during an interview or in a response to an email, are often sufficient to help us determine what has to be done with the case, how to resolve it. Then the investigator will interview the client. He may receive evidence, catalog the evidence, and head the case towards resolution. And it is, in fact, a very expedited process, but no steps are skipped. I think that's important to know. We're not skipping steps. We're not skipping important steps. We're just resolving things in a more efficient way. Finally, when a case is resolved, the investigator will write a disposition memo explaining what happened and how the cases have been resolved. So far this year, we have handled 137 cases in this expedited process. Of those, 100 of them are closed, 37 are still open, and the average age of the 100 cases that were closed is 85 days from opening to closing. And that's quite good. It's actually a very good number for us to look at. In order to explain how this works a little bit better, I think I'd like to talk to you about a couple of cases that we worked on. One of them, we received a complaint from a client, and the client complained that the attorney abandoned her case and just left her high and dry. It's a med-mal case, so it was a very important case to her. I reviewed the file, and I saw, as I reviewed it, that there was what we call a drop letter in the file. In other words, the attorney wrote to the client and said, I'm not able to continue with your case. I saw also in the drop letter that he noted the statute of limitations, the date the statute of limitations ran. The drop letter was dated in June, and the statute of limitations was in October, which is probably, and he advised the client, if you want to continue with your complaint, with your claim, you need to get an attorney. When I saw that, it appeared to me that there wasn't much merit to this. The attorney didn't just abandon her case, he closed the case, gave her notice of the statute of limitations, and did it in writing. So, it looked to me more like this was a client. We really had to discuss this with the client. We didn't understand her complaint at that point. I marked this as expedited. The investigator called the client, and she was really just upset with the results of some surgery she had. She got really bad results, and we told her, when we contacted her, the statute had still not run. There was still time for her to hire an attorney. And she said, no, I'm not going to do that. I don't want to hire an attorney. She didn't say this, but she was just upset. She needed to talk to somebody. So the investigator talked to her for some time. He also contacted the attorney to see what other steps he had taken, if any, to notify the client that he wasn't taking the case and of the pending statute of limitation date. And we found that he had called her before he sent the letter. He'd spoken to her. He sent the letter. And after our call, he sent her another email reminding her that there's a date coming up. If you want counsel, you need to hire counsel quickly. Right? So we thought that everything had been done here. We didn't see that it was practicable to go forward on this complaint. There was really no violation. So we closed it. This particular case was open, I reviewed it, on September 8th, and it was resolved by November 14th. A relatively short, pretty much in line with the timelines we discussed. And what this allows our investigators to do, and what this process has allowed our office to do, is by expediting the process on some of these cases that we can see don't need the full investigative process, it frees the investigation to spend more time on the cases that really need deeper digging, if you will. If I can talk about Yeah, I'll talk quickly about one more case. We got a complaint from an incarcerated client who said, my attorney owes me money. He said, I've been trying to get my money back from my attorney, and he won't respond to me. I reviewed that complaint too. And I knowing that this is a fairly common complaint, I sent an email before I even assigned it to the attorney. Said, by the way, we've got a complaint from a client of yours, and he needs an accounting and a refund of unearned fees, if any. He sent me an email back right away saying, I really don't remember that client, files are in storage, I'll get right back to you. Then I assigned it to the investigator and handed the email and the whole file off to the investigator. The investigator continued on that path. The attorney wrote back, said he found the file, and the investigator said, well, do you owe him money? Let's figure this out. The attorney prepared what's called an accounting, showing the hours he worked, deducted them from the money he'd been paid, and discovered that he owed the client $375. And promised to get it right to him. But he said, I don't know where to send it. So the investigator in his next process called the client, asked the client, said the attorney has some money, he owes you money, he's prepared to send it to you, where should he send it? The client, of course, was incarcerated, so he spoke to the client's wife. The client's wife said, you can send it to me. The investigator said, let me confirm that with the client, and he had the wife contact the client and told him to send us a letter, so he was okay to give the money to the wife. That happened. About a week later, we got a letter from the client saying, please just send the money to my wife. The investigator then contacted the attorney, gave him the address, the money was sent. He contacted about a week later the client's wife to make sure the money was received. The money was received, and we closed that case with a warning letter. Why a warning letter? It's on your chart, it says, if there's grounds for, if the investigation finds evidence of a violation, we can close with a warning letter. And in that case, we sent a warning letter. We found in our investigation that the attorney disputed having any prior requests for unearned fees. And the attorney's dispute, and the client didn't have any proof of making requests. So that's kind of a he said, she said on whether there was any request for fees. However, we were able to, we determined that the attorney should have done that accounting at the termination of his representation. And by not doing it, he violated his duties as client. And in that case, in an isolated incident like that, and a warning letter was the appropriate resolution. That case was resolved, that was about 4.5 weeks from beginning to end. And so we closed out with a warning letter. So those are the two cases I brought to illustrate how the expedited process actually works in our office. Are there any questions? Hearing none, thank you.
Thank you, Anthony. Good afternoon, my name is Mia El.
You're going to need a mic.
Turn it on, push the button. Good afternoon, I'm Mia Ellis.
You're going to need the mic a little closer.
There you go. There you go.
Good afternoon.
Goldilocks.
Good afternoon, I'm Mia Ellis, Assistant Chief Trial Counsel with the Office of Chief Trial Counsel. Next, we have a presentation from Senior Trial Counsel Kimberly Anderson and Investigator Joy Nunley on the case of James Schooler. The Schooler matter is an example of one of our more complex matters investigated and prosecuted by our office.
Good afternoon. Is it right there? Thanks. Higher technology. Good afternoon. When Ms. Schooler's mother died in the year 2004, she took over as the executor of her mother's estate and the trustee of 2 family trusts. She and her 4 other siblings were all beneficiaries of the trust. Ms. Schooler was accused by her 3 brothers and their attorney of breaching her fiduciary duties as trustee and executor of her parents' multi-million-dollar estate and trust.
If you're not speaking, please turn off your mic. We're getting a little feedback.
Between 2004 and 2011, over a period of 7 years, Ms. Schooler was refusing to distribute assets from the estate and the 2 trusts. She wouldn't provide any accounting to her brothers and their attorneys, and she was not cooperating in handling the main asset of this family estate and trust system, which was a multi-million-dollar beach house located in the prime area of Del Mar that all the siblings wanted. The trust also contained some other property, mostly consisting of numerous parcels of undeveloped land in Nevada and California.
In the probate court, the three brothers, through their counsel, filed 2 safe harbor petitions and motions challenging Ms. Schooler's actions, seeking to have her removed as trustee and executor. Since Ms. Schooler threatened that they would be disinherited if they violated the no contest provision in the wills and trusts, they had to file these safe harbor petitions to ask the court permission to challenge Ms. Schooler's their contentions that she was breaching her fiduciary duties to them. These proceedings were all related and coordinated to a pending probate case filed by Ms. Schooler to probate the will. So all told, there were 3 separate actions in the state probate court. The probate court ultimately found in favor of the brothers and ordered Ms. Schooler to pay sanctions. The court also removed Ms. Schooler as trustee and appointed a successor trustee, which really annoyed her, and ordered Ms. Schooler to turn over documents to the successor trustee and pay rent at the fair market value to the successor trustee on the Del Mar Beach House, which she was living in at the time rent-free. Ms. Schooler violated every one of these orders.
During the investigation, it became evident fairly
You need to
quickly.
be closer to your mic.
During the investigation, it became evident fairly quickly that this was going to be a rather complex and time-consuming case, mainly because of the amount of documents that would be needed to be obtained, the various courts that were involved, and Ms. Schooler's continuing actions to violate all those court orders against her. We discovered that not only was she violating multiple court orders, she was continuing to assert to third parties and the court that she was still in a position of authority over the estate and the trusts. She also grant deeded the beach house to herself and her sister, a sister who was only passively involved in the whole case. So this just added to the whole process. The successor trustee ended up filing an unlawful detainer action against Ms. Schooler and obtained a judgment evicting her from the beach house. And this set off another round of problems with her violating court orders. During the investigation, this was a situation where the statements and documents were obtained, and when reviewing those statements and documents, then we determined, well, we need even more statements and documents. And then looking at those, even more statements and documents. It was an ongoing pattern of getting more, getting more, getting more. Some of the things that I did during the case, first off, is I reviewed the complaint and contacted the complainant to clarify some issues and get some additional information. Once I got that additional information, issued a subpoena to the county clerk's office for information relating to the beach house. And because there were the 3 separate cases in probate court, we issued subpoenas to the court in each of those 3 cases for documents. We also issued a subpoena for documents relating to the unlawful detainer action. When we received those documents, I did what I do anytime we receive files, is I reviewed them, cataloged them, marked areas of interest in the case, in the cases, each one of them, where we might want to follow up, and if we needed more documents, which we did end up doing. At that time, I then received some additional information from the complainant, and based on receiving that additional information and all the documents from the court, I sent a letter to Ms. Schooler requesting she respond to the matter and give us her response, an explanation. I received a response from her probably a couple of weeks later, but it had no substantive content, and she just kept saying, I have appeals pending and I'll respond to you after the appeals are done, which didn't help us. At that point, I'm going on with the case. We contacted the court reporter to get a hearing transcript of the probate court trial in which she was removed as the trustee, had additional contact with the complainant to confirm some more details, and also contacted the successor trustees council regarding Ms. Schooler continuing, even at that point after receiving the letter from the State Bar, to hold herself out as a position in authority over the trust and the estate. This caused additional subpoenas to all of the various courts that we, at that point, or various court cases we were aware of at that point. I did actually speak to Ms. Schooler once on the telephone. She really didn't answer anything. I was asking her, can you give me a better response? Can you give me documents to support your response? She says, okay, but that really didn't happen. Due to information that we had found in the subsequent set of court documents, I sent her another letter saying, we still need a response on from the first letter I sent you, and now I'd like for you to also explain, you know, you've been sanctioned and you have not paid these sanctions. She was sanctioned by the probate court. So she responded via email, or rather via several emails, but all she did was attach copies of court documents, which we already had. She didn't give a response. At that point, I obtained a box full of trial exhibits, and I do mean a large-sized box. Trial exhibits and the exhibit list used in the probate court trial to remove Ms. Schooler as the trustee. At that point, Kim and I, we discussed the case, and it was determined at that point I could prepare my investigative report that would include all of the documents and statements and material that I had obtained so far. The report ended up being 1,573 pages long, or in total, the report and all of the attachments. The case then went to Kim to handle, and because of statements that Ms. Schooler made to Kim, it was decided that further investigation was needed. So I contacted the court reporter to get additional transcripts relating to her removal and other things that had happened in the court. Issued even more subpoenas for her ongoing conduct of continuing to claim to be in charge of the estate. I conducted Lexus searches on the 2 Nevada properties that were part of the assets of the estate, because Ms. Schooler was trying to claim control of those 2 properties as the personal representative of the estate, and issued then subpoenas to the Court of Appeals. Let's find out where these were found. Received those records, found out she'd filed something else, so I had to issue another subpoena. And it come to find out that between 2009 and 2016, Ms. Schooler filed 28 appeals and or writs in the 4th District Court of Appeals alone. She lost each and every one. Finally, we issued a subpoena to the mortgage holder on the beach house, because Ms. Schooler was asserting, oh, while I was living there, I was paying the monthly mortgage. When we got the records, which was another box or so, which covered several months of time, we found that there were numerous default notices inside, and the house actually went into a default.
And if you think Joy had a difficult time in the, technology. If you think Joy had a difficult time with the investigation, you can imagine getting a disciplinary matter filed into trial, and completing the trial in this matter was a bear. From our perspective as state bar prosecutors, there's this double-edged sword when you have an attorney like this who's representing themselves. She's going to keep going with the vexatious litigation, and she's going to say appeals are pending and I can't deal with you, State Bar, until after the appeals are done, which will be never. And so at some point you have to cut it off and file something and get it going. But then, so you can't wait, because if you wait, the misconduct you'll never bring it to light. So it's figuring out when is enough and then going on it. Ms. Schooler's repeated pattern of frivolous appeals worked to delay the disciplinary trial. For instance, at one point, Ms. Schooler represented to the court in a motion to abate, which is like a motion to stay, over our objections that a pending appeal would be dispositive of at least some of the issues in our case. Well, of course, you can guess she lost the appeal and then claimed it wasn't dispositive at all. It was somewhat helpful to us, but she did persuade the judge over our objection to delay the trial. At one point, because of all of the frivolous appeals being filed, Ms. Schooler got sanctioned by the Court of Appeal. Actually, several times she got sanctioned, and we had to decide whether or not to amend our notice of disciplinary charges to charge her with 6068C violations for filing unjust actions and frivolous appeals. We ultimately did decide to do that because one of the challenges for our office when you prosecute a lawyer who's acting not in a legal capacity, she's the beneficiary and the trustee with her siblings, and it's not your garden variety kind of dishonesty case or misappropriation case in the practice of law. Sometimes the state bar court is not inclined to disbar an attorney like that, particularly where they've been in practice many years with no prior discipline. So we ultimately decided to amend our NDC, notice of disciplinary charges, to also charge her with a bunch of the frivolous appeals. And the trial in this matter took over 10 days, and that's a court trial, not a jury trial. There was no jury selection. We didn't do opening statements or closing arguments in this case. It was all done with a pretrial statement explaining to the court what the case was about and a very large closing trial brief explaining all the law in this area. Ms. Schooler testified alone for 5 days. One of the challenges when you defend a case or when you prosecute a case against an in pro per respondent, you might think it's easier than dealing with an attorney on the other side. In state bar court, not so much. I see Mr. Stevens shaking her head. In state bar court, not so much because these respondents are not practiced in trial procedures. They don't follow the court's orders, trial setting orders regarding entering into stipulations and stipulating to exhibits and properly subpoenaing witnesses and things like that. And Ms. Schooler had lived with this case from 2004 till the day of our trial when her case was still going on in 2015. So she knew all of the ins and outs of all of these cases. And I never practiced probate or trust law. I'm a jack of all trades, master of none. So she came in and she was actually, I think I had underestimated her, she was very good at spinning a story that sounded plausible, except for the fact of the court records. Our trial exhibits were 8 volumes in this case, and I turned Joy's work into 3,700 plus pages. That's just the documents admitted at trial that we decided to use. And all of that was to show the court that, yes, what she's saying may sound plausible unless you compare it against the court records, which doesn't add up. Let's see what else I wanted to tell you guys. She put on her own lawyers from the underlying case who testified to a certain extent in her favor, but not completely, that they had advised her that some of her actions were okay. We put on an expert witness in estate planning, wills and trusts, and probate to indicate that no, her actions were not okay. Finally, on June 28, 2017, more than 5 years after we received the bar complaint, Ms. Schooler was disbarred. Initially, we went to trial, and the hearing department gave her a 2-year actual suspension, finding that while her conduct was very serious, and finding all of her misconduct, by the way, as well as several very significant aggravating factors, the state bar court hearing judge felt that disbarment was neither necessary nor appropriate. I guess this was a family dispute with a dysfunctional family over an estate. We appealed the hearing judge's discipline recommendation, and the review department found that Ms. Schooler also had committed all of the charged misconduct and all of the significant aggravation, as did the hearing judge. But then the review department agreed with us that she had to be disbarred on this case. All told, the court found that she breached her fiduciary duties under the terms of the trust to equitably distribute the assets to the named beneficiaries for a period of 7 years, at which time she was finally removed as the trustee. She distributed almost none of the assets of the multi-million-dollar estate. She was living in a Del Mar beach house rent-free. She failed to pay taxes on raw land. She failed to pay the mortgage on the beach house. And she, in aggravation, the court found substantial harm to the sibling beneficiaries who had not received the full distributions of their estate, and substantial loss of millions of dollars to the trust corpus. There were 2 trusts here, there were 2. After she was removed as trustee, she continued to make misrepresentations to courts and filed frivolous actions. She was indifferent toward rectification or atonement of the consequences, blaming nearly everybody for what happened. And the court found, because this was multiple, extremely serious misconduct over a 7-year time period, they had no choice but to disbar her. Following our success in the review department, we filed a request for publication because there are unique factors about this case. And it's important that we get published decisions like this, because we can then point the hearing judges to a case and say, on these facts, even though she's not practicing law, she's inactive, and she's been a lawyer for many years, she still needs to be disbarred based on the severity of this case and the aggravation. And thank you very much for your time. We'll take any questions if you have any.
Is it a matter of public record on a complaint like this, the source of the complaint, or is the source of the complaint kept confidential?
During the investigation, the complaint itself and the source would be confidential, except to write to the parties involved. And then after we file the case, it becomes public record.
And so I'm guessing that this complaint might have initiated with the siblings and not with a bench officer, but I was curious if there were a bench officer who was the source of the complaint.
It's a great question. There was a bench officer, and in the trial, he directed the siblings' attorney to file the complaint with the state bar, which we sometimes do see. Bench officers, I think in the other courts, don't necessarily always want to get involved. They want to. I think they're reluctant to report attorneys who are going to be continuing to appear in front of them. So.
Yeah, we would like to encourage the bench officers to be a greater source of opportunities for us to protect the public. And I know Steve is in dialogue with the California Judges Association about that. When we conclude a case like this, where there's at least one and probably several members of our judiciary who are intimately familiar with the misconduct that you spent years learning about, is there any feedback loop? Do we let them know that the case was resolved and how it was resolved? Or do we rely on them to read the discipline summaries in the Daily Journal?
That's a great question, and I think it depends on how the case comes in. In this case, because the complaining witness was the attorney for the brothers, we would write to that attorney and tell them about it. I believe the successor trustee sort of became like a quasi-complaining witness. As Joy mentioned, she interviewed the successor trustees counsel, and we may have reported it to them. We don't go back to the judge and report it to the judge unless the judge is a complaining witness, as I understand it. And when we do get judge complaints or judicial complaints, the judge can elect whether they want to be a complaining witness or whether they just want to report it and have it be a state bar investigation. If it's the former, we do send the judge a closing letter.
I'd encourage Steve and Rebecca to give some thought. I know you've got a lot on your plate, and staffing up your organization and protecting Californians is job number one. But to the extent resources allow, we might want to give some thought to whether we can improve the flow of information back to the bench, even when the bench officers have not been nominally the complaining party. Because I think if the bench officers start to hear what comes of our justice system, they may be more willing to participate in it. But thank you. Are there other questions from the trustees? Thanks for your report.
Thank you very much.
Thank you.
Thank you. In addition to state bar initiated actions in state bar court, as discussed in the Schooler matter, our office also monitors attorneys' conviction and ultimately the prosecution if the matter is referred to our office by the review department. To describe the monitoring process and the prosecution of those cases, we have supervising attorney Susan Kitchen from our San Francisco office.
Welcome.
Thank you. Good afternoon. Hello. I'm here to talk about conviction monitoring and the prosecution of those conviction cases. So the first question is, how does the state bar find out if an attorney has been convicted? And there are several different ways that we actually find this information. The first is there are statutory requirements for certain parties that they have to report to us. One party is the court. If there's a conviction of an attorney, the court is required to report that to the state bar. Prosecutors' offices also have a duty if there is a felony or misdemeanor that is filed against the attorney, they're required to report to the state bar. They know the person is an attorney. And then the member also has reporting requirements. And those are to report to us if there is an indictment or information for a felony that's brought against them, or a conviction for a felony or misdemeanor that's committed within the practice of law. Those are the statutory reporting requirements. But we also find out about these cases in different ways. One is just the news or regular media. So one of us will be reading the paper and we'll see about an attorney that was convicted that we didn't know about, and we'll notify the Office of Intake, Department of Intake, and they'll open up a case. Other ways we find out from independent sources, sometimes we get anonymous tips, and we'll open up a case there. As well as the fact that when we are investigating a case, sometimes we will uncover it during the investigation. And when we find that out, we'll open a case. So those are the many ways that we actually find out about the convictions. Now the process, when we do, what do we do with it? So we have a team. They are spread in the San Francisco and Los Angeles office. Right now, sorry, I misspoke. They were spread. Now they're all in San Francisco. And the team consists of 3 paralegals and 1 appellate attorney. And essentially, the team at any given time is tracking approximately 300 cases in our inventory. So approximately 100 cases per paralegal is active at any given time. Just so you know, these cases don't count toward backlog. Okay, so what happens when we receive a report of a conviction? Well, first of all, not all the time. We also receive reports sometimes for arrests that they don't necessarily result in convictions. But when we do get a report of an arrest, what we do is we open a file and we monitor it to see if there's a result. If there's no result, if the charges aren't filed or the arrest, it doesn't result in charges, then we will close the case. If, however, there is a conviction, then we will open a case. If there are actual charges filed that we know about, then we will open up what we call a C case. It's a conviction case. And essentially what happens is once we open it up, the paralegal will contact the courts, contact the district attorney's office, and try to obtain status updates. And approximately on a monthly basis, they'll try to obtain a status update on the case to find out what's going on, whether or not the conviction is final. So there is one additional piece at that point, and that is if there's a conviction that is a guilty plea or a no-lo plea where the court accepts the plea for a felony or misdemeanor that is moral turpitude per se, and there's a definition for what that means, then we will transmit that conviction to the review department, and the review department will then issue an order putting that member on interim suspension until the conviction is final. Once the conviction is final, then we would proceed with our regular process. But that's the one piece where they would be put on interim suspension and not entitled to practice law. Okay, so once the conviction is final, what happens is that we transmit what's called a transmittal to the review department. And in the transmittal, it contains certified records of the criminal complaint, the relevant minute orders, the plea and the order accepting the plea, the notice of lack of appeal. And in some cases, when we don't have formal finality, the respondent can actually waive finality. And we would transmit that. So then, the review department reviews the transmittal and then issues an order referring the case to the hearing department to determine whether the facts and circumstances surrounding the conviction involve moral turpitude or other misconduct warranting discipline. And if so, what discipline should be imposed. So, as you can tell, that's a very important phrase that we all abide by, whether or not there's moral turpitude, and if not, is there other misconduct in this that would warrant discipline. So when the hearing department receives that, what they'll do is issue a notice of hearing on conviction and a notice of an initial status conference. And at that point, it's before the hearing department on the trial schedule, and an attorney in our office will actually be assigned to handle the prosecution. So how do we prosecute these cases? Well, they are generally expedited. Generally, at the time that we receive the transmittal and all the paperwork, all there is the police report and the records from the conviction. So we actually, in most instances, ask for an investigator to be assigned so we can actually investigate the case and do our own investigation into, by interviewing witnesses. We would obtain whatever evidence we can obtain. And at that point, we would determine whether or not we need experts. Now, the reason why this is so important is because the conviction alone, the record of conviction alone, does not help us in identifying whether or not there's moral turpitude in the case. And the reason why that's so important is because a moral turpitude finding will affect the level of discipline. If there's a moral turpitude finding, then the level of discipline goes up exponentially from a regular case that doesn't have moral turpitude and it's just other misconduct warranting discipline. So that is why we can't just rely on the record of hearing on conviction. And I'm going to talk about two cases where that actually illustrates the point that it is really important for us to do these investigations, do a thorough investigation, and do them very quickly, because we generally only have about 120 days from the notice of hearing on conviction being filed in the hearing department to put on our case. So I don't know how many of you are familiar with the Wyatt or Guillory cases out of our office, but okay. So the Wyatt and Guillory cases are two recent cases that came out of our office. In both cases, we did a full investigation and presented witnesses and evidence at trial in addition to the record of hearing and conviction. Because in both cases, the record of hearing and conviction did not tell the whole story. And it was impossible to tell, just based on the papers, whether or not moral turpitude was involved. So let's talk about Wyatt. Now, I have to just give you the caveat, I didn't handle either of these cases, but my illustrious colleagues did, and they did a fantastic job in handling them. In the Wyatt case, the respondent hit a pedestrian while he was intoxicated and killed the pedestrian. He was charged and ultimately pled to a violation of Penal Code Section 191.5b, which is felony vehicular manslaughter while intoxicated without gross negligence. So that doesn't tell the whole story. These are the facts. The respondent lived in an adult community. I don't know how many of you know about Rossmore. It's outside of Walnut Creek in Northern California. He was at his home and he drank vodka. And then he drove to dinner and had a beer. On his way home, he hit an 85-year-old man who was waiting for the bus, the adult community bus, to come and pick him up. He hit him so hard that the victim landed on the windshield and broke the windshield and then was thrown about 40 feet. The victim landed in the middle of the street and was bleeding profusely from his head. The respondent got out of the car, checked on the victim, but he didn't have his cell phone. So he drove back to the guard gate and told the security guard what had happened. The security guard said, "Wait here, I'll call the ambulance, I'll call the police." In the meantime, the respondent drank a lot of coffee and water while he was waiting. So at the time that the police showed up, they interviewed the respondent. And the respondent had only mentioned drinking the beer at dinner. He did not mention the vodka he drank beforehand. In addition to that, he described the victim as having streaked in front of his car and gave him no opportunity to swerve. The victim was, I believe, 85 years old and walked with a cane. That was the first story that he told. When they conducted the field sobriety test on him at the scene, he failed miserably. And they also noticed that he just appeared to have been under the influence based on his physical appearance. When they tested his blood alcohol concentration, it was 0.18, more than double the legal limit. So more than one beer for sure. In a later interview a few days later with police, the respondent admitted to drinking a finger or two of vodka, just a finger or two. In the state bar trial, he denied how much vodka he drank, claiming that it was less than 3 ounces. However, we were able to introduce the blood alcohol content chart from the DMV and showed that if the respondent was telling the truth about how much he drank, his blood alcohol content would have only been 0.05%, not 1.18. So at the trial, we called police officers, we called a neighbor who cared for the victim, or saw the victim on the ground and was there caring for the victim. Also a bus driver who did the same, and friends of the victim to show that he was a good person and would be missed. So at the end of trial, the court found that the facts and circumstances surrounding the crime involved moral turpitude and recommended disbarment. Basically, the decision was based on the fact of all the surrounding circumstances, the fact that he drove. As I said, his decision to drive was not a close call. His conduct demonstrated a reckless willingness to disregard the safety of others and break the law, even knowing his actions were extremely dangerous. And they found that he lacked candor because of his testimony at the state bar trial, where he only drank a limited amount of vodka beforehand. So as you can tell, that's a really good result for our office. It's the right result, and it wouldn't have happened if we didn't do a full investigation and put on evidence of witnesses at trial. So let's talk about Guillory next, and this will be very brief. So the Guillory case on its face does not seem that egregious. He had 4 misdemeanor convictions for driving under the influence. Okay, and that was over approximately 13-year period. So the difference, though, is that when we put on the evidence, it showed that there was more to the story. So the first conviction occurred when he was still in law school, and he was driving his cousin home from a party and hit a parked bus. His cousin was killed. At the time, his blood alcohol content was 0.06 at the time of testing, and he was actually pled to a wet reckless, so it's not technically a DUI. But this was pre-admission, and he went to his informal conference before the Committee of Bar Examiners because they flagged this as an issue for his admission, and he promised he would never drink again. Okay. So then he gets admitted, and he becomes a district attorney, first in San Bernardino County, and then in San Francisco County, and lo and behold, he's prosecuting DUI cases. But he still continues to have his own. So the attorney was convicted a second time. That second time, he had blood alcohol content of 0.18. Then he gets convicted again, and he lied to police officers at that time, arrested again, lied to police officers at that time, stating he only had 1 glass of wine, and was permitted to drive to work on a suspended license. His blood alcohol content in that case was 0.15. And in the fourth conviction, he first told police that he had not been drinking, but then admitted to having 2 beers. Let me just bring this a little bit to light. Okay. He fell asleep at the wheel of his car in traffic, and because he was passed out. So it wasn't just that he was driving, he was incapacitated. His BAC was 0.24. And then the other thing to think about with these is that in each of these cases, he tried to badge the officers, which is basically he tried to get leniency by showing them that he was a DA. Come on, don't discipline me or prosecute me. I'm a DA. So at trial, we called police officers from all 4 cases. We called a toxicologist to prove how much the respondent actually drank, as opposed to what he told the police officers. We called an expert from Mothers Against Drunk Driving, who testified about how societal norms have changed since the 1990s when the courts last dealt with DUIs and state bar matters. And the court ultimately found moral turpitude in this case and imposed a 2-year actual suspension with a requirement that the respondent prove rehabilitation before he's returned to active practice. Any questions?
Very quickly, so the court found moral turpitude, let's just say in the last incident.
Yeah.
If they had not found moral turpitude, would there still have been some disciplinary action taken against the attorney simply for having the 4 DUIs?
Yes. Really, the moral turpitude finding goes to the level of discipline. So in that case, in a regular case, if there are 4 DUIs, we would anticipate we would receive discipline, but not as much. Any other questions? Thank you.
Thank you, Susan. Thank you, Susan. So we're going to change gears here. As you're aware, when an attorney is disbarred or resigns with charges pending, an attorney has to petition to the State Bar Court to be reinstated to the practice of law. We have Susan, we're going to keep Susan Kagan here, and she is joined by investigator Tom Mills, who will describe the investigation process as well as the challenges of investigating those cases and prosecuting them. And they will use the case of In the Matter of Maximilian J.B. Hopkins as an example.
Hello again. So, reinstatement cases. Essentially, 5 years after an attorney has been disbarred or has resigned from the bar with charges pending, they're permitted to file a petition to be reinstated as a member of the bar. There are some requirements that they must fulfill before they can file their petition, and the first being they have to provide us with fingerprints, they have to pay all of their prior disciplinary costs, and they have to pay a filing fee. In these cases, the burden is on the petitioner to prove by clear and convincing evidence 4 things. 1, that they pass the bar. 2, that they pass the MPRE. 3, that they are rehabilitated from their past misconduct. And 4, that they have present moral qualifications for reinstatement. So once the attorney does file that petition, then our investigation period starts. And it's a very limited period. We only have 120 days to investigate these cases from the filing. So what will happen?
What's the source of that time limit? Is it statutory or is it our rules?
It's by the rules. Rules of procedure.
And do you think, does your office have an opinion whether that rule that it bears revisiting?
I'm not sure. I can't speak for the office, but I would say we do.
Hanging, and we'll let the folks further the flagpole choose when and if they wish to take it up.
Thank you. So within that 120 days, then the investigator will conduct an investigation, and Tom will talk about that in just one moment. But after the investigation period ends, then we only have 10 days for our office to file a response to the petition, which basically sets forth our position. Then we have 15 days to conduct discovery, 45 days to take a deposition, and then we go right to trial, because trial is generally set from the filing of the petition about 5 or 6 months out. So it is expedited. So now Tom will talk about the burden and general investigation techniques.
Yes, as far as the time goes, we could use more time if you guys can get some for us. We used to have an extra 120 days of discovery on top of the investigation period, and that went away some years back when the rules were changed. And it actually gave us the ability to do something meaningful with discovery and with the investigation. In these cases, we're dealing with people that have proven themselves to be unworthy, and they tend to hide the ball and lie and cheat and steal. And one of the most important differences between these and other cases is that they initiate when they're filed by the petitioner. And we have no knowledge that they're going to do this, it just happens. And we've got 120 days, not counting weekends and holidays, to put together an investigation. And a lot of this involves what I think of as cold case material. We may have attorneys that were disbarred 20 years ago that are coming back and have had a period of 20 years where they're out in the world doing things, working, living, sometimes lying, cheating, and stealing as a continuation of what they did before. And so our investigation is focused on Basically, it's a massive background investigation of what this individual was doing and how accurate and truthful their petition for reinstatement is.
Let me just comment. I'll wait for management to decide when to bring this issue forward, but my own perspective on it is that I want management to have the flexibility to apply our resources effectively to protect Californians. And if you're hemmed in by rules that might make sense in the abstract but not in a particular case, or rules that haven't been looked at in a while and no longer make sense in the abstract, I'd like to free your hands to manage your resources better. So I'll just leave it that way, and we'll bring this back when the organization is ready to think about this in public.
Sounds great, thanks. Anyway, as far as the burden on the petitioner with these cases, the burden does lie with them to prove they're rehabilitated. It's a very high burden. And the truth is that we would probably win a majority of these cases by simply doing nothing, by just holding the hoops for them to jump through, so to speak, to prove their case. And the Hopkins case that we're going to talk about is a good example of why we don't do that. If we were to do that, we may win in today's case, but the judge would set them up for a return in the future with a decision that says something to the effect of, you know, Mr. Hopkins is on the right path, he just needs more time, blah, blah, blah. What my goal is, and what our goal is, the office is to find the truth of what this individual, what their makeup is, if they've actually rehabilitated or if they haven't, and if they haven't, to what degree they haven't. And my goal is to find the truth as best I can and as quickly as I can. To do that, we have various techniques. Like I said, in the petition, they have to disclose a great deal about their activities. They have to disclose their family members, their marital status, their address history, whether or not they rent from people, how much they pay for rent, their employment, their self-employment, any debts they may owe, judgments and liens, bankruptcies, and they have to lay all these cards out on the table. Our investigation is designed to figure out whether they told the truth or not, and we have databases to search, to do that, and various means of doing that. I won't go into it because we don't have time, but essentially we're casting very wide nets and pulling them back in and seeing if what they told us is the truth. And usually within a few days we have a pretty good idea of whether they've disclosed the things they ought to have disclosed, like lawsuits, bankruptcies, are big ones that are often left out. Most of the time when something's not disclosed, there's a motive behind it. Sometimes it's just an error. Most times it's not, and that was the case with Mr. Hopkins, and which is why it's actually a very good illustration. It wasn't the sexiest case in the office as far as the misconduct. It was pretty run-of-the-mill, but it covers a lot of bases because we caught Mr. Hopkins continuing to practice law, for instance, and other things that we'll get into in a little bit. But basically, we subpoena a lot of records. We obtain court records. Any case that's disclosed, any civil case that's disclosed, we get that. Any cases that aren't disclosed, we obtain that. Excuse me, we obtain that. We have their tax records. We'll contact witnesses and shop social media sites to see what we find there, and all to get an idea of whether this person's rehabilitated, whether they're telling us the truth in their petition. One of the biggest things in the petition that I find, the first thing I go and read, is the narrative statement that they give about their rehabilitation. In Mr. Hopkins' case, it was about a paragraph long, and essentially he said, I'm okay, I've gone through lab and everything's dandy. Most people, especially ones that are putting together a very good petition, will go back and explain the reasons why. They explain the misconduct, they fall on their sword, they provide some sort of explanation as to why they did what they did, and then they offer up the reasons how they fixed themselves and why it will never occur again.
So I just want to give you a little background on the Hopkins case, which I did handle to some extent. So Mr. Hopkins was disbarred for committing misconduct in 3 different cases. The most egregious misconduct he committed was stealing $69,000 from one client that had funds, community property funds, in his client trust account. Not only did he steal the money, but to conceal the misconduct, he issued false billing statements to the client stating that he maintained all the funds in his account except for authorized withdrawals. During the State Bar investigation, he provided copies of 10 client trust account checks to us, claiming they were used in connection with the client's case. However, they were not. Only 2 of those checks were actually used for the client. The other 8 were falsified. So When we were prosecuting this case, the petitioner blamed his wife for the misappropriations, claiming he was negligent in failing to closely monitor her bookkeeping duties. He's still married to her. And the court ultimately found that the petitioner intended to mislead the State Bar by falsely representing that those client trust account checks were issued in connection with the client's case. He lacked credibility and disbarred him. So then he filed his petition. Initially, he filed a petition in 2015 and then withdrew that. But during that petition, you actually conducted a small investigation.
Yeah, and he filed 2 petitions. The first was in 2015, and it was short-lived. It was probably less than 15 days because he realized very quickly, I think trial counsel at the time informed him that he had a fatal flaw. He hadn't paid the client security fund, and he hadn't paid his disciplinary costs, which are a prerequisite to filing, and he apparently didn't have the ability to pay that. So he withdrew, but in the short time that we had it, I had run a few searches, and I very quickly saw that there was a number of things he hadn't disclosed, and we had basically a roadmap to the investigation to follow. And a couple of those things, what the investigation revealed is that from the non-disclosures, for instance, he didn't disclose 3 lawsuits. There were 2 lawsuits involving his home residence, which had been foreclosed on. He lost in the foreclosure, and they were being evicted. He filed a bankruptcy. It was the second bankruptcy he filed, one a couple of years before. And he filed the bankruptcy for an improper purpose, just to delay the foreclosure and the eviction. And in that bankruptcy, he made misrepresentations under penalty of perjury that he hadn't filed bankruptcies before and some other things. So there was a pattern to why he didn't disclose these lawsuits and the bankruptcy. He also didn't disclose a great deal of employment, and once we got a little further into the reasons why he didn't disclose the employment, it became apparent why he didn't disclose that either. And because essentially he was continuing to practice law without a license. And one of the ways we got into this, I like to say, and I recognize cases from last year where I gave a similar talk about this, that investigatively we're like stray cats that return to the houses that we know that feed them. When we see a bankruptcy, I get excited because I suspect there might be assets that aren't disclosed. If I see undisclosed lawsuits, I think there's probably a reason for it. In this case, one of the houses that I returned to was our own complaint system, and I run the petitioner as a complainant in the system, see if they complain about anybody. And in this case, Mr. Hopkins had complained about another attorney, and that uncovered a situation where he was essentially practicing law in a roundabout way by striking a deal and actually having a contract with a client to provide paralegal services. In the contract, it said that he can't practice law, but the contract was an end run around that where he would actually practice law. And so we uncovered that one client. There was also another complaint that had come in from an individual who ran into him at the courthouse, in the street in front of the courthouse, as a matter of fact. And he had been representing himself in pro per, was a non-attorney. And Mr. Hopkins had approached him and offered to represent him for a fee. And that individual stopped cooperating with the State Bar. We believed that he had been either paid off or scared off. And at any rate, that gave us an insight into what Mr. Hopkins was likely doing. With that information, we subpoenaed bank accounts of Mr. Hopkins and a business that he had set up, a corporate entity that he was using to commit this unauthorized practice of law. And the return from the subpoena was a gold mine because in his own personal account and the account for this corporate entity were dozens of checks for legal fees, attorney fees, and so forth. There's more to the story, but I see that we're almost out of time. And I love handling these cases, and I can talk about them forever. I think it's a good idea to present this material to you guys in the way of stories because it's fun to tell the stories, but it's also illustrative of, it's better than sitting here and telling you what I do and how I do it, just without the real life application.
So
Anyway.
I just wanted to quickly tell you the results. So Mr. Hopkins came in for a deposition. This is before actually the case went to trial. He saw the mound of evidence that we had, and he immediately said, I'm going to withdraw my petition. And so ultimately, he didn't go forward with trial, and that was really the best result. It saved a lot of resources, judicial resources and time, because we did such a strong investigation. We were able to do that and get a great result. And one other thing I just wanted to say was that the investigation doesn't end in these cases. It goes all the way through the investigation period. We're still tracking down stuff during discovery, and even at trial, Tom is like busily working to try and find out other information we can find about the petitioner. Yes?
I have a question. When you've discovered an attorney that's been disbarred is continuing to practice through your investigation, say, do you refer that to district attorney's office?
We do. There were a couple of other cases that I've handled in the last few years where we referred for bankruptcy fraud to the U.S. trustee, and those individuals were prosecuted and actually recently pled and were sentenced. So.
Yes.
About the 120-day time frame we've had, when does that begin to run?
It begins the day that the petition's filed with the State Bar Court.
So if I understand, the attorney who wants to now be reinstated would file a petition, is that right? And I think you said, I mentioned among the prerequisites was, in addition to being disbarred for 5 years, that they would have to take the bar exam.
Yes.
And pass the bar exam, right?
Yes.
Do they have to get any permission from the bar in any sense in order to take the bar exam again?
Not that I'm aware of.
So they can just take the bar exam. You don't have any notice at that point that you have an attorney who has been previously disbarred who is now taking the bar exam?
We don't. Sometimes I'll get a heads up from the folks in the client security fund because of the requirement that the disbarred attorney reimburse the fund. And I'll get a call from a friend there saying so-and-so is inquiring about how much they owe, which is usually a tip-off that that person might be filing in the future. But it would be improper of us to initiate an investigation before we actually had a case filed.
Right, I get that, but at least
we know.
If you knew, you'd have a 6-month window roughly to say, hey, this guy might be coming up, we might have to do an investigation.
Well, something that I didn't mention, and I don't know if Mia's going to get mad at me because I'm taking too much time, but these investigations aren't just limited to the period of disbarment. Oftentimes somebody's disbarred and they're disbarred on this amount of evidence and misconduct, but really behind that is a heck of a lot more. And it's important to me and to the court to know the extent of the misconduct. Is the greater the period of misconduct, or the more serious the misconduct, the higher the bar is. So if I've got an attorney that was disbarred for stealing client funds in 2006, but he had been disciplined going back in time, or there were cases still pending, I'm going to investigate those cases as well as sort of a bar-raising exercise to be able to show the court this is who he was, and this is who he's claiming to be today. So it's not just limited to that point in time, which further cuts into our period of investigation.
Thank you.
Thank you.
Not surprising, due to the nature of the work that we do, OCTC often sees the consequences of when an attorney is unable to practice law and oversee their law practice. And oftentimes, we see the harm that causes their clients. In an effort to educate the members, in 2017, Senior Trial Counsel Murray Greenberg and Brooke Schaefer wrote an article for the Los Angeles Lawyer magazine addressing the steps OCTC and the Superior Court take when no succession plan is in place, and advising members of the procedures to take to place their practice in place, and so they can protect their clients. We distributed a copy of that article, and next presentation we will have the case involves a petition that the Office of Chief Trial Counsel filed to seek jurisdiction following the attorney's abandonment of their law practice. This matter was handled by DTC Deputy Trial Counsel Jennifer Kishimizu-Penny and Investigator Rosemary Almaguer.
Thank you, Mia. I'm Deputy Trial Counsel Jennifer Kishimizu-Penny, and here with me is Rosemary Almaguer. And together we worked on the assumption of jurisdiction over the law practice of Robert Yousefian. And this was a unique case because it appears that the inability of Mr. Yosefian to continue with his law practice stemmed from an unforeseeable circumstance. And it really underscores the importance of why attorneys should put into place some sort of succession plan or closing procedures for when the circumstance may arise in the event that they are unable to continue representing their clients. So in situations where a plan is not put into place, Business and Professions Code section 6180 and 6190 allow the Superior Court to assume jurisdiction over an attorney's law practice in order to protect the interests of clients in any unfinished matters. And when the attorney is unable to continue his law practice due to death, disability, incapacity, or some other inability to act. So in the Yosefian matter, we filed a petition in the Burbank Superior Court under section 6190 based on the fact that he had abandoned his law practice, based on evidence that we had acquired through our state bar investigation. And I'll let Rosemary go into some of what she discovered.
Hello, I'm Rosemary Almaguer, and I investigated this matter, which started out as a routine standard complaint by a client who had reported that the attorney failed to communicate and that the client had gone out to the attorney's office only to find it closed during business hours. He'd gone repeatedly. As time went on, I received more complaints from different clients. A number of clients had contacted me and I interviewed them. They reported that they had found the attorney wandering about the area of his office, and they observed that there was a significant change in the attorney. While the attorney was usually a very well-groomed, well-dressed individual who wore a suit and tie every day, they noticed that there was a significant change in his appearance and his demeanor. He now looked, as one client described him, he looked like he was a homeless person. His clothes were rumpled, he looked unbathed, he wore long straggly hair and beard, and he appeared distracted. When one client asked about his case, Mr. Yosefian responded to find another attorney because he didn't feel well enough to continue on his case. In fact, the attorney complained to him that he hadn't eaten in a few days, and the client bought him a meal. I had also, during this time, sent letters out to Mr. Yosefian, but I received no response. At that point, I determined to go out to do a site visit to Mr. Yosefian's office. When I got there, I found that the sheriff had posted a notice to vacate on the office door, and the lockout date was scheduled for a few days later. I also, while I was there, I contacted an office neighbor who had her own separate business, and she also shared some observations with me. She also noticed that there was a dramatic change in Mr. Yosefian, and also in his appearance and his demeanor. She also stated that the attorney was unkempt, he was ungroomed, his clothes were rumpled, and he appeared distracted, he was not characteristically himself, and she observed there must be something serious going on. I also contacted the landlord, and a few days later, we agreed to meet at the attorney's office. When we got there, we were greeted by a mound of unopened mail, which was underneath the mail drop behind the door. When we entered the office, the attorney and I discovered that Mr. Yosefian was breaking into the office through a fire escape in the roof. The hatch of the roof was still open. We also observed that the attorney had assembled a makeshift bed from office chairs. He had lined them up in a row so that he could have somewhere to sleep. There were also various items of clothing throughout the office. We also found that the attorney was doing makeshift laundry with drinking water that he had carried into the office. We found there were large containers of clothing soaking in water. We also observed that the attorney had large quantities of balsamic vinegar and olive oil, as well as gastric medications that he had stacked very neatly against the wall and on the desk. We also found in the pantry area, there was a mound of bank cards, including credit cards, debit cards, and his bar card was even in that stack. Amongst eating utensils, paper plates, and there were also client checks just randomly there in the pantry area by the eating utensils. We found that throughout the office there were client files. Many of them were in file cabinets and they were organized. There were other files that were throughout the office, just in no particular manner. They were randomly about on desks, on tables, in the pantry area, in the reception area. There was also unopened mail. There were checks that weren't associated with any particular file. I also noted that I recognized many of the names of the clients that I had spoken to over the phone. So with that information, I came back to the office. I shared this information with Jennifer, and we coordinated a plan of action.
So, based on Rosemary's investigation, we decided to proceed by way of petitioning the Superior Court under Section 6190. And in order to do that, we must establish that there at least is one unfinished client matter and that no other attorney would be willing to resume or assume responsibility for that client matter, and that the interests of one or more clients would be prejudiced if we did not proceed to act. So based on Rosemary's investigation, we proceeded with preparing the pleadings to file in the Superior Court, which included the ex parte petition and application, declarations from myself as well as Rosemary, and declarations from the abandoned clients, proposed permanent orders, and importantly, the interim orders, which allow the State Bar to act as an agent of the Superior Court to carry out the necessary duties to close down the practice. And that includes orders to seize all client matters, reroute telephone lines to the State Bar, forward any mail to the State Bar, and freeze any and all bank accounts associated with the law practice. So prior to closing down the practice, there's a lot of coordination that happens here. There's an operation plan meeting in which our team consisted of 7 attorneys and investigators got together. We coordinated the schedule of events that would happen on the day of the assumption. The investigators coordinated the moving trucks as well as the empty boxes that we would need in order to pack everything up. We had contingency plans in place. The nearest law enforcement agency, in the event that Mr. Yosefian was actually at his law office on the day of the assumption. The nearest hospital in the event that there is a medical emergency that may have arisen. And we contacted Central Administration and General Services to coordinate the return of the moving truck when we would come back and what time, so that they would be prepared to unload the boxes here at the State Bar. So on the day of the assumption, Rosemary and I went to the Burbank Superior Court and filed the pleadings and obtained the interim court order. And upon the signing of the court order by the judge, Rosemary and I returned to the law office of Mr. Yosefian, where we met up with the investigators that were stationed there with the moving truck and the boxes. We also met up with the landlord who unlocked the door for us. We provided him with a copy of the interim order. At that point in time, we did a walkthrough of the law office and went through each room systematically, and we looked through files, documents that may pertain to client matters. And like Rosemary said, he was relatively organized. We were able to separate active files from closed files. And then there were also other files that were just in offices that we gathered together. And we documented and photographed the condition of the law office as we went in prior to seizing any of the documents. And we also, at the end, documented the condition of the office as we left it. So at the end, we collected, here are the notes from Mr. Yosefian's client matters, which appear to be organized, like Rosemary said, and seemed consistent with some sort of indication of some sort of life event that may have prevented him from continuing his law practice. So at the end, we collected 134 boxes of documents and 5 computers and brought them back to the State Bar offices here. We served notices on the telephone company advising them to forward the phone line to State Bar line, forward all mail to the State Bar, and to freeze any and all bank accounts. At the end, we also posted a notice on the door outside of Mr. Yosefian's office advising the public that the law practice is now closed, and provided the State Bar contact information should the public have any questions. So the current status of our investigation is still ongoing. We have now obtained a permanent order from the Superior Court, which allows us to proceed with filing the petition in State Bar Court for the involuntary inactive status of Mr. Yosefian. We are going through the process of identifying and returning any and all client files. We've subpoenaed the client trust account records, and we'll be doing accounting and reconciling client trust accounts. We've also notified clients regarding the availability of client trust or client security funds in the event that it is needed. And Rosemary has contacted Mr. Yosefian's family and advised them that should Mr. Yosefian ever contact them, that the State Bar has resources available to him to assist him in this time. So seemingly this was, an unfortunate circumstance that, and the assumption of Mr. Yosefian's practice could have been avoided should he have put into place some sort of contingency plan or succession plan or closing plan for his practice.
The 2 questions occur to me. One is, how do these cases come to your attention? How do you learn of the need to protect the public in this way? And the second question is, does the consequence of an order allowing you to assume a practice also lead to the disbarment of the attorney or the suspension of the attorney, or is that a separate process that normally follows as well?
So the first part of your question, I think, as Rosemary touched on, it came in as a regular investigation. We had no idea that this would lead to an assumption matter. It's usually clients are unable to contact their attorneys, communications are not being returned, phone calls, emails are not being returned. And so based on that, the fact that there was a number of clients, similar clients situated in this case, Rosemary decided to do a site visit, and that's when she learned and discovered more pressingly that this would turn into an assumption matter.
So it presents itself as a discipline case, and you learn that it's not.
Correct.
You learn that it's something else.
Correct.
Got it.
And the second part of your question, it certainly may lead to disciplinary action at this point in time. It's kind of early to tell in this case, but there are procedures in place that would be a separate disciplinary proceeding.
And I assume there's an opportunity for somebody who's in this circumstance to voluntarily take inactive status.
Absolutely, yes.
And are you occasionally in the need to refer these candidates to another state agency which can serve to conserve that person? Do you occasionally find people who need that sort of assistance from society?
There are circumstances that may arise where there is a conservator in place. In this circumstance, Mr. Yosefian did not have that.
Right, he wasn't a good practice law, but he could take care of himself and wasn't a threat to others except as a lawyer.
What does the State Bar do with like an attorney that passes away that has an estate planning, like a vault of old wills and trust? Back in the day, I know the State Bar took those. Is that still the practice for deceased or non-practicing estate planners that have wills and trusts that belong to folks?
I do know that there is a proceeding under 6180.
It's a similar type process. And we do work with the estate in situations like that. But it's a similar process where we would oftentimes go into Superior Court. But it varies. It depends on the situation.
So if an attorney passes away, does the State Bar get those wills? Does like the family of the deceased attorney then turn them over to the State Bar?
Well, those wills, to my understanding, we actually turn those over to the court. Those are original documents. You're talking about of clients.
Right, who aren't necessarily dead. We don't know where they are.
Right. And we actually have another presenter who will address that. But those files are usually, we do turn those over to the court.
Thank you.
What happened to Mr. Yusefi?
What was that?
What happened to Mr. Yusefi?
We have no idea at this point. We don't
had
know.
an attorney in our area who developed Alzheimer's, and he behaved very much like what you described. And he was a Stanford grad, brilliant attorney, and all of a sudden we started seeing him chasing squirrels in the courthouse park. And eventually, the attorneys, we all sort of came together trying to help him out. It reminded me of Mr. Yusefi, of what had happened. So I just wondered what happened, poor guy.
We did reach out to the family members we were able to contact through our sleuthing. They did report that he will randomly go to their house to visit, but that's very random. But we did reach out and we offered services. We asked Mr. Yusefian to contact us, and we would help him get resources to assist him.
I think that's great. I was thinking something similar, Mark, and Michael and I were having a little sidebar. But also, I was thinking this when we heard of the earlier case, one of the drinking cases. And I was thinking about our public protection mission in this context, and if it is truly limited to the licensing issue, and have we protected the public if we disbarred, for example, or suspended? Or in these situations, is there a broader public protection purpose that we have when we're looking at situations where people can go out and put the public at risk in different ways other than through as an attorney? And that gets to sort of questions I think that we have yet to really grapple with about our role in rehabilitation. So even if somebody is not going to practice law again, or not going to practice law for some time, do we have a role or a responsibility in the area of rehabilitation? And it's just an interesting question for me. I'm not sure what the right answer is, but it's interesting. So we took care of the legal part, and it's great that we reached out to the family and tried to make that connection.
Next, we have two attorneys, Supervising Attorney Manuel Jimenez and Senior Trial Counsel Elizabeth Stein from our team dedicated to investigating the unauthorized practice of law by non-attorneys, and when necessary, seek Superior Court assumption of jurisdiction over the law practice. Also, we are distributing a handout describing more in detail the team as well as the statutes involved.
Good afternoon, my name is Manuel Jimenez. Good afternoon, my name is Manuel Jimenez, and I've had an opportunity to see some of these presentations today, and I have to say that this is not hypothetical. You just heard about assumption of jurisdiction. Tomorrow I'll be in San Joaquin Superior Court getting a final order on an assumption. You heard about the Hopkins matter. I tried the case, it got disbarred. And I'll be in trial next week on a reinstatement matter. So I personify the work of the state. But let me go to the real important stuff here. I appreciate the opportunity to showcase the work of the non-attorney unauthorized practice of law team. There's a dedicated team. I've been with the state bar for 13 years, and prior to that I was a prosecutor. I've been in charge of the NAUPL team since April of 2017. And with me is one of the stars of the NAUPL team, the non-attorney, unauthorized practice of law team, Elizabeth Stein, who has gone above and beyond this last year and done some of our greatest work. Everybody's done a lot of great work. I'm going to briefly discuss today the function of the NAUPL team, the tools for doing our work, discuss the challenges that we face, and also some of the creative engagement that we engage in communities. Elizabeth, Ms. Stein, is going to be talking about assumption matters, in particular, the assumption matters she handled this last year that got a lot of attention. Let me say that during my tenure with the non-attorney unauthorized practice of law team, it has been a period of transition and evolution. We are continuously striving to improve what we do, adapt, because oftentimes the victims of unauthorized law practitioners are vulnerable victims of our communities. Those people in the country without authorization to be here are often victimized. They don't speak the language, and they are preyed upon. So that makes our mission particularly important. We don't have all the tools. We can't disbar people who are not barred in the first place, so we have creative solutions that we do take. But we do have some powers, and we'll discuss those now. And I'm supposed to be handling this, and let me see if I can do this correctly. That's the other way. All right. Here we go. The NAUPL team has a dedicated staff, presently of 13 persons, attorneys, investigators, support staff, paralegals, to deal with this issue. You heard a little bit earlier that we have a complaint process that has different languages, and that's true. For the NAUPL team, for those persons that have been victimized by persons who are not practitioners, you can file a complaint online in English, Spanish, Korean, Chinese, Vietnamese, Russian, and we have a multilingual complaint line, telephone line you can also call. We also get complaints from, obviously complainants, judges, law enforcement, and other attorneys, and we have a kind of a good relationship with law enforcement, and not only do we receive complaints from them on cases, but we refer cases to law enforcement. And almost every case that comes in before us, we make a referral almost immediately because we're worried about statute of limitations issues regarding Business and Professions Code 6126, which makes it a crime to practice when you're not authorized. We also work with law enforcement. We actually go out into the community and different agencies and try to form relationships. And as I said before, one of our most powerful tools is the assumption of jurisdiction for NAUPL practitioners, which is different from the one you just heard, the 6180. Our authority stems from 6126.3, 6126.7, and various statutes like that. So what are we looking for? Business and Professions Code 6126 basically lays out what we're looking for. Those persons who are not entitled, who are holding themselves out to practice law, or entitled to practice law, or actually practicing law. That's who we're looking for. And that is challenging. Why is it challenging? Because often, like I said before, some of the people who are victimized are from communities who don't trust government agencies. They're afraid to come forward, so getting people to come forward and cooperate is one of our issues. We have to have evidence of recent or ongoing unauthorized practice of law. If it's stale, it makes it more problematic because oftentimes these practitioners, and I'm using the term practitioner, it gives a bit of a legitimacy that it shouldn't have. These criminals basically are they'll move offices and associate with different people. We have to prove that there was a legal service rendered. You know, there are law-like vocations out there, legal document assistance. In some counties you have unlawful detainer assistance, you have immigration consultants that are authorized by statute not to practice law, but to give services that appear to be law-like. So making a determination whether there was an unauthorized practice of law is one of our things that we do. And proving there's no licensed attorney involved. Of course, you know, paralegals often do in law firms law-like work, you know, drafting pleadings, doing that sort of thing. We have to ensure that when somebody makes a complaint about somebody, that they're not working under the direction of an attorney. Those are some of the challenges that we work with, and there are others, of course. What does the unauthorized practice of law look like in the real world? I'll get to that in just a minute. But before I do that, let me just discuss what we do when a complaint comes in. Complaint comes in one way or the other. We give an attorney immediately to review the complaint. They're reviewing it for two reasons. One, is there an allegation of the unauthorized practice of law by a non-attorney practitioner? If there's no such allegation, that's problematic for us. And also the merits, an initial review of the merits. If we can't see that there's evidence of misconduct, then we're going to have to do a little more digging. So what happens is that these complaints come in, they're reviewed, they get assigned to a legal advisor who's an attorney and an investigator. And these investigators on the NAUPL team go out to the field, and they go out to the field often. And this photograph you're looking at right now is a law office, allegedly, except for there's no lawyer. At the time this picture was taken, there was no lawyer involved. This person operated a law office, in quotes again, scare quotes, that dealt with tickets. You know, he wanted to help you fight your tickets. One of our attorneys, I believe it was Lee Kern, and Hugo Gonzalez Val, the investigator, went out to the office, and then subsequently had a conversation with the owner of this office and said, gave him kind of, an education in the unauthorized practice of law. That was on August 1st of 2017, and by September 1st of 2017, he associated an attorney in to his office. Does that mean that we didn't pursue it further? No, we sent out a law enforcement referral because his conduct was misconduct and against the law. But hopefully that mitigated some of the damage that may have been done. Here's another investigator went out into the field again and dealt with an individual who had many corporate entities, one of which being Global Investment and Development. But if you see in the background, she also had TD Global Immigration Service, and she actually practiced adoption law and immigration law, which was interesting. Complaints came in regarding those subject matters. Our investigator went out, had a conversation with staff there, said, hey, I'd like to talk to your attorney. The staff said, well, we do have an attorney, but they just didn't happen to know the name of the attorney. Soon after, again, this was a senior trial counsel, Leanne Kern, and again, Hugo Gonzalez Val, that went out there, investigated and worked on this matter. Soon after the visit, and they were aware of our investigation, that office disappeared. It is no longer around. So we believe that she has moved on, but at this point, that's the effect of that. I'm going to turn it over to Ms. Stein now, who's going to talk about a case that she worked on.
Hello. Hello, my name is Elizabeth Stein. I'm a senior trial counsel on the non-attorney unauthorized practice of law unit. And earlier heard Jennifer talking about court orders to assume the jurisdiction over the law practice of an attorney who's incapacitated, dies, or just can't practice law anymore. Those orders similarly apply to non-attorneys who are engaging in the practice of law. The requirements are a little bit different in what we have to prove up to obtain the orders. Here we have to show that they were either holding themselves out as an attorney or engaging in the practice of law. But the orders task the State Bar with carrying out almost the same actions, where we seize client files, we reroute the phone lines to the State Bar, we collect their mail, we seize if there are any bank accounts. So one example where we did that was in the Eddie Bonilla matter. The Eddie Bonilla matter came to us from actually the city attorney's office. So this is a great case that shows where even if we have a hard time locating victims, because victims are sometimes reluctant to come forward on these cases, we can work with law enforcement to get the evidence needed to shut these places down. So the city attorney had actually already convicted Mr. Bonilla in this matter. They didn't know the extent of his unauthorized practice of law, but Mr. Bonilla pled guilty to one count of unauthorized practice of law early in the year. Sometime in June, they found out that he was violating his probation by still engaging in the practice of law. They had some hint that it might have been much bigger than they anticipated, so they asked us to help him out with the case, because if it did turn out to be a bigger practice, they would need to shut down his practice. So mid-June, we were notified of this, and we were told that there was a probation violation hearing happening in 2 weeks. So within a 2-week period, we got on the case. There was an investigator assigned to the matter from the State Bar, and he worked fast and diligently. He went out and conducted a site visit and saw that Mr. Bonilla, as he advertises here, advertises attorney services, but he's not an attorney. He had a law practice down on Olympic in the Curacao building. It's a very big building. His law office looked legit. There was a reception area. There was filing cabinets. There was advertisement of what legal services he offered. He also worked with the city attorney's office investigators to obtain declarations regarding what was the underlying misconduct in their criminal matter, and he obtained certification that showed that Mr. Bonilla was not an attorney. So with this information, we started up our drafting of a petition to assume jurisdiction. So similarly, like Jennifer, we prepare an operation plan, gather our team, and assess the situation to see how we're going to carry out these orders. We also plan for the ex parte hearing and the shutdown. In this case, my investigator and I brainstormed that since Mr. Bonilla had pled to the criminal conviction matter, we figured maybe he'll plead or stipulate to certain terms that will help us in our case. And certainly Mr. Bonilla did. At the probation violation hearing, I presented to the city attorney's office that for terms of probation, I would like Mr. Bonilla to stipulate to cooperate with the state bar, which would mean not opposing our petition to assume jurisdiction, and also not to move or destroy any of the client files, because we were certain that there was going to be a lot of client files. So with that, Mr. Bonilla agreed. He was violated on probation, and we got the go-ahead to go file our petition in Superior Court. So the day that we filed our petition, we had the interim order signed by the judge, and we prepared to go over. There was 2 investigators and myself who went over to shut the practice down and to take the client files, but we quickly learned that this office was a lot bigger than we had anticipated. It was really a labyrinth of offices behind the main reception desk. There was files everywhere, filing cabinets full of client files. And what we learned was that Mr. Bonilla had been in practice for 20 years. And the reason a lot of people had not come forward was because he was a pastor in a church. So he had gained not only their trust as being an immigrant, Spanish speaking, but a pastor of their church. So a lot of them were sometimes satisfied with their work, or if they weren't satisfied, they were just afraid to speak up. So it turned out we needed actually a whole team to go over and help execute the orders and gather all these client files. Ultimately, we seized over 250 boxes, and once we brought them back to our office and they were sorted through, we realized there were close to 5,000 client files that Mr. Bonilla had in his possession. We did the similar thing where we put a notice on the door saying the law office has been shut down. They can contact the state bar to get further information. We rerouted the phone lines. And just from the sign and rerouting the phone lines, within a couple months, 400 clients had called our office saying, we've been victimized by him, you might have our client files, can we get them back? So there is Mr. Robert Mason's going to be speaking further on how they inventory the files, but we do try to address those people that call in with concerns because those are the urgent matters that need handling. We let them know we can't be their lawyers and handle their client matter, but we do refer them to the lawyer referral service. Even after this case was done, the work doesn't end. We were actually asked by Univision and Telemundo to do press coverage on the case. So I was part of an interview with other nonprofits where I presented information on the Bonilla matter, gave information, the phone line where people, if they had been victimized by Mr. Bonilla, could call in, but also spread the word that the state bar handles non-attorney UPL matters and gave the general multilingual complaint line, also informed them of the online multilingual complaint form and let them know that regardless of their immigration status, they can come forward, because a lot of people think that we're going to be checking their immigration status and not helping them. But we tell them that's not a requirement, that's not something we care about. We really are here just to shut people down like this who are not attorneys, aren't engaging in the practice of law.
Just very quickly, because we're going to run out of time here, I want to emphasize that yes, we are out in the community. She did give interviews to several media sources, but we're also not just reactive, we're proactive. We monitor foreign language media for indications of NAUPL activity. We have gone out into the community. I've been out with actually Mr. Moad and other members of the team. We went down to San Diego, Fallbrook, California for an immigration seminar down there. That was run in consultation with Jesse Navarro, the Community Relations Representative for the San Diego DA's office. I spoke at the 11th Annual National Conference of Vietnamese American Attorneys about these issues. We had members of our team attend the Pathways to Citizenship workshop. Investigator Michael Chavez did that on behalf of our team. And we're presently working on trying to get into the detention facilities that hold immigrants. That's a big project of Mr. Moad, CTC Moad, and we are on the trail. I appreciate your time. Sorry to take more time than we had. Any questions? Thank you.
Thank you. Next, very briefly, we have a presentation from Senior Administrative Supervisor Robert Mason on what happens after we shut down and take over a law practice.
Thank you, Mia. Good afternoon. My name is Robert Mason. I'm the Senior Administrative Supervisor, and I oversee various central administration functions and teams in the Office of Chief Trial Counsel, one of which is the 618090 unit, which is comprised of 2 full-time coordinators of records, but we also have 6 other people and staff members that are cross-trained that can assist us with setting up files and data entry into the I-6180 database. Our number one goal during this process is simply to reunite the client with their client file that the respondent had. Before the assumption takes place, the paralegal that's assigned to the case sets up a specific phone line to where these clients can call in and leave us messages, and we can get back to them at that point. We also have to make a determination of where the inventory is going to be stored. This can be a little challenging sometimes because during the last year or so, our inventory has ranged from one box containing 11 client files to the Bonilla matter that was just mentioned that contained over 5,000 client files and took us 3 months to inventory. Determining opening matters always takes precedence during the early stages of this. The investigators and attorneys that go out and perform the assumption really play a key role in this. Taking the Robert Yusefian matter as an example, they identified on site 4 boxes of open matters and put them in separate boxes, and we subsequently got inquiries from these clients, and we were actually able to track every one of these client files down for these people thanks to the good work that was done on site. The attorneys and investigators also, after the inventory is received, keep us surprised of names of people that have open matters or potentially open matters, and we keep an eye out for those as well while we're performing the inventory. You know, honestly, sometimes we don't find these files ever because if the attorney was not anticipating the assumption, it might be at his home office, might be in his car, his briefcase, or whatever, but unfortunately, we do not always find them. Giving you a brief overview of what our unit does once the inventory is received, each client file is assigned its own specific client file number. The information, client information I should say, is entered into the 6180 database, and each file is then assigned to a specific box. Respondent mail that comes in afterwards is reviewed by our paralegal. It then, if appropriate, gets turned over to us and included with his business and personal documents. We also keep an eye out, and I think this is going to answer your question that you had earlier. Wills and trusts are also flagged and identified at this point, and I'll get into that a little bit more in a bit. Criminal files are also flagged and identified and stored in specific boxes because they can never be destroyed. And when we send those to the off-site facilities, we flag them at that point that they can't be destroyed. The Robert Yusefian matter is a key example of this. There was a significant amount of criminal files in this inventory. Respondents' personal documents and business documents are also identified and boxed separately. Loose documents during the inventory process is without a doubt the most time-consuming process that we have. The Carlos Negretti matter that we had about a year and a half or so ago contained literally 300 boxes of loose documents and took us several months just to inventory that. We had to do everything from rebuilding client files to just identifying contact sheets for somebody who just happened to call in. Likewise, these, like the files, are assigned a specific box and stored accordingly. At this point, notification letters are sent to the clients. They are sent in English, but we do have the capability of also adding a second language depending on the primary language of the clients. We do send these letters out in batches, so we can send an early run out for the open matters or potentially open matters. The files, we inform basically the client that we have their file and what to do, and it also provides them with that previously mentioned phone number that had been set up that they can call in. And like Elizabeth had mentioned, for the Bonilla matter alone, our staff returned 356 client phone calls for just that matter alone, which is practically a full-time job. Our authorization forms are also included in there, and the authorization form must be completed by every member that was listed as the client on the file. It's required that a copy of their driver's license be sent or acceptable form of ID. These files are sent by UPS, but if the client wishes to do so, they can make an appointment and pick them up in person. Before the termination orders are received, we continue to maintain all of these client files and honor any requests for the client files to come in. Going back to your other question, the original wills, grants, and trusts are then lodged with the appropriate court before the termination orders are received. The termination orders, whether you know or not, authorize us to destroy the client files, equipment, and other documentation. The destruction of these equipment and files is performed by an outside vendor who provides us with a certificate of destruction confirming the boxes and specific equipment has been destroyed. Once again, I'll reiterate, client files may never be destroyed. So that's a very quick overview. Anybody have any questions? Thank you.
Well, last but certainly not least, we're going to take all the time we can. We have our senior trial counsel, Brandon Teedy, who will walk us through the appeal process.
Good afternoon. My name is Brandon Teedy. I actually plan to have a senior attorney meeting type discussion with you after presenting the Mark Wenzel decision, but we've run really short on time. So let me give you an abbreviated version of the presentation that I had planned. The decision that I want to talk about is the Mark Wenzel decision, which was decided by the State Bar Court Hearing Department. And Mr. Wenzel's case was a criminal conviction referral. He pled no contest to one misdemeanor count of violating Penal Code Section 647J1, which is disorderly conduct, viewing into a bathroom by means of instrumentality with the intent to invade the privacy of the person or persons inside. Well, what did Mr. Wenzel actually do? He went to 4 Coffee Bean and Tea Leaf restaurants, and actually 3, and on 4 separate occasions, he put a video camera or recording device underneath the sink of the bathrooms, and the Coffee Bean restaurants had unisex bathrooms. He placed the video recording devices so that they would record unsuspecting victims using the toilet. And he testified at the hearing department trial that he had a sexual interest in doing so, and that he had deliberately planned to place the devices in the restrooms. And there was also evidence that he had surreptitiously recorded his wife without her permission and her best friend. During the trial, Respondents' Counsel asked the hearing department judge that Mr. Wenzel's misconduct did not involve moral turpitude. That was one of the 2 issues that was involved in the criminal conviction referral. The first issue was whether the facts and circumstances surrounding the misconduct involved moral turpitude or other misconduct warranting discipline. The second issue is that if the answer to that question is yes, what should the appropriate level of discipline be? OCTC's trial counsel recommended a 2-year actual suspension with compliance with former standard 1.4C2, which would have required respondent to prove rehabilitation, fitness to practice, and present learning and ability in the law. The hearing department filed a decision in which it recommended that Mr. Wenzel be actually suspended for 1 year without a requirement that he comply with former standard 1.4C2. And so the issue for OCTC was whether to seek review of that decision. And what I had planned on doing with you was going through the process of what it would have been like to decide whether to seek review. That process is the senior attorney meeting, and in the senior attorney meeting, the trial attorney, the members of the appeals team, supervising attorneys, and management talk about the case, and then arrive at a decision whether to seek review. In this particular case, the office was considering whether to seek review, and the factors in favor of review were the egregiousness of respondents' misconduct. The hearing department, for example, found that this misconduct was vile, V-I-L-E, and that it clearly undermined the public's confidence in the legal profession. In addition, the hearing department found there were two aggravating circumstances. Respondent committed multiple acts of misconduct, and he caused significant harm to the coffee bean restaurants and to one of the people who was actually victimized twice. He was a victim of two separate recordings that respondent had made. So in favor of seeking review, which would have involved seeking higher discipline, there was the egregiousness of the misconduct and the factors in aggravation. In support of the hearing department's discipline recommendation, Mr. Wenzel had impressive mitigating circumstances. He had been an attorney for 33 years without prior discipline. He entered into an extensive stipulation of facts with the State Bar, including admitting that in 2009, before these 4 incidents, he had placed a recording device in a coffee bean and tea leaf restaurant to record unsuspecting victims using the toilet. And that's something the State Bar probably would not have discovered without his admission. He called 6 good character witnesses, all of whom had outstanding reputations as trial lawyers in California, and all of them testified that they had known Mr. Wenzel for years and that he had good character despite their knowledge of what he did, and that they felt that his misconduct was an aberration. He was also very active in the American Board of Trial Advocates. He had been a former treasurer of that organization. He had written a book commemorating the 50th anniversary of the Los Angeles chapter of ABOTA, and believe it or not, he had received that organization's award for civility and professionalism before he committed the misconduct. He had volunteered at 2 food banks helping the needy, and he was the chairman of a scholarship fund at UCLA that provided scholarships to UCLA law students. Ultimately, OCTC decided to seek review. We felt that the egregiousness of the misconduct was sufficient to support an increased discipline recommendation. I briefed and argued the case to the review department, and the review department agreed that the misconduct involved moral turpitude, and he increased the level of discipline to a 2-year actual suspension with the requirement that Mr. Wenzel comply with former standard 1.4C2. And because there was no similar case that could serve as precedent, the review department designated the Wenzel opinion for publication, and so OCTC actually made new law by appealing the hearing department's decision. That is a really abbreviated version of what I had planned, but do you have any questions?
And we're circulating a copy of that opinion for you.
Thank you for your report.
And thank you very much for allowing me to appear before you today. Thank you.
Thank you. That's it for the Office of Chief Trial Counsel. Thank you so much.
Next up is our complaint review unit, which has recently been relocated from the OCTC into the Office of General Counsel. And I can just report that team inherited a substantial backlog of cases, chewed through it in about a year, and is quite current. And we're really pleased with the accomplishments of the team. Want to give them a little props as they set up for their presentation.
Thank you. My name is Carissa Andreessen, and I am an Assistant General Counsel in the Office of General Counsel. So we're going to just briefly give an overview of the complaint review process. And Essentially, what this process is going to look at is what happens to a disciplinary complaint that's been filed and hasn't resulted in disciplinary charges. So what we'll see here is that it represents just a very small part of the overall disciplinary process. I think this past year we received just under 1,000 requests for review, so much smaller than the total complaints that are received by the Office of Chief Trial Counsel. But even though it's a small part, it's an important part of the disciplinary process. So what is a second look, as it is termed? And it's essentially intended to be an independent review of closed disciplinary complaints with the intent of determining whether there are grounds to recommend a reopening of that complaint for further investigation. Essentially what it's going to provide, it's going to give the complaining witness in any particular case an opportunity to respond to or rebut the determination and the basis for closing their original complaint. Importantly, it provides a couple of different important things here. One is it serves as sort of a check and balance on the investigatory process to ensure that the decisions are closed properly and are not arbitrary. And then it also provides a mechanism for the complainant to seek review in a way that's much simpler than the alternative. And we'll discuss later on some of the other alternatives that a complainant has to seek review of the closure of a complaint. But this mechanism is a much more simple, less formal process than seeking review from the court. So as was previously mentioned, as of July 2016, this is a function that was transferred to the Office of General Counsel from OCTC itself. There was an internal audit and review unit. And that transfer essentially followed a recommendation by the state auditor that this be transferred to an independent source outside of the Office of Chief Trial Counsel. So the board recommended an amendment to Rule of Procedure 2603 that essentially accounts for three important things. The authority to review the closure of these complaints was delegated to the Office of General Counsel. This unit can only make recommendations to reopen. We don't actually reopen the cases ourselves, and that authority and discretion to actually reopen a case remains with the Chief Trial Counsel. So what does this actually look like within the Office of General Counsel? We have a small team of assistant general counsels and a dedicated administrative staff to handle the requests. The requests come directly to our office, typically in writing, and it allows the CW to present their basis for their request. So typically they'll include the grounds for their disagreement with the closing decision, new information or evidence that they think will change the determination. And sometimes it's just a general request for review. They essentially want a second opinion on the closure. And it allows them, it's a small unit, but it allows them to contact us directly. We have a dedicated phone line for the complainants to reach us with questions on the process, status updates, or if they do have substantive questions about why their matter was closed, if it remains closed within our unit. So the review itself is a full and complete review of the file for a particular matter, and we assess all the specific and credible allegations of the complainant. The standard, as is listed in the Rules of Procedure, is a case can be reopened upon a finding of significant new evidence or other good cause. And essentially, operating under the standard that no case is going to be reopened unless there's a reasonable possibility that we're going to be able to prove those charges by clear and convincing evidence. That's going to be the standard that OCTC is going to face. So when a matter does end up being reopened, it's not necessarily a determination that some misconduct has occurred. It tends to be an issue of something was missed in the process, or there's new evidence, something like that, but certainly not a determination that disciplinary charges are going to file, but just that more work needs to be done. So in reviewing these, there's essentially 3 dispositions that would occur. One is that the matter is going to remain closed. And by far, that's the majority of the ones that we receive. I think it's about 95%. And when we make the determination that the matter is going to remain closed, a letter is sent to the complainant that essentially provides a full and clear explanation of the basis for a closing decision, and then provides them information on their next step, which we'll get to in a moment, but it's essentially seeking an additional review with the California Supreme Court. In the event that there is a recommendation to reopen that's made, there's a memo that is transmitted to the Office of Chief Trial Counsel along with the file. And again, it includes the explanation or the basis for why we believe that matter should be reopened, either significant new evidence or some sort of good cause. Sure.
I'll have to talk loud because this isn't working. When you make a recommendation to reopen, do you advise the complainant?
We do. Yes, the complainant would be notified at that time that their matter is being recommended to be reopened and it's being referred over to the Office of Chief Trial Counsel. They are notified that once an investigator is assigned, assuming that it's reopened, they'll be contacted directly by that office. And similarly, you raise that point, if we do reclose a matter, we would contact the respondent, particularly in an investigation case, and let them know, we did receive this request for a review and we've determined that the matter is going to remain closed, so we do let the respondent know as well. And we do have a small subset of cases where the review is denied essentially as an untimely request. The complainant at the closure of their case in the Office of Chief Trial Counsel is informed that they have 90 calendar days to seek that review, and if their review is the request, is received beyond that time frame, it's denied as untimely. And again, they are informed of their next option, which would be to seek review with the California Supreme Court. So that review, if they do want to go to the Supreme Court and get another review of the closure of their case, they essentially file what's termed as an accusation against the attorney. So it's a Walker petition pursuant to the N. Ray Walker case, and it allows basically another review of that matter. And what the Supreme Court is, in that case, is essentially saying what they're going to look at is that the complaining witness has presented specific charges, which, if proved, would provide grounds for disciplinary action. They presented those specific charges to the California State Bar in writing and with the intent of invoking the disciplinary powers. And after receiving those, the State Bar has arbitrarily failed or refused to grant a hearing, or after that hearing has failed to take appropriate action. So that would be the standard that the Supreme Court is going to look at in making these reviews, and could, in those instances, grant their petition for review, which would, open the case up for more investigation. The good news is that for all of the accusations that have been filed, none of those petitions have been granted since 2015.
I'm not sure that's true. I noted on the most recent, or perhaps the second to most recent RAD report, that there were 2 or 3 Walker petitions this year, and I reacted to that news because it was news, and checked in with the Chief Counsel and Chief Administrator of the court to find out what it was appropriate to tell me about those petitions, and was satisfied that these were fairly routine aspects of our justice system and were not something that should come to the attention of this board as a warning sign. So I wanted to A, correct that, and B, assure the public that we protect, that we are watching this closely.
Oh yes, thank you for that. And so that's essentially just an overview of the complaint review process. And so if you have any questions.
I just wanted to say that I just got the 2017 report on the office, and it looks like 95% of the cases remain closed, and then 5% are recommended for reopening, which, given the volume, is about 50 cases, which is not insignificant. So, some interesting stats I just got.
And the productivity of this unit is remarkable, particularly given where you started, and again, we're grateful for it.
Thank you.
I have a question in regard to the 5% of the cases. Have they gone through the process far enough to know what the end result is?
I don't have that data, so I just got kind of the aggregate statistics.
Okay.
I don't know. It's something interesting that we should track over time and see what happens.
Yes.
Yeah, right now, we don't have any formal tracking of where they go. So far, any recommendation we've made has been reopened for investigation, and so they get assigned out to a separate team of investigator and trial counsel. But from that point, there's no formal tracking. Thank you.
Next, we're turning to a presentation on the State Bar Court. Judge Purcell and Tony Darling.
Tony, I think this is your first time meeting
Yes.
most of the board, isn't it?
I'll introduce myself when we get to my part.
Okay, great.
All right, well, turn it on, thank you. Is that better? Okay, thank you. Good afternoon, everyone. My name is Judge Catherine Purcell, and I'm the presiding judge of the State Bar Court. I've been with the court 10 years and 4 years in my current position. Tony Darling is we'll call the new Colin, and so in that position. And we're going to do something a little different this year. We're going to split up the presentation that is made by the State Bar Court between myself and Tony. And then when it comes to Tony's part, she's going to give an introduction of herself so that you'll get to know her a little bit, and also through the presentation. I'd like to, first of all, we're going to give you all of the statistics and the general information that we would usually give in this kind of a session. But I want to start off, because I think this year is a little bit special since it's 2018, and that is that the court was created by statute in 1988. So that makes us almost 30 years old. A very young court, actually, for 30 years old. We are the only professional attorney discipline court in the country. We are an administrative arm of the California Supreme Court, and we do independent review, as does the California Supreme Court, of all attorney discipline cases. And before 1988, as you may know, the hearings were held by volunteers and volunteer arbitrators throughout the state. And I can speak to, I feel like this year I can really speak to how much better the system that we have, our court, is that I'm president of the National Council of Lawyer Disciplinary Boards, which is a national association that works together to have education and best practices. We're the only court with a professional court. And the delays and all of the problems that come along with trying to get arbitrators and volunteers together throughout a state, a huge state, even a state like New York or Florida, proves to be very difficult and delays things. So when we attend those meetings, we feel like we're really the crown jewel because we have such a great system. And just a minor aside is that in 1986, before the court was ever born, and by the way, the court was the collective vision of the governor, the legislature, and the Supreme Court, and designed to have a better discipline system, reduce the caseload of the Supreme Court, who has cases from death penalty cases to here all the way down to every civil policy case. But in 1986, I clerked for Justice Lucas on the California Supreme Court, my first year of law school. It was a lucky duck deal because I applied to him on the federal district court, and he took all his applications to the Supreme Court, so I actually never did apply to the Supreme Court. So in the only year he was an associate justice, I worked for him, and that was before this court was in effect. And so I actually remember working on the attorney discipline cases, and there were a lot of them. So I would say to you in this special year, this 30-year anniversary, that the court has been. We didn't know how it was going to turn out. How was it going to turn out? And I would say to you, it turned out very well. We have court performance standards in the court. And those standards came about in 2004 and were made public in 2005. And essentially, the court performance standards every year are a public document on the website. This is my copy. And with the help of the National State Court Center, they were able to devise a way to look at all of our data. So in terms of transparency, what we do, how many cases we do, what our standards are for compliance, timeliness, this is all covered in the court performance standards. And the standards measures these items: access to justice, expedition and timeliness, equality, fairness and integrity, independence and accountability, and public trust and confidence. And so, as the court began in 1988, added on court performance standards, we're moving along to what I like to call a court of real excellence. I want to address this issue of judicial independence, and that is, myself having come from Superior Court, judicial independence is well established because we're the judicial branch of government, and then there's the executive branch and the legislative branch. In this particular situation we're in, kind of a sui generis situation, the name of our court is the State Bar Court, and the logo that hangs behind the court says the State Bar of California, and even it says the State Bar of California, but our slides are red, which we're very grateful for to delineate that it is the court. But I want to tell you about the independence, why it is so that we are an independent court, what establishes it, and how very important it is that we remain independent and are viewed independently. First of all, the California Rules of Court provide that all judges in our court are subject to the same discipline as and the same ethical responsibility as any judge in the state of California. Our own rules of procedure provide that the rules of disqualification, which are ethical rules, wholly apply to us as judges. And the standard for proof is clear and convincing evidence that must be proved by OCTC or the prosecutor for culpability, aggravation, and mitigation. And that standard of proof is relatively high because it is the standard used in juvenile dependency cases. And so with all of these things that are so, we are governed by the rules of court in terms of our discipline. We are governed by disqualification by the rules of court, our own rules, and we must provide a standard that we find evidence to be so before we will find culpability or would then recommend discipline. This proves the independence of the court. But maintaining that as an optic is something that's very important. It's not important so much, it's important to everyone, but it's particularly important to the public and to the respondents, because the respondents want to feel that they have had a fair trial. And sometimes just the combination of State Bar Court and the logo hanging above us, and we're in the same building, and all of those things that for all the years in Superior Court have been developed, even if you're in the same building as the DA's office, the independence has been developed over time. So it really is my goal to always express to everyone that we are a recommending court to the Supreme Court, but an independent court, independent from public opinion, independent from the prosecutors, independent court, and that is what will promote fairness, is our maintenance of independence. And so that's why I always like to raise initially that judicial independence promotes fairness, and we are an independent court. All right. The next slide is the life cycle. I think some of you that have been here have seen this slide so many times. We'll reinvent it one day. But it's sort of like a criminal case, right? There's intake, you've heard about investigation. It goes to a hearing department where there are 5 judges, I'll talk about it in a moment, and there are 3 appellate judges. And the hearing department has 3 trial judges in Los Angeles, 2 trial judges in San Francisco. And the reason that is true is because of the amount of work. About 60+% is from from Los Angeles, and the rest is from San Francisco.
In defense of our friends in the South, it's because there's more lawyers there, not because they have lower standards.
That's right. Yes, it has. It's just pure numbers. It's pure numbers, and that's just. Remember, we're a statewide organization. You know, judicial statewide organization. There's one pro tem judge. We always have one pro tem. The chief assistant court counsel is a pro tem judge in Los Angeles, but can travel. And you may know, we didn't put it on the slide, but former presiding judge Ron Stovitz is a volunteer pro bono pro tem appellate judge. So he's been volunteering his time appointed by the Supreme Court for many years when we have disqualified attorneys. In the review department, there's myself and 2 other appellate judges. and Judge Stovitz is the judge pro tem there. And we are all appointed by the California Supreme Court. And at this level is where we begin our independent review. So the trial court holds the trial, no jury of course, and we review the transcripts and we review everything independently. It goes to the Supreme Court under our recommendation, and the Supreme Court reviews it independently, and then the Supreme Court makes the decision. The presiding judge, as I said, and the review judges are all appointed by the Supreme Court. The hearing judges, 2 are appointed by the Supreme Court, one in San Francisco and one in Los Angeles. One in Los Angeles by the Speaker, one in San Francisco by the Senate Committee on Rules, and one appointed by the Governor in Los Angeles. And now we're getting to the area where we're going to talk about some numbers, some statistics on our cases, and I'd like then to introduce Tony Darling to take over.
Thank you. It's lovely to be here. At least one of you knows my long history. I started working at the State Bar while I was still in law school in San Francisco in the now gone Office of Sections and Committees. I was then advised by one of my mentors that you're not a real lawyer if you haven't been a litigator for a while. So I transferred to the LA office and was in Office of Trial Counsel for 5 years. I had been a lawyer for 40 years. After I left the State Bar, I went to the United States Department of Justice. I worked as an assistant U.S. attorney in the Western District of Louisiana, y'all, where I did criminal prosecutions, mostly white-collar crime. I then moved back to California and worked in a brand new program, I like new programs, the Office of the U.S. Trustee, which is part of the Department of Justice, and you actually heard one of the investigators talk about that. It's the bankruptcy watchdog agency, and I did that for 27 years when the program was pretty much brand new. I was the only assistant they had ever had in Sacramento. So I have a long history of both from the prosecutorial side, but also the management side, because I was the manager of that office. I also worked on many national projects, developing rules and procedures and processes, and more importantly to our court, I've been through the transition from paper to an electronic court. So I know where we're going, and that's going to be my big goal, is to shepherd us into an electronic age, which I think is very exciting. So I started December 18th, so you're getting me 6 weeks into my job, and I'm learning a lot. And first is our numbers. So there are 2 graphs here that basically show how many cases we've had, disciplinary and regulatory, and we'll talk about the difference in a minute. But basically, you see, it goes up and it goes down. And it's going to go up again. It happens, especially with the fingerprinting coming up and from all this money at OCTC. The cases will go up again. Right now, the numbers up there are only through November 30th for this year because we haven't gotten the numbers finalized, but we do have the final numbers for a couple of things. I'll put that on another chart. But we'll go through them specifically. So in 2017, there were 439 by the end of December. 439 disciplinary cases. These include cases arising from complaints, clients, judges, other agencies, criminal convictions, Rule 9020 violations or 9.20 violations. That's when an attorney is ordered to notify their clients of discipline and they fail to do so. Violations of probation, or a reciprocal court has imposed a discipline against an attorney, some other court, and we then have to take a look at whether or not discipline is appropriate here. So that 439 cases in 2017 compared with 2016, which was 354. So it's down a little.
Total.
Yeah, that's total. Regulatory cases, these are a little different. There were 82 of those by the end of 2017, and the biggest group of these are cases in which the court has to enroll, you just heard about that, an attorney inactive for either physical or mental health reasons to protect the public. The next largest group is considering an attorney's request to resign while charges are pending, or even a complaint is pending an investigation. In those, the court has to consider whether or not allowing the attorney to simply resign rather than go through the disciplinary process would thwart the goals of discipline or cause harm to clients. In other words, you don't get granted a lot. Pretty much, I think the example I was given of when that might happen is where somebody's ready to retire and they forgot to do their NCLE. we would let them, and there's discipline pending, we would let them probably resign with that pending. And again, another group of cases you've heard about will be appeals from a moral character evaluation that says they're not fit to take the bar exam. And here's compared to 2016. Again, the numbers were a little bit higher. So we do have discipline guidelines that we follow. And in those, they were developed by a task force and were approved by the Supreme Court. And it's very important because we want consistency in all of the decisions. And if everyone knows what they're doing, then they're going to get consistency. If it doesn't happen at the hearing level, it's going to happen at the review department level. There's recommended discipline that based on mediation, aggravation, existing case law, and a couple of Supreme Court cases. There haven't been many. There have been 3. You heard about one, Glass, which had to do with moral character cases. There was Silverton that had to do with whether or not the standards of discipline were appropriate. And there was another one called Grant that had to do with criminal convictions and whether or not something was moral turpitude per se. So all of the court considers the same guidelines in determining discipline. The disciplinary levels by percentage have stayed pretty consistent. The numbers, of course, change by the number of cases, but it seems in the last few years that it's not like we're running wild and letting all kinds of people off. The percentage of disbarments is pretty much the same, a little lower on actual suspensions, a little lower on stayed. But again, these are the final discipline, meaning this is what the Supreme Court signed off on, and that's important. I'm going to hand it back to the judge for this.
All right, I'm going to talk about the 3 remanded cases. And of course, I'm going to talk about them generally because of certain confidentiality. And that is that sometimes in some years and sometimes in other years, we may have the Supreme Court, rather than take a case and take a, as we call, take a case and then publish it and hearing, etc., we may have what's called a remand, in that they are the final arbiter of all discipline, and they can remand if they choose to a case to us to reconsider. And so therefore, sometimes we get some cases back and sometimes we don't. We haven't had any cases remanded in several years. We did have 3 cases remanded in 2017, and both of those arose from, both of the 2 arose from stipulations. In one case, just as an update, a new stipulation was resubmitted to the Supreme Court and is currently pending there. So the case comes back, and in a public, very short order, the court says, please reconsider this case in light of the case, or in light of the standards, or in light of what everything issues to put on the order. And so this was a case then that would go back with that order. Everyone evaluates it, and a new stipulation actually came to be with all the parties agreeing and submitted to the court as pending there now to determine whether they would accept that. The second case remains pending in the State Bar Court, and that case has had a number of settlement conferences and has a further settlement conference in February 2018. Trying to settle the case. If it doesn't settle, then cases go to trial and they don't settle. And then the final case was a default disbarment case. And what I mean by that is a case where someone defaulted and the automatic, we'll call it the automatic presumed sanction is disbarment if it's default. However, the parties can bring, there's a lot of discretion for the parties to come back to court and ask for relief, 473 type relief. Can I be relieved and can I go forward? Well, our court never received that particular request. Instead, that request went to the Supreme Court, who sent it back for us to consider in light of their having considered the 473 type relief. And in that case, discipline was sent back to the court, and the court accepted it and it was closed. And so these are rather uneventful, in my mind, sendbacks or remands, as you might say. And I think it's interesting to look at what they are every year if we get them. But as I said, we haven't had them in several years.
Let me add something, because I thought it was interesting. The 2 cases that were kicked back that had to do with stipulations both had to do with out-of-state criminal convictions. And since we're anticipating an increase of those with fingerprinting, we paid a lot of attention to why they came back. And we've revised our procedures on what we're going to require being sent with that order, because it was clear there just wasn't enough information. So we've changed our internal practices that I think will make sure that this doesn't happen again. I mean, that's not to say the Supreme Court won't disagree with us sometimes, but we do pay attention when things are kicked back. It's important to us. And so please don't think we would at all disregard them, except for that one where the person didn't get around. I don't know if you understand the known lawyers. Default means this attorney had nothing to do with the case. They just laid back and did nothing until it finally got to the Supreme Court and they woke up and said, oh, wait.
What happened to my license?
Right. So that was, that's a real anomaly. That's probably not going to happen for another 20 years.
A couple comments that I'd like to insert here. One is I know an apology to our Assistant General Counsel for the review unit. These are the cases I was talking about, and technically they're not Walker petitions.
No.
Although I view them through the same lens as a trustee. It's something I want to know about. Secondly, it's useful to remind the trustees, particularly the newer ones, that we have an ethical obligation to stay out of details of particular cases of discipline, which means that our interactions with the judges of the court and our interaction with Steve and his team have to be pretty thoughtful. We don't want to create a paper trail that suggests that there's political influence over the wheels of justice. I usually use the analogy of a relationship between the board of supervisors of the county and the elected district attorney's office. The board sets the budget, the board has some administrative responsibilities, but they don't tell them who or her could prosecute and what outcomes to produce. So in your policymaking role, you should be thoughtful about who you communicate with and how. And generally, it's rarely going to be appropriate for you to communicate directly with the judge of the court. It will be more frequently appropriate for you to speak to Antonia. She can be that sort of messenger who protects the independence of the court and keeps us in our appropriate policymaking role. Similarly, when I've been a little freer speaking with Steve as president of the board, because I have a slightly different role than I've had in the past, forgive me, chairman of the board. But generally, I have spoken to Leah or to Donna, Dag as he comes into his new role, maybe Sarah in her secretariat role. But I'm looking to our management staff to be that buffer between me and Steve's team so that I'm not leaving a paper trail suggesting in any way that I've attempted to influence their work. So this just seemed a good moment to remind us as we're orienting ourselves to this business what our ethical obligations are and what best practices are about demonstrating commitment to those ethical obligations.
Thank you. I also think that it very much speaks to my first point of judicial independence. And I think that Tony's point was a very good one. Well, I'll make one more footnote on what you've said, which is that if you notice, there are no names of any cases up here, and everything on the past slide is public record. It was a public record, public order, everything was public, so none of those cases were confidential. But it's a very good point, because when any court, whether you are a superior court, I remember you get a case back from the appellate court, you certainly study it very much, and you determine, well, what is it that the court is saying to me in this? And so, yes, we have, when we say changed our the way that we were doing things a little bit and sending things to the Supreme Court, we're just sending a little more information that, instead of summarizing it, giving them real, better information, perhaps the original document, ways of just always improving, and we are always looking to do that. And so I think it's important that you would know that that kind of effort is going on in, say, these kind of cases. Okay, just for an example, the timeline goal for a contested case, this is in the hearing department, and this is set out by our CPS standards, is, as you can see, a case is filed, a response, the matter goes to trial, ideally day 125, and of course 10-day trials aren't that common, although trials can be anywhere up to 20 days. And then a decision is filed, and we have a 90-day rule for our decisions being filed also. And so that's an example. We have set in place some rules or internal policies to expedite cases and increase efficiency, and not at the cost of due process, though, to anyone. So we're always balancing efficiency and due process. This is true in any court. And so there were some rules a while back made about mutual exchange of discovery. We have a new evidence standard. It's been around now about 3 or 4 years, and it's a kind of a partial APA standard, that is, dealing with relevance and hearsay. the state bar has adopted rules loosening a little bit those standards, such as in the APA. So evidence can, hearsay evidence can come in if it supports or supplements or explains other evidence, as opposed to the general rules of hearsay. Although if it is to prove a fact by itself, it's still subject to the rules of hearsay. In every way, shape, and form, the trial judges try to have trials on consecutive days if they can. It's not always possible because of people's schedules, including the respondents' schedules. And I would say that the last one on here is really the most important one. So the most important one either was first or last, right? But I put it last because it really connects to the next slide, which is our final slide. And that is that we are making in the court every effort imaginable to file our decisions earlier than the 90 days, early anytime we can, but we are not sparing due process. So we have simply put into place different kinds of triage as to what can be done sooner and what can be done, let's say, faster and filed sooner. And so, for example, if we look then to the next slide, the average pendency of all cases in 131 days in 2006. But we've shaved off nearly 20 days in 2017, and probably more because of November 30th. And I attribute this to a couple things. One is the judges' efforts to file their cases before the 90-day deadline, and simply to not have that be their deadline, but to move the cases forward as they can and within due process. The other is an internal trial that we're doing, which is where when we have a default case, that means no one has appeared, we also have a 90-day deadline. But those matters are uncontested and take much less time. So we've moved our own internal deadline up so that default cases then can be filed sooner. And, I think it comes to reality when you say this to yourself. If you file a default case on the 30th day and not the 90th day, and that party was owed money, and somehow they got their money through the client system, that 60 days, now you think about money and you think about 60 days, or even just stress in 60 days. Maybe stress should be higher. But you might be able to buy a house that you couldn't buy. You might be able to put your child through education if the school year started and you weren't able to. In real terms, something like 20, 30, 40, 50, 60 days does, down the line, make a difference. And that really is, I think, in the interest of protecting the public, the courts, and certainly the reputation of our profession. So that concludes our presentation today. I hope we've been able to give you some good information. I know some of it's repeated for the many faces that I know and see, but we're always happy to come. And I think we even are exactly on time, or have time for maybe a question or two. We have how much? Well, we have 3 minutes for questions.
Then I can quickly point out our upcoming projects. We are working on revising our rules of practice. Rules of practice should be like local rules, and we found that our rules of procedure and rules of practice are a little messed up, kind of interwoven. So we're trying to sort those all out so that real rules of procedure and the rules of procedure and the rules of practice are just local rules. And that will give us more flexibility when we get to an electronic court, which will be necessary. We're working on revising a probation condition that we believe is ineffective. It's the law office management practice one. It's just too vague. So we're working on getting that cleaned up. Again, we continue our project of getting the earlier filing of opinions and decisions, but this means drafting them and not waiting to the last minute. And the internal committees we've created to make our court more efficient, coordinating administratively with the Office of Trial Counsel on procedures. Steve and I talk about lots of things, none of them cases, all about how do we get from A to B. And so that's, again, that judicial independence.
And I'd like to thank Tony because there was another slide on my next page that I totally didn't see. So I thank you for doing that. Are there any questions? We're probably down to a minute.
Well, I want to thank Judge Purcell not only for her presentation today, but for her leadership of our independent state bar court. And I want to welcome Antonia. We're grateful to have your leadership on our team, and we look forward to great things.
Thank you very much.
Questions from the team for these presenters? given that they're coming in under budget and on time, under time, I'm gonna give us a 5-minute biology break. We'll be back at 3:10.
Thank you, everyone.
Wow.
Okay, we're on the air. Please introduce yourself. Let's start.
Okay. I'm Michelle Harbin. I am the acting program manager for the Lawyer Assistance Program. And I'm going to tell you a little bit about...
Get a bit closer to your mic.
Oh. Is that better?
Yes, I think so.
Okay. So if you didn't hear, Michelle Harmon, Lawyer Assistance Program. So I'll tell you a little bit about what our program does. And so it's not the exact same as last year, some of our newer initiatives. And the first newest thing actually is that our program is open to active, inactive, and formerly licensed attorneys in California. You'll see on your agenda for Saturday that one of the items on there is changing our program rules to comply with the statute. SB 36 amended our statute to include students who are in law school or who have applied for admissions to the bar as eligible for our program. So this is going to be huge for us. You'll see when I get farther into the slides about the scope of the issues of mental health and substance use for younger attorneys. But we've been getting many more referrals over the past few years from admissions, from the Committee of Bar Examiners, to take a look at some, for people that are referring to us with concerns about arrest, usually alcohol or substance-related arrests like DUIs or drunk in public type charges, and want the applicants to have an opportunity to take a look at those issues. I think last year about 25% of our referrals were from admissions or from word is getting out amongst the students that if they have things like DUIs or things on their application that are going to come to the attention of moral character, to come to us sooner and start dealing with those issues before they start running into their deadlines of bar exams, things like that. So this is some of the newest data. This you may not have heard of, but is huge in my world. This study was published in 2016, and it was a joint effort from the ABA and the Hazelden Betty Ford Foundation. And this is the newest information we have on the scope of the problems of substance use disorders and mental health issues in attorneys. This study had over 12,000 respondents. It was a national survey. And before this, the best information we had was a study that was about 25 years old and was only about 1,000 respondents in Washington State, so it was very narrow. And it's changed our thinking about problems that attorneys are having, because it was previously thought, and based on that Washington State study, that it was older attorneys that have that are experiencing problems at a greater rate, which intuitively made sense. Substance use disorders are progressive illness. It gets worse as lifetime goes on, as people's careers go on. Your body can't take as much as it used to when you were younger. But this actually showed the opposite, this newer study of the self-report. 22.6 reported problematic use of alcohol or drugs at some point in their lives, and if you add up all of those numbers between those who reported use started before law school, during law school, or within the first 15 years following law school, that makes 85.5% of all of those respondents. So I picked out a quote from the lead author of the study, Patrick Krill, said, "Taken together, it's reasonable to surmise from these findings that being in the early stages of one's legal career is strongly correlated with a high risk of developing an alcohol use disorder." So that's where we're looking. That's why we're very excited to be able to have these law students and applicants come in.
Let's dwell on that number for a moment. 22%, almost a quarter, 2 out of 9. That's a huge problem for our profession. And I think the profession needs to confront it in every way that we can. Certainly we as a regulator have a role to play, and that's what we're hearing about. But our friends elsewhere in the profession need to give thought to this issue too.
Thank you. And mental health, these are the top 3 reported, self-reported mental health concerns: anxiety, depression, and social anxiety. I've heard Patrick Krill and others present this study many times, and one of the things that doesn't usually get presented but really stuck out to me was they also asked about suicide attempts, and so those attorneys who were willing to respond about their experience with having suicidal ideation or actual attempts, it was only 0.7% responded that they had made a suicide attempt in the past. But if you take that over the over 12,000 attorneys who responded to the survey, that was almost it was about 89 people who had attempted, attorneys who had attempted suicide at some point during their careers. And morbidly, those who succeeded were not included in this study, obviously. So, shifting to how we intersect with the discipline departments. Of course, attorneys suffering from mental illness and substance use disorders are more likely to be subject to discipline. I have old studies about that too, but hopefully new research will be done on that. And the discipline often brings to light other mental and emotional problems that weren't noticed before people were able to sweep under the rug, especially depression, anxiety. And these are examples of some of the things that we see: acts or omissions leading to discipline, failing to answer phone calls, open mail. Failing to open mail is actually huge with the depressed attorneys that we have. They just find it so scary, especially if there is the seal of the state bar on the letter that you just don't want to open it. And one of the things that's often talked about in our LAP support groups is creating like a buddy system, someone to check in with you, make sure you're going through your mail, or even bringing mail to the group to open together if they need the support, making sure your inbox is cleared. And of course, acts all the way down to missing court dates, filing dates, lying, misappropriation of funds. And so we're also really happy to be able to reach law students and bar applicants now in order to hopefully prevent these issues from becoming a problem later in their practices. So there's three main things that the LAP offers: the orientation and assessment, and the support and the monitoring program. So the orientation and assessment is the first part of the program. Applicants are able to come in and meet with the case manager. All of the case managers are licensed mental health professionals, and they will do an assessment. They will talk about their substance use history, mental health history, family practice issues, and will make some recommendations for a structured program of recovery. In this first phase, what we call orientation and assessment, people are also able to access 3 of the LAP support groups for no fee. So there's no fee for any of this part of it. And then support and monitored, actually, go to this slide. So the recommendations that the case managers will make will include things like these examples. So the weekly LAP support group, which I've been referring to, which across the board is the best feedback we get about the program. The groups are small, we keep them under 10 people, and it's a very unique environment from what I'm told from the attorneys, to be able to sit in a group of other attorneys or law students, people like you, but not talking about cases and not talking about the law, talking about other issues, family, other stresses. And we will also recommend things like individual therapy if that's appropriate, psych testing, medication, psychiatric evaluation for medication management, and biological fluid testing, urine testing. So our program is confidential. We don't release any information to any other departments within the state bar or anyone outside of the state bar without the attorney's prior written consent. But as attorneys are going through the alternative discipline program, one of the things they do is sign a release of information to allow us to be able to report on the monitoring to the alternative discipline, to OCTC. And probation. And so what we're reporting on is their compliance with the items that are on the plan that they've agreed to. So the urine testing, of course, is an important part of that for them to be able to demonstrate a period of sobriety. The same thing with bar applicants referred to us by the Subcommittee for Moral Character. We'll sign a release that will be able to send reports on them, and they're usually very happy to be able to demonstrate a track record of sobriety, show that they're taking very seriously, they're addressing these issues.
Can you explain, yes, can you explain what of these plans are actually covered by LAP funds and what have to actually be paid for by the person participating in any of these programs?
They all have to be paid for by the participant in the program. So there are some that don't cost very much, like the abstinence-based self-help groups, or things like AA, NA, the other bar, things like that, which usually are for you pay $1. But the individual therapy, the LAP support groups, urine testing, the participants all need to pay. We have a financial assistance program for currently licensed attorneys, but unfortunately we can't offer that yet to bar applicants.
Yeah, I'd like to, while you reframe your question, I just want to put in a small plug for the other bar. The other bar is effectively a 12-step program by and for lawyers with alcohol and substance abuse problems. They've been around for a very long time. They have very distinguished leadership, and they do wonderful work. They have some resources that we don't have, like they can accept people anonymously, and they can offer confidentiality. We're the cops talking to people about potentially disciplinable behavior, so we are scary to licensees. And so therefore have had two populations we serve, people who are not yet licensed to meet this entry into the profession, and folks who are so sick that they have nowhere else to go or come to our attention. So we're looking to reframe this program in a way that we can get folks in between those two humps of the camel. But I just want to say the work that the other bar does is a real compliment to the social harm convention that we're trying to do. Joanna?
So since the mandatory fee that the attorneys pay into LAP every year doesn't go to these things, maybe you can explain what it
Right,
is.
that covers the administration of the program, so the salaries of the staff, essentially, so that would include, that's why it includes the initial assessment, and then any outreach we're doing. Which if I had more time, I would go more into, but one day.
Stacey?
So the different groups that we offer, whether it's the LAP group or abstinence space, self-help groups, et cetera, who are they run by? Do we contract out with contractors to come in and provide support groups, that kind of thing? Or who's actually conducting those groups?
We contract with therapists for the support. It's a support and monitoring group, but they're all run by licensed therapists so that they're prepared to deal with any other
So
kind
our
of
contract
crises.
with a subcontractor to come in and provide services.
Right, well, and they provide their own, so they're spread out throughout the state. They don't actually do those groups here at the state bar. And the rest of it is referral based. We don't contract. We contract with the company that does the urine testing, but we don't contract with otherwise psychiatrists or individual therapists.
Got it. But if somebody wants individual stuff, then they're on their own to pay for it themselves, et cetera, like Joanna
Correct.
asked. Okay, thank you.
So that sums it up. In a nutshell, the People in Support Lab can pick and choose what of those recommendations they want to do, and monitored, a case manager is checking up with them and following through to make sure that they are following those recommendations, and then reporting to whoever is requesting reports. Thank you.
Thank you.
Thank you for your report and for the good work that you do. I want to turn that microphone off to make sure we don't get feedback. Thank you.
Good afternoon, I'm Terry Golding, I'm the supervising attorney for the Office of Probation, and I thank you for this opportunity to tell you a little bit about what we do. Obviously, one of the main things that we do is we monitor disciplinary orders. We also monitor Rule 920 declarations, and we also monitor any other order that the state law court wants to give us. So it could be an additional cost order, an AAP case, anything that's sent to us in an interim case capacity, maybe conditions to restrict or supervise an attorney's practice. Obviously, the number of files that we get each year is heavily dependent upon the number of cases that are filed in state bar court and that are resolved by the court. So the main impact on our numbers this past year is a reduction in the number of cases that we monitor Rule 920 in for resignations without charges pending. We work with other departments to modify the form that's used by attorneys to resign with charges pending, so now the information that's required by Rule 920 is a part of the resignation process so that they don't need to do a separate 920 at the end. I'm not sure if it was discussed with you earlier, but Rule 920 is a public protection rule. It's a Supreme Court rule. What it does is it requires each attorney who's going to be suspended for at least 90 days to give notice to clients, to the tribunals, to opposing counsel that they're not going to be able to practice law. It also requires them to return client papers, funds, and property. And then it requires the attorney to also file a declaration stating that they have done all of this with the state bar court. So we review both the substance of that in my department and maybe perhaps refer them.
Let me comment for a moment here. There's been some news coverage and public controversy about the effectiveness of our enforcement of Rule 920. our new management team, with the help of you and your team, have been looking hard at this. And I think we've made some changes that may explain why that number has fallen as far as it has. We're doing a better job of preventing harm to clients by educating the regulated community of what their obligations are and helping them to fulfill them, rather than just whacking people after the fact. So I just want to applaud that success. Can you give us any insight into why the number of agreements in lieu of discipline shows such a stark change in recent years?
Well, for my department, we no longer monitor agreements in lieu of discipline. So the Office of Chief Trial Counsel is now monitoring their own agreements. Agreements in lieu of discipline aren't discipline, they are supposed to be confidential. And so in the past, the Office of Probation did monitor those, but I think it was about in September of 2016, they took back the monitoring of those matters.
So this is your unit's workload, but not the total of our
Yes,
workload. Okay, thank you.
exactly. The Office of Probation opens a case upon receipt of an order from the state law court. So in this case, Douglas Shoemaker, it was resolved by stipulation. It's a probation case, so in addition to the stipulation, we got a Supreme Court order. Once we receive it, we obviously have to review the order for the actual conditions that are in it. This case is public, so this stipulation is on this member's attorney profile on the State Bar's website, along with all of his conditions and the effective date of his probation. So, but although the discipline itself is public, his compliance with his probation terms is confidential, and that's under the rules of procedure. In reviewing the orders, we do look for all of the specific requirements for each individual case. In this particular matter, he had extremely common conditions. He was required to schedule and hold a meeting with his probation deputy to review his conditions. He was ordered to file quarterly and final reports, attend ethics school, which is held by the Office of Chief Trial Counsel, and taken past the multi-state professional responsibility examination. This is the same test that new admittees have to take, so they all have the same passing score of 86, and it's offered by the National Conference of Bar Examiners. Other common conditions that are set forth in the court-approved stipulation forms that are also on the State Bar's website are things like restitution, certification of client trust accounting conditions, compliance with their underlying criminal probation matters, preparation of the law office management plan. This is what State Bar Court was referring to. This is the condition that we're looking at changing. Preparation of the law of the medical conditions and the lawyer assistance program. So there's attorneys who don't want to be in the lawyer's assistance program. So the Office of Probation does monitor lab testing, AA attendance and therapy sessions, MCLE client trust accounting, and Rule 920. The court, however, and the parties can negotiate completely different conditions, and then we will monitor those. After determining what the conditions are for each individual case, the Office of Probation prepares a courtesy reminder letter for each attorney, and then we upload that to their private member profile. We send them an email concurrently with that, letting them know that it's been uploaded. We provide them with information, including the list of all of their conditions and deadlines, but we also provide them with a lot of information. So we have an information sheet on the MPRE. We provide them with a courtesy copy of a quarterly report form, so they can use all of these information. And then in the letter that we provide to them, we let them know that according to case law, Office of Probation is to help them, but their probation is self-rehabilitative in order to show that they have been rehabilitated. Included with the letter also are various things that we provide to them, and then if they need to, they can re-access the documents on their private member profile at any time 24/7, so that they can get their quarterly reports into us each time. For those that have been ordered to, we do conduct the required meeting and we review all of that information with them all over again. And then we have a form that we've created that sort of documents that every issue that we've discussed with them, and after the meeting, we then email them that form so they get another form of contact. Each attorney then submits documentation to us. We review it very closely. If there's a problem, we may need to refer them. If they know that they're having a problem, they can file a motion in State Bar Court and ask for additional time. The Office of Probation does not have the authority to change their conditions. The rules set forth standards that the court considers when granting a motion to modify, and then if the attorney does not comply, we do refer them. Depending upon what type of violation it is, depends on what we do with the case. So if there is a probation case and the attorney has violated the multi-state professional responsibility examination, we notify the review department and they're almost immediately put out on actual suspension until they can provide proof of passage. If it's a reproval case, a Rule 920 case, or a probation that's already terminated, we prepare a referral folder for the Office of Chief Trial Counsel that has a memo that sets forth all of the communications as well as documentations that they can use as evidence. If there is an ongoing probation, there can be a choice either by the Office of Chief Trial Counsel to file it as an original proceeding, or as what happened in the Shoemaker case, I can file a motion to revoke his probation. In this particular case, he did not schedule and hold his meeting. He did not file his first 2 quarterly reports. So in this particular case, the State Bar recommended that the Supreme Court impose 6 months actual suspension, revoke his suspension or probation, and impose new probation conditions, which the Supreme Court did. These are the number of referrals that we've done over the years. You can see that even though the caseload has gone down this past year, the number of referrals stays relatively the same in total. So by doing these referrals, I believe that the Office of Probation does assist in the State Bar's public protection mission. And I thank you for this opportunity to provide you with information.
Do we have any questions? Just one comment I would make. SB 36 required us to make significant changes at the bar, and they required us to do a number of important studies as well. And 2 of the studies that we did, one mandated and one voluntary, was the classic compensation for our entire workforce, not just discipline as the statute had required, and also of how we were using staff and how we were doing the business of the agency. And we hired the National Center on State Courts to come in and evaluate the way we use our resources to protect Californians. And their report produced recommendations that we look closely at how we operate our LAP program and how we operate our probation program to make sure we're getting maximum benefit from the talents of the folks in those units. And that study and the thinking about that is still underway. And so this board will have some policymaking judgments to make along the way as how to optimize those programs. And it is hard work to operate a program at full speed while being asked to think deeply about how to operate it. And so we know there's the change stress that you and your team are experiencing. And we just appreciate you all the more for it. Thank you.
Thank you.
Welcome.
Good afternoon, I'm Lori Mella, and I'm with the Client Security Fund. I think we're going to go out on a high note this afternoon because who doesn't want to hear about giving money to victims, right? And we do a lot of good. So I'm proud to oversee this fund. I'm proud to be part of a profession that says we can't control all the bad attorneys that are out there, but those who steal from their clients, we're not going to tolerate that, and we're going to do our best to reimburse them if we can, and that's what we do. So the fund was created by Business and Profession Code 6140.5 to relieve or mitigate pecuniary losses caused by dishonest, active, licensed California attorneys. The payments are discretionary. Nobody has a right to reimbursement from the fund, but we, of course, are not arbitrary in our decisions. And it's subject to the regulation and conditions as the boards shall prescribe. The fund has reimbursed over $150 million since its inception. We currently have about $6 million per year to reimburse, and we need approximately $22.5 million to reimburse just our pending inventory, and that's something that's going to be a discussion later on this year that the board will be looking at. We've reimbursed over $20 million to over 3,400 people in just the last 3 years, so we're trying to really help the victims out there. Again, this was created by 6140.5, which the board then was told to create how the fund was going to be administered, and they created the Client Security Fund Commission and the rules of the fund. There are 7 members who serve 3-year terms. They're appointed by the board, 4 attorney members and 3 non-attorney members. And it's the commission who has the sole and final authority to determine whether to grant an application. And myself and my staff, we are counsel to the fund, and we do the work of the fund. CSF is funded by $40 from the annual licensing fee for active attorneys, $10 for inactive attorneys. That assessment has not been changed since 1989, except when it was actually reduced for a few years to $35. So we've been surviving on that $40 for a long time. Anyone can apply for reimbursement from the Client Security Fund. Anyone who thinks they've lost money due to the attorney misconduct can apply. You need to complete and sign a CSF application, send in your evidence, and then, of course, there are more procedures to follow. And we're separate from and independent of the discipline process, but of course we work closely with them, and we cooperate and share resources whenever we can. One of the main, there's a Supreme Court case, which is Salibi versus the State Bar, which provided how we do a lot of our process. And so Salibi said that since applicants are not parties to the discipline proceedings, they're entitled to independent review of their CSF applications, and they must be given due process, including an opportunity to be heard and respond to whatever proposed CSF disposition there is. And there must be written findings of fact and conclusions of law upon which review can be made, and that review is writ of mandamus to Superior Court. Now, Salibi only talked about applicants, but later on there was a case that extended that to respondents, so of course both parties are given full due process in responding to CSF applications. So the main requirements for CSF reimbursement, again, you're an active California attorney, must have received the money or property at issue. The loss must have been caused by dishonest conduct, which is essentially theft. Wrongfully retaining entrusted funds, a settlement check they received and kept, probate funds that they took out of the accounts they had access to. Failure to refund unearned fees when no work or an insignificant amount of work was performed, or borrowing, investing client money with no intention of repaying or making a real investment. That category actually has extra conditions on it because we have to make sure it was really part of the attorney-client relationship when it's a loan or investment case. So what we don't cover is malpractice, negligence, interest, consequential damages, things like that. It's actually the money that was received by and wrongfully retained by the attorney, and we require documentary proof of that. So CSF works along with the discipline system. One of our requirements, we refer to it often as the discipline requirement, but there are other ways that can be met. The attorney has to have been disbarred, and that can be for any conduct, and on any case that is before the fund now, the fund can proceed if the attorney was disbarred, even if it was not part of the disbarment. Or voluntarily resigned with charges pending. If the attorney has been disciplined less than disbarment, then it has to be on the matter related to the CSF application for us to go ahead and proceed. We can proceed if the attorney has died or been adjudicated mentally incompetent, or if the attorney's been convicted of a crime related to the applicant's matter or found civilly liable. Restitution does not have to be ordered by the State Bar Court for CSF to reimburse an applicant, and we're not limited by the orders of the State Bar Court on what those amounts are. You're supposed to get an independent look at your matter, and so that's what the fund and the commission does. Restitution is generally not ordered on most of our matters because they tend to involve disbarred attorneys, and a lot of those cases come in maybe after the attorney was disbarred. And restitution is relevant, though, if we are trying to collect later against the attorney, which we'll talk about a little bit in a minute. So CSF counsel and our staff, we conduct a legal evaluation and investigation of the applications. We assist the commission by writing the decisions after they approve them and provide the written findings of fact and conclusions of law per Salibi. We present the matters to the commission and provide counsel at the meetings. The commission meets 6 times per year. And then we serve the legal documents and authorize the issuance of the reimbursement checks. There are 3 attorneys who do all of the work of the fund. We are getting a new attorney starting Monday, so there'll be 4 of us, so we're looking forward to that. And we'll also be getting an investigator, because right now the attorneys also do all their own investigating of the cases. So there's two different ways a case can get through the fund. You can, if it's a clear case, the rules provide that the director of the fund can issue a notice of intention to pay. This is served on the respondent attorney. It says you stole $5,000 from Ms. Smith when you got her personal injury check and didn't give it to her. If you don't object within 30 days, we'll be reimbursing her. And if the respondent attorney doesn't object, then we go ahead and send the check. For more complex cases, or if we know the attorneys or even the applicants are going to be objecting, then we bring a tentative decision to the Client Security Fund Commission for approval. They review that decision, and then it's served on both parties. They have 30 days in which to object, and if there is an objection, the entire administrative record goes back to the commission with the objection for them to review, and then a final decision is issued on that matter. Once the final decision is issued, that's the final action by the state bar, and the parties have to go to the file a writ of mandamus if they wish to challenge the fund or the bar in those proceedings. And we're represented on those by the Office of General Counsel. We do have collection and subrogation rights. The statute provides that for us. So repayment of CSF reimbursements is a condition of continued practice or reinstatement of practice. We get a lot of calls from respondents when they're thinking of coming back after having been disbarred. How much do I owe the fund? And tell them $250,000 or whatever it is, and they have to pay that before they can even file for reinstatement. A lot of the times we don't hear from them again, but if they do, then they have to pay first. If restitution is ordered, the bar can obtain an automatic judgment against that respondent attorney. For all other matters, then we have to pursue litigation to get that judgment. And then we have just a bit of a comparison here to some other states. You see that the work that the California Fund does, we're by far the largest and most comprehensive fund in the country. We resolved 2,332 applications in 2016, and the closest by far was New Jersey. They had 912 that they resolved. So we're doing a lot of work. As you know, I'm sure California is almost its own country a lot of the times with the way that it works and the number of people we have and the way the number of cases that we get, not only in the discipline system, but then that come to CSF. So we do have a lot of work that we were working our way through. We do our best to try and get the reimbursement to the people that are qualified. Not everybody qualifies. You do have to provide proof, obviously. You have to make sure you meet all the requirements. Since we have just a minute, I did want to share with you a thank you letter that I received. I thought it would be nice for you to hear that people do appreciate the work that we do. They said, the Bar Association has not only given monetary restitution to us, for which we are immeasurably grateful, but has also given us both a lot of emotional healing as well. Your department's work is very meaningful and impactful to affected Californians like my wife and I. It must not be easy trying to correct the transgressions of a few bad members. In our circumstance, it must be recognized that the restitution fund worked extremely well.
That's good. Very nice.
So,
before I open this to questions, I want to make a couple of observations about the Client Security Fund. The folks who get paid are thrilled. The folks who are waiting are less thrilled. And most folks wait a long time. The reason they wait a long time is that we have to complete the bar discipline process as to the attorney, all the way through a signed Supreme Court order, because the attorney is going to be responsible to repay this money to be readmitted. And therefore, we are dependent on the wheels of justice and the discipline side of the house. The second reason that people experience delay is that we get $40 per licensee per year, a number that was chosen in a legislative way, shall I say, many years ago and not revisited since. And my sense is that number was never very carefully calculated to address the problem. So for many years, we built up a substantial reserve. And then the loan foreclosure mitigation mess arrived and not only depleted that reserve, but brought us right down to the reserve level that's recommended to manage this program. The loan mortgage mitigation foreclosure mess has been solved largely by the real estate market. And those cases are working their way through the rabbit, and the Client Security Trust Fund seems to be recovering a bit, I think. But we as a board have a duty to keep monitoring this. We may end up having a dialogue with the legislature about whether more resources are needed, and we have a report on exactly this subject in March. So that's all background for you as to policy issues that are coming your way. With that, do we have any questions or comments for Lori?
Thomas had one. What is the delay from eligibility to payment? Once we've said, okay, you're eligible, then what's the delay in getting the check? Then?
Once we've actually processed it through and we're ordering the check?
No,
Or-
from when it's determined that the claim.
So now, yes, it has jurisdiction, we could move forward and bring it through our process.
And it's been determined that the claimant has a meritorious claim. What's the length of time before
Do you
they
do that before discipline is final?
No, because there's such an inventory of cases, we don't really have time to look at the ones that are waiting. We're working on the ones that we're trying to get through. I mean, if you were to file today and the attorney was already disbarred, you'd be looking at approximately 36 months till you got reimbursed.
That's where I'm getting feedback from the community, and I'm not criticizing, I'm not, but that's where I'm
and I
getting.
think the largest part of that is the metering of the money out. We're budgeting $7 million a year. In order to stay current, we need more than $7 million a year, and so the key was built.
Right.
Is it 7 million, am I right on that?
Six.
Is it in part to keep the money, are we doing that to budgetary reasons, or is it?
We're paying out the full amount we have every year to
Okay.
pay out.
Okay.
So we had 6 million last year, we paid 6.4, we were able to go a little bit over. We had more cases that, the staff had been working on, that if we had more money, we might have been able to, continue, but those will go early this year to the commission to get ready and go. So it's really a balancing of, some of it is the work. I mean, we couldn't tomorrow pay everybody with 3 attorneys or even 4 that we start, but it's also a balance with the money. There's just not enough to handle the
A few
amount
years
that
ago, we
we have.
had what we called the surge, where we brought in more boots on the ground, so to speak, to process the backlog and spend down our reserve to a prudent level. And we did that, and we made a lot of people partially whole or whole, and we don't have the resources to do that again. And the concerns you're hearing, our legislative friends are hearing too, and that's why we're asked to report to them in March. But they may find that the solution is a hard one, which is more legislative authority that may be difficult to create consensus around.
Lori?
Stacy and then Jim.
I guess one of the questions that I would ask, you don't necessarily have to answer it here, but is what is the communications with the individuals like during that 36-month period? And maybe looking at that in addition, because the check may not be able to go out, but what is the communications like to maybe kind of just, and not that that's going to take the place of it, but sometimes that helps that process. We don't have to litigate that here right now, but maybe that's something to look at in the future.
It's a good question.
I mean, we do provide, as soon as they file, we send an acknowledgement letter, and we try and be upfront with them in that letter about how long the process can take. We specify, if there's discipline yet on your matter, you have to wait for discipline to be final. If there is discipline, this is about what we're looking at. We also send status letters throughout the year, updating them, and generally people will call and ask, what is the status of my case? And we have someone who either returns that phone call or sends a letter explaining what the process is. And, most people are generally understanding of the process. You will get people who will, continually call and ask, and we understand they're in difficult circumstances. We do our best to talk to them and explain the process and tell them we're trying to handle these as fairly and efficiently as we can with the budget that we have.
So, Lori, you might want to just further explain that. Proactively sending the status letters to all of the applicants is relatively new.
Correct.
And that this year we're going to do it twice, right? And that you've also worked on the language of the letter itself.
That's correct.
So that's really helpful. I mean, I think that's really helpful information. 'Cause that may even change some of the,
Hard feelings.
stuff that we hear on the ground or whatever.
Yes.
And I think that because the general public thinks that it is a right, and we all know it's not. But I think they think that once discipline's been imposed, it's now my right, because this is a governmental agency, my right. So that's an optic.
Yes.
I think that's the
Yeah. As I understand it, we're generating about $6 million a year in revenue from the assessment of $40 for active, $10 for inactive. But did I hear you correctly when you said now that it would take 36 months to clear the backlog? Has discipline been imposed to the level where actual reimbursement that is now outstanding would be $20 million?
So we actually get more, and then some of that goes to run the fund.
Right.
But the amount we actually have for reimbursements is about $6 million every year. What we do is we look at a 24-month rolling average of the amount that has been requested on all the applications, and there's an equation that is done to determine how much we think we'll be paying out on that. So right now it's about 22 million. Not all of those have the discipline yet, but I would say a very large portion already, yes, there is discipline, and we're having to wait to be able to reimburse on those.
Well, one of the concerns that I have is that I think it's going to be mandatory that we're going to have to get an increase in the assessment because the number of attorneys is not growing exponentially right now. I mean, we're not adding to our ranks, so that's not going to generate the revenue to be able to satisfy the 22 million outstanding.
Right, I mean, and then it's part of this report that we'll be doing for the legislature, going through different scenarios in terms of maybe other things we can look at, but most of those really are not going to be enough. We're going to need an increase. If the legislature and if the public and the board expects us to be able to pay people more quickly.
Anything further for Lori? Thank you, and I think you're winding up, so I will release the gavel to Mr. Stallings, who will convene the audit meeting. Those of you who are not on audit are at liberty, and you are welcome to join us for dinner at 6:30. If you don't know the where, let us know, and we'll get you that information. If you are on audit, please stay present because we need a quorum.
I'm not. I'm gonna try and see.
Okay, 30 seconds out.
We are 5 members, so 3 is a quorum. Until Mr. Petula has been appointed by the Senate but not yet sworn, so he doesn't count against us, so to speak.
Now we have Renee, Jason, and Caleb. They can't here.
Highland.
So 1, 2, 3, 4, 5, 6 members I count. If you look at the agenda, you'll see 7 names, the chair plus 6. If you lose Mr. Petula because he doesn't count yet, that's 6. 3 is a majority of 6, right?
4. I mean,
Got it, majority, we're just shy of them. So do we have anybody on the phone?
No.
No one's noticed.
In which case, I suggest we have a committee of the whole, but not take any action.
What we're going to do is we're going to receive the whole sounds report and we're going to table the approval.
That makes sense. And maybe what we can do is adjourn the audit committee meeting to Saturday, where we may have a quorum.
Well, let's receive them off out of.
Oh, sure, we can do our business, but if there's any action that needs to be taken, we could continue this meeting to Saturday and take the action on Saturday.
But that wasn't noticed.
Under the Brown Act, I'm looking for somebody who doesn't play a lawyer on television but is one for this purpose. Under the Brown Act, a properly noticed meeting can be continued to another stated date, provided that a notice of continuation is promptly posted.
Well, we can check on that.
Yeah, so we may be able to do that.
Okay, I'm going to call, are we good to go on the webcast? All right, I'm going to call the audit committee meeting to order. If you could take roll.
Chen. Colantuno.
Here.
LeBron. Lee. Steinbrecher.
Here.
Stallings.
Here. All right, seeing as this is being webcasted, just remind everybody to speak clearly into the microphones. If you can, and if you're not speaking to the activation microphone so there's no feedback. I will see if there's any members of the public who wish to make public comment. Any members? All right, going once, going twice, gone. All right, so with that, we are going to get into our Moss Adams report. So on the line we have Mary Case from Moss Adams, as well as Kevin Harper and Lynn Montesinos from the State Bar. So who would like to go first?
Yes, I just wanted to introduce Mary Kate as the audit partner
on the audit of the state bar. She's been our audit partner for the 5 years that we've had Moss Adams as our auditor. And this is a typical meeting at the beginning of the audit for the auditors to interact with the audit committee and share their perspectives and get ideas from the audit committee members as to what kinds of risks have been noted that they need to consider as they start their audit. So with that, I'll turn it over to you, Mary.
Great, thank you. Hello, everyone. It's great to be with you this afternoon to discuss our audit plan for the upcoming year. With me today is my colleague, Kinman Tong. I think some of you may have met Kinman in the past. He leads our team in the field, and so he's going to be chiming in here on the discussion of our audit plan as well. I don't know if someone is there able to move the slides forward, but I'm on slide number 3 of our PowerPoint. And I know the audit committee has received our PowerPoint presentation a little ahead of time, so we're not going to read these slides to you. We're going to hit them at a pretty high level so that we keep time for any questions or discussion items, because we very much like this to be a conversation with you. We value your perspective and your thoughts about risk as we discuss our plan. So if someone can move to slide 3, that would be great. This shows you your team. Myself and Kinman on the left-hand side. Jim Lanzarota is our concurring partner. We always involve 2 partners in all of our audits, and Jim is the leader of our government practice for Moss Adams, so a very strong technical player. Other members of our team are Danny Bacchiocho and Christy Chan. And so you've got the same team as in prior years, which is very good. It provides for a more productive and more effective audit when people are not having to learn about the organization or are able to really focus on doing audit work. Moving forward to the next slide, slide 4, some required communications with those charged with governance. We have the caption now and later. Later being when we wrapped up the audit. There's quite a few communications that we're required to have with you, and we have these and more. At the beginning here, we discussed the planned scope and timing of the audit, as well as our responsibilities under U.S. auditing standards. And so just in a nutshell, on slide 5, the required communications about our responsibility are listed there. Again, I'm not going to read all of this to you. I'll just say, we must express an opinion on the financial statements to ensure that, or attest that they are fairly presented in all material respects. We don't test every transaction, as you know, and so that's why it's in all material respects. We provide reasonable rather than absolute assurance. We do consider internal control over financial reporting as a basis for planning our audit and designing our procedures, but that doesn't constitute an opinion on internal control or provide assurance over internal controls. Finally, in addition to our audit opinion and required communication, that would include communicating any findings that we felt were important relative to your responsibilities in overseeing the financial reporting process. So the audit process, turning to slide 6, involves 3 types of tests to conduct our audit. The first phase of our audit, we do some interim work, and we've completed that already. That involves internal control testing. We do look at information technology controls inherent in the financial reporting, not every single information technology process at the bar, but those that are relevant for financial reporting. And what we do is we do walkthroughs of your major transaction cycles so that we develop an understanding again or update our understanding of the controls you have in place over the major transaction cycles. Might be billing and receiving, procurement and disbursement, HR payroll. Those are examples of major transaction cycles which will observe the controls in process, and then we'll do tests of those controls that helps us plan all the other procedures that we use during our audit. Analytical procedures are also used along with substantive procedures. Those typically are done primarily at the final test time for the audit, where we're doing balance testing. And so analytical procedures are primarily used in revenue and expense areas. We look at trend analyses, comparisons with other organizations and industries. And then substantive procedures would include such things as confirmation of balances, looking at supporting documentation, obtaining representations from your general counsel, looking at objective evidence, typically from outsiders. So that's the nuts and bolts, the three-legged stool of types of testing that we do during our audit. And so I'm now going to pass the baton to Kinman to talk a little bit about materiality and some of the other required communications concerning our audit. But I'd like to stop just for a moment. Any questions out of the chute?
All right, I don't see any.
Okay, very good. Then I'm going to turn it over to Kinman.
Thank you, Mary. So one of the things that Mary briefly mentioned was in all material respect, and what she means that is we do set the materiality as part of our audit process to guide our audit plan. So this is a materiality that's set both qualitatively and quantitatively, and it's usually a set as a percentage of either the net position or assets or just revenue. And qualitatively, what we're looking at here, especially if there's a debt covenant item or any other item that is of substantive nature, we will adjust materiality for those purposes as well. And this will guide how we determine the nature and extent of work that we will be performing, as well as the evaluation of any findings or statements that we might come across during the audit process. Another usage of the materiality is also to help us determine what we would consider significant audit areas, which I'll cover next on slide 8. So on the next 3 slides, there are some significant audit areas that we have identified as part of our planning process and the conversation that we have with members of management, and also with just our walkthrough process that we have gone through during interim phase of the audit. And so it wouldn't be unusual for you or surprising to you, because a lot of them are significant balances of your financial statements. The first item, of course, is the financial closing and reporting cycle. This is where the preparation of the financial statement, the drafting of the footnotes, disclosure, and preparation of the information that was used for the audit purposes. There's always an area that we spend a lot of time on, because organization like the state bar doesn't always prepare a full set financial statement on an ongoing basis. It's usually an annual process, so we do spend time on that. The second area is investment valuation and disclosure. Just because of the amount of investment that's held by state bar, we do spend time to get the valuation of those items and disclosures on them. Pension accounting and accounting valuation and disclosure. This is specific to the pension that state bar has that is managed by CalPERS. And we look at the valuation of it, the actual valuation of it, and also all the disclosure that comes along with it. This is a big area that continues to be a focus, because GAP C68 that brought attention on the face of the financial statement is the third year that's in effect. So we do spend time on that as well.
Yeah, just to interject very quickly, as mentioned before, we do look at the internal controls relevant to all of those areas, because they are material balances and they're pretty important to users of your financial statements. So, around the financial reporting and the investments, we're definitely going to be looking at the internal controls used by the organization to make sure the reporting is correct and that the investments are safeguarded and appropriately reported and valued as well.
And then on slide 9 is the 3 other areas. The first one is the other post-employment benefits, OPEB. The accounting valuation disclosure of this item is important just because it's another estimate that is disclosed in your financial statement. So we do an actual valuation as well. We look at the investment portfolio that makes up the OPEB as well, just making sure those are all C, especially as we work towards getting GAP C75 adopted in the near future. Revenue recognition is always an area that is the appropriate area because revenue is an area that we always spend a lot of time looking at just because of kind of considerations that recognition of receivable and deferred that we have to look into as well. And the state law has a lot of source of revenue, so we do spend a lot of time on that. And then finally, in regards to your loans and debt, it's just the valuation of your loan payable, the classification of your loan payable, as well as the debt covenant that accompanies the loan. So making sure that you're in compliance with all your financial covenants as part of our work as well.
So I think we should pause for a moment and just, like we've done in prior years, ask you for your perspective. Those are significant account balances and significant transaction areas that we just talked about. Are there any comments or questions or thoughts about additional areas of risk that you'd like to bring up right now?
So this is Brandon Stallings.
You can also bring them up later to us, but if anything comes to mind at this point, we'd be grateful for that input.
Okay, definitely. This is Brandon Stallings. I wanted to ask if you feel that you need to pay any special attention or do anything differently in this year's audit compared to previous audits, just in regards to the section separating and then with turnover in finance staff.
Well, those are both great observations and questions. The sections are actually coming off of out of the state bar subsequent to the fiscal year or the calendar year that we're auditing. So, we do as Kim will mention shortly, there are a couple of deliverables in addition to the financial statement audit. There are two other examinations that we do. One is of the mandatory fee statement, and the other is of the sections report. So we'll still be doing both of those this year. But in terms of the transaction to remove the sections from the state bar, that will be part of next year's audit. The amount that's removed will be tested in your next audit. As far as the change in entity scope, change in scope of your staffing, that's a very important issue, and I think we mentioned that on the next page. So, during the year, there was significant turnover in the accounting area. And so that does, always cause a change in scope. Number one, to assess whether there was a degradation of the internal control environment for that last quarter, and possibly even before that point in time, because we had a lot of people depart, and that could have had an impact on the system of control. The good thing is you do have some strong accountants on board, some consultants who are serving in the role of CFO and controller who are very strong in their skill set. So we anticipate that may mitigate some of the concerns that we have and should provide for a more efficient production of the financial statements. That has always caused considerable delays and effort in prior years. Just the sheer numbers of CPAs available to construct the financial statement has always presented some challenges. But definitely this is on our radar. We are going to be doing additional internal control testing. We are going to be looking at the control environment, particularly around financial reporting. The same individual has prepared the financial statements for a long period of time. And so, it's difficult for people without the historical perspective and all the information readily at hand and the institutional memory to necessarily, do that easily. But as I said, you really do have some strong technical finance people on board who will, I think, be able to help greatly in diminishing the challenges. but it certainly is on our radar. It's, something that we mentioned on the next page. There may be additional work required. There may be some additional cost incurred. And so we'll keep you posted and advise you about that, and we'll work closely with Kevin Harper, the CFO, in all of our communications, and also with you as the audit committee. Keep you informed.
And I don't know, Kevin, if you want
I
to...
hope that answers your question.
Kevin, do you want to share your thoughts on this topic? Because I know we've had some discussion about it, and you may have a slightly different perspective.
Yeah, so yes, obviously there's a loss of some institutional memory with Christine Wong and Hazel Tam leaving the State Bar right at the beginning of the close and the beginning of the audit. But we brought in people with very strong skill sets, very experienced in the business of closing the books and preparing financial statements. One of them, and both of them being CPAs. So sitting in both of those desks, Christine and Hazel, is a CPA. So the first one is Olivia Llewellyn, who is the former retired controller for the Port of Oakland, and she for many years was the person responsible for the accounting function, including preparing the annual financial statements of an enterprise fund government, the same as we are. So her experience is extremely relevant. Obviously, doesn't have all the historical knowledge of the State Bar that Christine had, but is very good at anticipating what the auditors need, what the auditors mean when they ask for certain information, and so she will be extremely helpful. Francis Gura is the one sitting at Hazel's desk and doing a good job of helping to close the books. So between those two and I, who am also a CPA, we're going to have a team that is going to spread the workload, whereas everything funneled through Christine Wong in the past. I strongly believe that this will make it easier for us to participate with the auditors on the audit and the preparation of financials. And the biggest issues in terms of the loss of institutional memory will actually be before the auditors arrive, which is getting the books closed, understanding, making sure that all the transactions that need to be considered and remembered are identified and put into the accounting records before we actually draft the financials. So we have some things to learn, but I do believe we have the right team in place to be able to do that.
Great, thank you. Any other?
Yeah, and Kevin, I agree with you on all of those things. As you know, the standards require that when there is a significant change in personnel, that you take a slightly different tack with the audit, which we will, but I completely agree with you that the efficiency and the skill set is very good for closing the books and getting the financial statements prepared.
Okay.
All right, any other questions?
Did we answer your question?
Yes, you did, thank you.
Person that asked that question?
Yes, you did, thank you.
Okay, you're welcome. All right, so we've got just a couple more slides, and again, we're going to hit everything at a pretty high level. The time is limited. We do consider fraud during the audit, and there are a number of procedures listed there that we perform. Some of them are done on our part, and some of them are done wherein we're meeting with various people at the State Bar, including members of the audit committee, to formulate an assessment of fraud risk. And we do a number of tests to improve the likelihood that we would detect fraud. Among those is tests of journal entries. Journal entries are often used by people at the top of organizations, usually people who are pretty high level, who may have perpetrated a fraud and covered up with journal entries. So that's just an example of one of the types of tests that we do to help detect fraud. Okay. Kinlan, do you want to talk about our deliverables and the time frame, please?
Sure.
So which slide are we on now?
On slide 12, this is going to remind you of the deliverables that we will be enhancing. depending on. The first one is the financial statements for the state law. And then the next two have to do with first one has to do with the sections, which is the statement of receipts collected and expenditures of the section. And then the next one has to do with the mandatory membership fees. And both of these essentially required examination that's done for legislature reasons. And then the next two items are essentially reports that we have issued in regards to required matters. One of them is the action part of this presentation. And then that's why there's any internal control matter that's noted as part of our audit process, we'll be communicating that as well in the proposal. And then on slide 13, just high level audit timeline, the kind of consistent with last year, with the goal of making sure that the audit and all the statements will be filed to the state by April 30th.
Okay, so that concludes our formal presentation of our audit plan for you. We did include some accounting update information. The GASB has been quite busy. There are a number of new standards coming down the pipe, but there aren't any that are applicable for you for new implementation this year, which is a blessing. Just given all the changes at the state bar, it certainly would be challenging to also implement new standards this year. So, but we wanted to put those in there so you knew what was coming in the coming couple of years. So we'll let you take a look at those, and we can talk about those more when we meet with you at the conclusion of the audit, if you like. So any other questions or comments at this point from the committee or members of management?
All right, no, I think we're good.
Okay.
All right.
All right.
Thank
Well,
you so
thank
much.
you again for allowing us to join you and for letting us to continue to serve you. We very much enjoy our working relationship with your team, and look forward to meeting with you again at the conclusion of the audit.
Yes, please let us know if you need any assistance.
Will do. Thank you very much. We'll definitely be in touch with the audit committee chair along the way.
Perfect.
Thank you, Mary.
Thank you. All right. Should we drop off now, Kevin, or should we stay?
Yes, you may. And thank you very much, Mary. We appreciate your comments.
All right. Talk to you soon then. Thank you. Mary Case and Kinman Tong.
Thank you, Mr. Conference.
All right, so seeing as we lack a quorum, what I'm going to do is continue further discussion of the approval of the annual work plan to Saturday, and I'll talk with staff further about that. I believe that we can, but I want to have that placeholder, put on record at this point. So maybe do that just prior to the executive.
Why don't we adjourn it to the beginning of the board meeting, which I believe is 11:30?
11:45.
11:45. Adjourn it to Saturday, 11:45, and then if we need to amend our calendar during the day to get business done, we can do that. But folks know that they want to participate in discussion of our work plan, which I promise will be a scintillating discussion. Their opportunity to do that will be 11:45 on Saturday.
All right, with those comments, we will adjourn unless there's any further discussion or objection. All right, so adjourn with those comments. Thank you.